Gosh. Good evening. Good evening. Sorry, it's a little late, but we're gonna go ahead and get started. Um, I am asking Commissioner Hope to lead us in prayer, followed by the Pledge of Allegiance being led by Vice Mayor.
For those who'd like to participate, if you would stand and bow your heads, please. Dear Heavenly Father, we reach out to you this evening to provide us peace and wisdom as your people to make decisions that are best for all within our community. May you grace us with the ability to listen well and discern clearly the information and opinions of all present in this meeting. We thank you for the work of our city staff, contractors, legal counsel, guests, and citizens that speak as it relates to our agenda tonight. We thank you for the presence and active participation of our community citizens at this meeting. Their interest and commitment to being with us is very important to Archer. Thank you for our calm weather in the past few weeks and provide solace, direction, and well-being for those who have not fared as well. Please remain with our men and women in uniform across the world who defend and protect our freedoms at home. Be close to all our first responders who ensure our safety, health, and well-being 24/7, and remain with and their families until they return home each day. Please give guidance, peace, and resolution for our brothers and sisters in Israel and the Middle East who face fear and strife every day. All can be solved as only you can do. May we remember it is not mere chance or blind fate that determines the sweeping changes that impact every generation. You are our sovereign God who takes full responsibility. You tell us it is you and only you who affects change if we listen. And the good news is this: when changes occur, they are never out of your own control. For as it is written in Daniel chapter 2, verse 21, he changes the times and the season. He removes kings and raises up new kings. He gives wisdom to the wise and knowledge to those who have understanding. In your name we pray. Amen.
Amen.
Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you to the both of you. Additions or deletions to the agenda?
None from the staff mail.
Adoption of agenda.
So moved.
Thank you.
Second that, Madam Mayor.
Thank you. We have a motion by Vice Mayor and a second by Commissioner Holt. Any commissioner discussion on the motion? Public discussion on the motion? Please.
Good evening, Commissioners and Madam Mayor. My name is Byron Flagg. I'm an land use and environmental attorney in Gainesville. I represent Mr. Lewandowski. The reason I'm coming up right now to address you in public comment is because I know that the agenda has been changed to add an important item that I will be discussing on the next item. The agenda has been changed to add a letter or a contract between the city and a Mr. Brian Thomas, a planning consultant, onto the consent agenda. And on behalf of my client, we're specifically opposed to that item being placed on the consent agenda because we believe that that contract was entered in violation of the city code, specifically section 2-85, which requires that any professional services agreement that is in writing actually be submitted to the city commission prior to that contract being entered into. And we believe that that contract is void and it should come to the commission at some other time for actual consideration and a vote, which is what your code requires. And so we would ask that with regard to that item being on the consent agenda, that it be removed so that the commission can actually talk about that issue and give the public an opportunity and my client to address the commission on that. And with regards to changing the agenda at this point in time, without that item having been on a prior properly noticed public agenda, you can do that. The Sunshine Law allows you to do that. But the Florida Attorney General's office has issued a strong opinion to local governments recommending that you not do that. And I'm going to quote from that Attorney General opinion. It's 2003-53. It says, the purpose of the notice requirement of the Sunshine Law is to apprise the public of the pendency of matters that might affect their rights, afford them the opportunity to appear and present their views, and afford them a reasonable time to make an appearance if they wished. In the spirit of the Sunshine Law, the City Commission, in this case, not your city, a different city, should be sensitive to the community's concerns that it be allowed advance notice and therefore meaningful participation on controversial issues coming before the commission.
Thank you. Additional public comments? All right, seeing none, let's go to a vote. Does any commissioner have anything else? No? All right, going to a vote. All in favor of the motion signify by saying aye. Aye. Opposed likewise. Motion carries 5-0. All right, consent agenda, which does include the approval of minutes from August 12th, August 19th, and ratifying the services between the city of Archer and Brian Thomas.
Madam Mayor,
Yes.
if I may, prior to the making of a motion, I would like to comment on the services agreement between the city and Mr. Brian Thomas. It was brought to our attention that the city commission needs to approve a professional services agreement. There's a specific clause in your code that requires it. Despite the purchasing requirements and the maximums that the city manager can make without bringing before the commission for approval of the contract. So after speaking with Scott Walker in our office, his recommendation tonight was to have the commission ratify it nunc pro tunc. That means now for then, essentially saying that the commission authorizes this agreement to have been entered into at the time that it was such done. Thank you. There's
We
not
don't have a motion
motion.
yet.
Madam Mayor,
Yes.
I will make a motion to approve the consent agenda, pulling agenda item 3. Discussion.
Thank you. We have a motion. Is there a second?
I second that, Madam Mayor.
Thank you. We have a motion by Commissioner White and a second by Commissioner Hope. Commissioner discussion on the motion. All right, public discussion on the motion. All right, seeing none. I was going-
December McSherry here. When did the city commission meet to talk about hiring Brian Thomas? And what conditions were presented to you by the manager? Did you have a debate about the cost and the payment to Mr. Thomas? And what are the conditions of that contract? Nobody here ever even heard about this. Shouldn't be new. We've been asking you for a workshop for a long time. These issues could have been talked about. And it seems like you're afraid to let the public be aware of it. So can you tell me what commission meeting you approved hiring Mr. Thomas? It's the law. It's in your code. So you don't know anything. Thank you.
Thank you. Additional public comments?
Charles Tufano, resident. I have a question. Mary Ashford at one time came to one of our commissioner meetings, if I'm not mistaken, correct me if I am misspeaking. And she indicated that the county of Alachua would provide free of charge to the city a planning to help us plan and review projects like what Mr. Arnold here is proposing in his CUP. So my question is, for a strapped city, why would we pay somebody if we could receive those services free from the county?
Is that your only question?
Yes.
Okay. Thank you. I don't remember Ms. Alford attending a meeting and offering that. I do remember an email, but I don't have that email, so I don't remember what all she offered. But we will go ahead and let our legal counsel answer both questions if that is all. We will let our legal counsel go ahead and answer both questions.
It was the joint Alachua County City meeting that was held right here.
Okay.
in April, I think.
I
I'm
re-
not sure.
I remember the joint
Okay, that's
meeting,
when
but
it
I,
came up. There was discussion on it, that the county, we could reach out to the county.
that we can,
But
yeah, but he said
I
some
thought it was
elaborate.
individuals. I didn't realize.
Exactly, exactly.
So, but we did get the letter
Mhm.
and they offered their services. So
Mhm.
I thought,
Okay. All right, good. Well, let's let our legal counsel speak for those two questions.
Yeah, sure.
Yes,
Mr.
go ahead.
Tufano, correct me if I misstate or misremember one of your two questions, so just bear with me. I believe the first was, why do we not utilize the county? Was that the first one? Okay. The recommendation of the city attorney's office was to utilize a private consultant who had no ties to any other local government, applicant, interested party in the area to provide the city with unbiased advice that would be solely for the protection of the city as a legal entity. Second question was?
It was Miss December.
We have a lot of people in the audience tonight, so if you're going to talk, I'm welcome to engage, but will you please just step up to the microphone?
And the second question was Miss December's question, but I don't remember what she said now.
It just revolves around, if I understand, the Alachua County free services for a consultant would be
Alachua County,
Alachua County for
Right.
this, for that help, to help us plan the services.
right?
Would be, they wouldn't have any ties to anything
But
specific.
Alachua County,
But Alachua County,
Right.
correct.
whereas an independent consultant has no ties to any municipality or county.
The same gentleman that used to represent Newberry,
He doesn't represent Newberry right now, sir.
not anymore.
He doesn't right now.
Thank you.
Thank you.
I think her question was why did we enter the contract and
I think I've already answered the question as to why we entered it. We weren't aware of the service in the code. Hi.
Good evening, Commissioners. I'm Mary Helen Wheeler, Alachua County Commissioner. I was looking to see if Commissioner Alford was here because I was not going to speak if she was here. I don't see her in the room yet. But I did want to say that the offer still stands. I spoke with our attorney tonight just to make sure that I wasn't speaking out of turn if Mary was going to be here and that I was legally allowed to be here. The reason that I am here is my sister lives here, and she lives right close to this property that's being discussed tonight. But I did want to say that the offer still stands. The EPD group is coming tomorrow from our county to work with the city. So I'm hoping that you all will accept that offer from our Environmental Protection Department as they come here to survey the property to help with the process. But I just wanted to say that that offer still stands and the county stands ready to help any way they can, free of
Thank-
charge. Thank you.
thank you.
Madam Mayor, I do want to bring to your attention that the motion on the floor right now is to approve the consent agenda and remove Mr. Thomas's contract to be an actual agenda item for further discussion.
Thank you.
Madam Mayor, may I speak again to the motion?
Yes.
Thank you very much. I've provided a letter to the commission as of this morning and entered it into the record by emailing it to city attorney and assistant clerk. But just to explain our position, it's our understanding that this contract that is now on the agenda for you to review, according to Assistant City Attorney Nunk Pro Tunc, meaning after the fact, our view is that you have a specific requirement in your code, section 2-85, written contractual agreements. And I'm going to read it to you verbatim, word for word. It says, prior to entering into a contract for professional services, the city manager shall submit a written contract to the city commission for approval. Said written contract should embody all provisions and conditions of the procurement, including but not limited to the nature of the contract, compensation for the contract, the services to be performed, public records provision, termination, and that the contract must be ratified by the city commission. There is no provision in your code that says if this doesn't happen, that you can then nunc pro tunc after the fact ratify it. And in fact, Mr. Thomas has already gotten to work, and he's provided a staff report as part of the next agenda item. So he has been off and running, doing the work according to a scope of work that was already agreed to between city staff and Mr. Thomas, without that contract ever being submitted to you, Commission, for review and approval. And so that's our point of view, and that's our argument as to why you need to postpone the next agenda item until this matter can be resolved one way or another. Because if you were to go forward on the next agenda item, having approved this contract nunc pro tunc after the fact, it creates a legal question as to whether or not that contract is actually still legally effective or void. And the problem with that is in your land use code, the city manager is your designated zoning administrator who reviews land use code provisions and makes recommendations. This contract with Mr. Thomas has delegated away the city manager's duties as zoning administrator to a private consultant, which is, the city can do that as long as it follows its code for entering into those kinds of contracts. But that didn't happen here. And you didn't get a chance to review the scope of the work that would be involved. And so that's our position. And that's the end of my comments on the motion.
Thank you.
Good evening, Mayor and Commissioners.
Good evening.
My name is Patrice Boyes. I'm a shareholder at Stearns Weaver. It's a law firm. I work out of Gainesville. I've practiced land use and environmental law in Gainesville and Alachua County in North Florida for 33 years. And I really hesitate getting up and getting involved in internal discussion, but I did want to share with you some experience that I have had on this very issue. Municipalities such as yours can take action to ratify conduct that has occurred. And there's appellate case law that says it relates back because you're like a corporate entity and those activities relate back. And in fact, we had a situation in another municipality where a sunshine law violation was cured and that related back to the vote and it survived judicial challenge. So I think we've heard 26 minutes of filibustering to delay this item tonight. And that's clearly the strategy. And I would submit to you that my client has obeyed every submittal requirement. He's been in this process for a very long time. And we have 11th hour folks who understandably may not like the idea, but we'll get into the merits hopefully this evening because I do think my client deserves your vote tonight. The other thing I wanted to mention is all this discussion about the planner's contract. Let's say he didn't have a contract. We could adopt his opinion as ours. And in fact, I'm doing that right now. We're adopting the report of Brian Thomas as a portion, a supplement to the applicant's submittal. So if that helps you skate over this issue and move on with the business before you, I'm happy to do that. And again, I apologize for interfering in your internal issues.
Thank you.
Madam Mayor?
Yes, ma'am.
We have a motion on the table.
Yes, we
and,
do.
We've had discussion about everything but.
They can't hear you, sweetie. Yeah,
It's on.
it's on.
Can you hear me now?
Yep.
Sorry, I guess it has to be in my mouth. So I'm gonna ask that we consider the motion.
And so what maybe we need to remind people, the motion is to pull number 3, the ratification of the service agreement, off separately. So to have it as a separate item from the minutes for August 12th and August 19th. That was the motion. All right, do we have any?
Yes, ma'am. I heard you address that gentleman who got up and spoke a little while ago.
Could you come to the microphone, please, sir?
That's what I mean right here. We can't hear. You guys have got your microphone stuck up. in
Can you hear me?
They're not pulled down.
Okay.
I can hear you, yes,
Okay.
and the attorney, nobody else.
Okay.
I'm just a dumb old worker sitting in the back. I can't hear a thing.
Thank you.
Thank you.
Can you hear me?
All right.
No, you haven't.
Madam Mayor,
Yes.
why don't we just have them all do mic checks really quick? Starting with Commissioner Green at the end.
You want testing? I have a loud mouth, so they'll hear me with or without the mic.
Can you hear me now? No?
I think you just a little, your voice is just a little low. You gotta speak up like
Gracious, it's
me
gonna be.
and Commissioner Green.
Can you hear me now?
Pull it down. a
Pull it
little.
down. Her light is
I
on.
can't believe it.
Yes, it is.
More?
It is.
Okay, now? All right, help it.
Commissioner Hope.
Fletcher Hope, can you hear me? Thank you.
All right, thank you all. All right, additional comments on the motion. All right, seeing none, let's go for a vote. All in favor of the motion on the floor signify by saying aye. Aye.
I,
Opposed likewise. Motion carries 5-0. So we are going to go to agenda item 3, which is to ratify the services agreement between the city of Archer and Brian Thomas.
Madam Mayor, for sake of brevity, I've already introduced the item. There's been discussion on it, so you all know what's going on. I would agree with Ms. Patrice Boys's assertion this evening that you all are well within your legal right to rectify a wrong, not only via the relate back doctrine, but there are other legal doctrines that make this decision defensible. And I would proffer to you all that this is a procurement issue that Mr. Flagg has identified. It is not a quasi judicial issue. So conflating the two, I don't feel is entirely appropriate.
Madam Mayor,
Yes.
I do have some questions about it. Do I need to make a motion first, or do I need to? Okay, then I will,
You're still low.
I'm trying to decide.
you want me to make a motion?
Yes, go ahead.
Okay.
Are you making? a
Madam
motion?
Mayor, for the sake of further discussion, I make a motion to consider this procurement issue of a ratification of a professional planner, Mr. Brian Thomas.
Thank you. Well, a motion
I will second it.
and a second by Commissioner White. So a motion by Commissioner Hope, second by Commissioner White. Go ahead, Commissioner White. Or
Madam Mayor, I am getting so tired of being the last one to know anything. And I did speak to the attorney about this, and, but I wasn't aware of the scope of services until I saw it. And that scope of services is very narrow. My understanding is it doesn't include our comp plan, any environmental studies, a lot of things that we're going to need. And I understand too that our city manager didn't have that either. So I'm just not sure.
Madam Mayor.
But I know everybody here wants this settled. And I mean, I do too, because I'm tired of it. But it needs to be settled, and it needs to be settled immediately, but it needs to be done with all of our Ts crossed and our Is dotted. And I'm not sure they are at this point in time.
Madam Mayor.
yes.
If I may, Mr. Thomas has well exceeded the scope of services and what he has looked at. In fact, I think it would be appropriate if the commission would like to ask Mr. Thomas what he has reviewed to understand, because we're here tonight, as Mr. Flagg pointed out, he has performed the work. So the scope of services is obviously no longer the operative portion of this. Rather, it would be what Mr. Thomas has actually done. And I think that that may alleviate the concerns of the commission.
I would appreciate that.
Certainly. So, good evening. My name is Brian Thomas. I'm the professional planner in question. Madam Mayor, I just, the comp plan not being listed there, when I put down under research Archer codes, that was a shortcoming on my part.
Brian?
I guess they, yeah, you gotta be
Because
close.
I can hear it coming back at me, so it sounds like it's right there. When I wrote in research Archer codes, I meant codes as well as the comprehensive plan. So I have reviewed the comprehensive plan as well. And the environmental reports that were submitted as part of the application. I just didn't specify everything, but everything that's in the application, I have gone through and reviewed on behalf of the city, and as well as the comprehensive plan. In the staff report, I reference back to the comprehensive plan and my review of that and whether or not the application is in compliance, in my opinion, with that. So, if you have any other questions.
I do. My understanding is that we were charged for 10 hours. Is that right?
Up to 10 hours. I probably exceeded that in the first week. I have spent the last 10 years working for a small municipality to our north, and I guess you would say I have a bit of a soft spot for small municipalities. And so I put a 10-hour cap in there basically to protect the interests of the city. I spent a good 4 or 5 hours reviewing just the video of the Planning and Zoning Board review, as well as several hours reviewing the comprehensive plan and the Archer codes, land development regulations. And then I've made phone calls to Alachua County Growth Management. I've discussed it with Alachua County. I'm a member of the Alachua County Environmental Protection Department. It's gone well beyond the 10 hours, but that's a not to exceed amount. And that way the city knew exactly the maximum amount that they would be charged.
Then I appreciate that because I figured it'd take you 10 hours to just read. Yes. Okay.
Yes, ma'am.
Additional questions from the commission, comments? None? All right. All right, so public comments on the motion. 3 minutes, please.
The motion on the floor is to approve the contract as written. I think, who made the motion? Commissioner Hope, and it was seconded by Commissioner White.
Correct.
Madam Mayor, again, Byron Flagg for the record representing Mr. Lewandowski. I appreciate Ms. Boyd's comment that it appears that this is some kind of filibuster. I can assure you it is not. Absolutely no way. I think that the discussion that we're having tonight, whether, what was reviewed, what was to be reviewed, that is exactly the point. Section 2-85 of the city's code says anytime a written professional services agreement is to be entered into, it has to first go to the city commission. The fact of the matter is the written contract we're talking about involves review of your comprehensive plan, even though it doesn't say there. Now we've heard that it did review it. It probably did. But we'll get into the merits of how that was done, how well it was done. But the point of this is your code was violated because this contract didn't come to you first before it got entered into. That's the point of this little argument. It's not filibustering. And my client has a right to bring that point up. And the reason this is so important is because if the contract doesn't come before the city commission to have a full meeting on to discuss and consider, it deprives the commission of a meaningful opportunity to know what's going to be reviewed and to ask questions and to have input rather than just I'm an old Coast Guard guy, rather than just say, as we do in the Coast Guard, just gun decking. That's what we call this. And so it also deprives the public of a meaningful opportunity to hear what's going on and to have input, as well as my client. So that's our point. It's not meant to filibuster.
Thank you. Additional?
Good evening.
Good evening.
I was wondering, when you decided to engage the services of this consultant, did you also think about, because clearly he's an industry person, So likely we'll have a pro-industry council. Did you also think about engaging someone who will tell you about the other sides of the issue that he may not, bring up? Thanks.
Thank you. Additional comments?
You have one? This one? Yeah.
December McSherry again. Commissioners, we don't need Brian Thomas. We have a qualified manager, we have qualified attorneys, and we have a qualified county environmental protection department, which has a hazardous material, a whole department that reviews hazardous materials. Now, Mr. Thomas just said that he contacted the county. I contacted the county, and the city has not offered a hazardous materials plan. And also, they have not offered a fire suppression plan, emissions discharge plan, a noise plan. No, they need to submit all these things before you even know how to discuss this whole application. And with the county input, these guys are pros. I was on the Environmental Advisory Committee for 9 years. I worked with these staff people, and they're all PhDs and know what they're talking about. They're experts. You have such a great opportunity to have real experts come here and help Archer. They've always helped Archer. We got the dump closed. When the boat factory, when that company was not monitored by the city of Archer, they collected so much acetone for their fiberglass that one little flick of a cigarette into the garbage pail made that boat factory blow up. They had to evacuate 1,200 people out of Archer. We have enough experience with horrible industrial accidents here. The fertilizer company caught fire. The city of Archer could not put that fire out. The pipes, the water line pipes are all rotting. Mr. Hammond said that his staff has to go out and fix rotten pipes every week.
So, Ms.
All
McSherry,
right, I'm done.
your time wasn't up, but
Oh.
we needed you to speak on the motion that was at hand. But if you're done, thank you.
Yeah, we don't need Mr. Thomas. Thank you.
Additional comments or? All right, let's move on.
Madam Mayor, while Ms. Lopez is approaching, I wanted to let you all know that we have a court reporter here this evening, and I promised her I would make this announcement earlier, so I apologize. I know you guys don't end up in depositions very often, but something Mr. Flagg will tell you, something Ms. Boyes will tell you, is that court reporters can only write down what one person is saying at a time. So I know that it's easy to get in the back and forth between us and an applicant or a citizen, but please make sure that you're not speaking over one another this evening to create a clear record. It makes it really hard on the court reporter. And the other thing is to make sure that you're not answering with like nods of the head or like non-verbal responses. Because when you think about it, she's looking down typing. She's not looking up to see if you're nodding, to answer a question. So if you could just ensure tonight that your responses are verbal for purposes of helping her get her job done, that would be
Yes,
much
ma'am.
appreciated.
Yes, ma'am, thank you.
I'm Roberto Lopez. I served on the commission here and served as a vice mayor and mayor in Archer for about 7 years. During that period of time, we were able to work with the Alachua County and accomplish many, many goals. It is my understanding from Chair Lady Alford, Mary Alford, that they offered these services to you. What I don't understand is why we continue to spend our money when we could get all this free service. I brought in all kinds of resources as a commissioner. And we worked with the county because during that time, the people in Archer did not want to work with the county. They were saying home rule, whatever it was they were talking about. But trust me, you can get so much without spending our money. So I would like to suggest that from now on, any contracts that are out there, and we discussed this in a meeting, that all contracts should come by the commission for approval. And also, the attorney should not let anything go out without reviewing it. I also mentioned that in a meeting. So I'm asking you to please utilize your services, utilize the county, utilize the state. We didn't get this building here under my guidance without utilizing the state of Florida, historic preservations. So I'm just telling you, please do not do this anymore. And as far as Mr. Thomas is concerned, yes, I think he should go back to Newberry and take care of his business over there.
Well, thank you. All right. With that being said, commissioners, oh, we have enough. I'm sorry. Uh-huh. You're welcome.
Good evening, everybody. My name is Chris McHouston. I'm a local resident here in Archer. My wife and I, we have 8 children in the home, ranging from 18 down to 19 months. We live on 10 acres that is approximately 3/4 of a mile from where this proposed concrete batch plant is going to go. We had no idea that this was even on the agenda. People in this city had no idea.
So
We were
So
basically,
before you get far into it.
Yes.
The motion is about the contract with Brian Thomas, is we're not
Okay.
to the
yes, ma'am.
batch plant
Yes, ma'am.
yet.
Yes, yes. And to that end, we have not seen the full breadth and scope of what this can do to our environment. From what the EPA stands, the mitigating factors that you're going to utilize, which I understand, I appreciate that you're going to attempt to mitigate some of this environmental hazards that are going to leach into our community in the air and the groundwater, not to mention the environmental
Okay,
noise, the traffic. But you hauled in somebody
So
who's
excuse me.
basically paid to promote these types of things. And again, rather than utilize our free services, we circumvented the whole system. And for what? So if you truly cared about this community, you would have done something better years before. You wouldn't have just owned this lot with, it's so frustrating to watch and to
so-
listen and to see
so
this whole process.
I don't
It's a
want,
mockery
I
of
do
the
not want
system.
to interrupt
So,
you, but I
apologize,
need you to
but
stick
I'm
to
done.
the motion.
And I understand
Yes, sir.
that, but there's so much that we have to
We're
say
gonna
as a
have
community.
we're gonna have a public comment that you can say that, but right now we need you to stick to the
It's just-
motion that's at
More
hand.
proof that people can be bought and sold. And we hired in somebody who has a biased opinion,
Okay,
and
Thank
it's unfair. It's unfair to the people in this community,
okay,
and that's not right.
thank you.
Thank you.
Uh-huh. Is that all?
Madam Mayor.
So I need everyone to stick to the motion
My name-
at hand.
My name is David Norden. I'm curious about the relevance of this contract with Mr. Thomas and what effect it may or may not have on your decision to approve this concrete mixing plant. Can you just clearly tell all of us what effect, what's the relevance of this contract with Mr. Thomas?
Madam Mayor,
Yes.
Mr. Thomas's purpose is to provide competent and substantial evidence tonight on behalf of the city as a legal entity. You're going to hear presentations tonight, and I'm really not going to get too much into quasi judicial because I don't want to trounce on that. You're going to hear presentations tonight from Mr. Flagg, who is representing Mr. Lewandowski, as he said. And then you're also going to hear presentations tonight from Patrice Boyce, who represents Mr. Arnold. Neither of those sides is representing the city. Mr. Thomas is here to provide the city with testimony as to whether or not this conditional use permit and all the other things that went into this application process comply with our code, comprehensive plan, so on and so forth. The city retained him for that purpose, to represent the city as a legal entity such that competent and substantial evidence gets into the record that is not coming from either party.
Whether or not everything complies with your comprehensive code, is that a guarantee that the project will be approved?
The commission has to weigh the competent and substantial evidence that is presented this evening to determine whether or not the application complies with all of the requirements of a conditional use permit. The testimony that's going to be given is going to be from Mr. Arnold's side, Mr. Kosicki. I keep trying to drag you into this, Mr. Lewinsky. So you're going to hear what am I saying?
I don't know.
All I'm asking is if everything within the application is considered appropriate for the current code, is that a guaranteed,
That's the decision they're making this evening.
but I'm
That's what-
asking the commissioners.
It's not
I'm
appropriate
asking the
time to ask.
commissioners, is that a guaranteed approval?
It's not the time to
Or
ask
are there
that.
other, okay.
Thank you.
My name is Ashley Miller Everhart, and I was wondering under what specific conditions was this specific person hired to know that he was giving an unbiased opinion?
His contract is with the city. It's not with anyone else. And
Who chose him?
our office recommended him because we represent 8 other local municipalities. So we've seen really good planners come through cities, and we know that Mr. Thomas would be a good representative for the city of Archer. And our recommendation to the city was Mr. Thomas.
But under what grounds and how?
I'm sorry, I don't understand your question.
I don't understand how it's determined who you chose.
From
to do this
experience
job.
and personal interaction.
From your personal interaction?
Yeah, all of us at the city attorney's office.
Thank you.
All right. So let's go to the motion.
Yes,
Madam Mayor.
yes. I want to ask our legal what the options are.
I apologize, Commissioner White. Your options are you can ratify it or you cannot. The ratification doesn't affect Mr. Thomas's ability to testify tonight. All we're doing is correcting a procurement problem.
Okay. Suppose we say we don't want to ratify it. Could it then go to our city manager to act as our representative for tonight and we continue on? Or would we have to stop this meeting?
You gotta stay.
Did y'all hear that?
No.
I apologize.
The effect of approving or denying this, I apologize, Commissioner White, because I can barely see you. The approval of this item or denial of this item does not affect whether or not this hearing is going to happen this evening.
So the meeting will continue either way.
Correct.
Thank you.
Anything else, commissioners? No? Okay. All right, so let's go to a vote. Please turn your microphones on.
Can you restate
And I
the
told you
motion again, maybe?
Yeah.
Can you
Madam,
restate the motion again?
motion was to consider the ratification of this contract of this outside planner. So if we make a motion and vote, it's to consider it. So we'll have to have another motion to accept it and ratify it, in my opinion, Madam Mayor. I can amend my motion if the second is willing to amend hers to ratify this
Okay.
contract.
All right.
And for the sake of time and our citizens and their patience or impatience, I will amend my motion to move this along to ratify this planning contract.
I will second it.
Okay. Thank you. So the motion was amended to ratify rather than just consider. All right, all in favor of the motion on the floor? Uh, uh, Gosh, why does mine keep going off? I guess because
The
everybody's is
second
on.
that more than two or three are on, I'm watching as soon as one of the fifth or sixth one of you clicks, someone turns off.
Oh, so it's turning me off. Okay. All in favor of the motion on the floor signify by saying aye. Aye.
Aye.
Aye.
Oppose likewise. Motion carries 5-0. All right, we are down to the public hearing. Agenda item 1, resolution number 2024-19, conditional use permit.
Madam Mayor, if you'd like, I'd be happy to run this portion of the hearing.
Please.
So tonight we have a issue before us that must be considered and voted on by the city commission in a quasi judicial manner. I know that we've got some folks that don't regularly attend, so I apologize. I'm going to be a little long-winded tonight just so that everybody knows what's going on. The resolution is resolution number 2024-19, which later on I will read by title only. The purpose of the following procedure is to ensure the applicant provides a complete presentation of their request to the city commission prior to any testimony being provided by the staff, so that the applicant receives a full and fair hearing on their application, and any decision by the city commission is based on evidence presented. All public testimony will be taken under oath this evening. Given that there is so many of you, I will probably just have those who aren't going to testify when the time comes raise your hand so I can make eye contact with you. If you plan on testifying tonight, you do need to be sworn in. I like to do it all at once. It saves me from asking you 100 times if you solemnly swear that you're going to tell the truth. So if you don't plan on testifying, actually, let's go ahead and do that now. If you're not going to testify tonight, under any circumstances, I can always swear you in later. Can you please just raise your hand if you're not going to testify? Okay, you guys. Well, if you're not going to stand up at all, not going to testify. Not testifying, not going to stand up at the podium and testify. Okay. All right, so everybody who didn't raise your right hand or your left hand or whatever hand, go ahead and raise your right hand now. So we're not going to do this one at a time because to save time, but do you swear or affirm that the testimony you're about to give is the whole truth, nothing but the truth, so help you God? Thank you. So I've sworn you all in, so now when you stand up, you need to understand that you're testifying under oath. There's an expectation of telling the truth. So to accomplish this evening, I want to lay out to you all what the order of presentations is going to be, just so that everybody understands who's what, when, where, and why. So the city or the city delegee is going to provide a summary and an overview of the application. Then the applicant will get to present. City staff will present its case. And then we do have a third-party intervener. If you frequent City of Archer meetings, you know that this doesn't happen very often. So the people that I just mentioned, the third-party intervener, the applicant, and staff all have unlimited time limits. They can present for as long as they need to. Then we're going to go to, let's see, what's next. So then we're going to go to a public comment. It's essentially what we've done before. It's going to be on this issue at hand. That's how we're going to run it. You have 5 minutes. This is different from regular public comment. In our regular meetings, you normally get 3. You're going to get 5. As you all can see, there's a lot of you here tonight, so we're going to stick really closely to the 5 minutes. So please, when you hear the ding up here go off, please just wrap up as quickly as possible. We then go back to essentially a cross-examination phase, and this allows the applicant to cross-examine anyone who's testified, and also to respond to anything that's been said. And then the party intervener gets to do the same thing. Mr. Flagg is representing the party intervener. You guys have met him this evening, so he will then have the opportunity to cross-examine. Following any party interveners, city staff may do the same and cross-examine any witnesses. After these responses, if the mayor deems it necessary and appropriate to ensure fairness and due process, the mayor may choose to allow participants to respond to any testimony provided by others during the hearing that's gone on. So if you have someone who has gotten up and given testimony about something and they feel as though that they just need to clarify something, we'll then allow them to come back up and clarify whatever was said. At this point, members of the city commission through the mayor. We're going to direct everything through the mayor this evening. So tonight, when you're asking a question of someone, it's going to be Madam Mayor and then ask your question. The city commission can then ask questions of anybody who was involved, staff, applicants, participants. If the city, after the city commission asks any questions they may have, the applicant, followed by city staff, may make any final arguments if they desire to. Sometimes attorneys waive it, sometimes they don't. When we get there, we'll play it by ear. I'm then going to advise the commission as to the applicable law and the factual findings that must be made in order to approve or deny the application. Once advised on the law and necessary findings, the city commission will conduct deliberation regarding the evidence presented as it relates to the application. And at that point, it will be appropriate to make a motion. Let's see. So at this time, I would like to go down one by one. I know that this has been a heavily discussed issue in the community. So Commissioner Green, I'm going to start with you. Have you received, or have you had any ex parte communications?
As far as receiving emails? or
Receiving
any type of
emails? Have you?
Yes,
Okay. And have you sent those to the city clerk for purposes of disclosure of ex parte?
yes,
Okay. And is any of your decisions going to be based tonight on those emails or receipts of documents or anything to that nature?
no,
And do you feel as though you're unbiased and they're not going to affect your judgment this evening?
yes.
Okay. Who's next? Commissioner White,
Yes, ma'am.
same questions to you. Have you had any ex parte communications related to this application?
This has been going on 2 years. I don't think I have, but it's quite possible. But I have received emails that I did forward to City Hall. I have, I did speak to Mr. Lewandowski right after we hired the planner, and it was about the planner. That was it. Who else? Most people that contacted me, I told them to understand that this was my home, my city also, and I would make my recommendation based on the evidence and what we heard. So
And so just to clarify, those emails that you received, you did send to City Hall
I did,
for purposes of disclosure of ex parte communications?
I did.
And your conversation with Mr. Lewandowski regarding Brian Thomas,
Yes.
is that going to affect your decision-making this evening at all?
No,
Are you going to use that conversation as a basis to approve, deny, or approve with conditions?
well, apparently not. No.
And so you feel as though the communications that you've received you're unbiased as regardless of having received those?
Yes.
Okay. Commissioner Hope,
Yes, ma'am.
have you had any ex parte communications?
I've had no ex parte communications. I have on record and received community comments, letters, documents that are on record in my City of Archer email. I've
Okay.
not responded to any of those, but they are on record at City of Archer email address.
And if you haven't already, are you going to submit those documents to City Hall for purposes of disclosure of the ex parte communications?
Yes,
And those communications have not impacted your ability to make decisions tonight, is that correct?
no,
And you feel as though you're unbiased in your decision-making this evening?
yes.
Thank you.
Madam
Commissioner
Lady.
Penny, Vice Mayor Penny, excuse me. Yeah,
And I just ask you one, I do want to disclose that I did watch the planning and zoning meeting.
you watched the planning and zoning
I did
meeting.
see the planning and zoning, but I didn't speak to anybody. I have also been researching, refreshing my memory on the comp plan and the land development code.
Okay, in regards to watching the P and Z meeting and hearing testimony and hearing evidence, are you going to use any of that information tonight to make a decision?
Probably because it'll be repeated tonight.
Right, but you'll be
No,
hearing
not-
it tonight.
Yeah,
So your decision-making tonight is going to be limited to
what I heard.
what you hear this evening.
Yes.
Thank you. Vice Mayor Penny?
Good afternoon.
Good afternoon. Good
Good
evening.
evening.
Have you had any ex parte communications regarding this application?
Other than the emails that all of us received.
Okay. Those emails that you received, have you or will you forward them to City Hall for purposes of disclosure of ex parte communications?
How I understand that all of us received the same email from the city. So
will you then subsequently, everything you received in connection to this,
I will forward them. I thought
Perfect.
they was already,
they were probably duplicates. I take your point.
right. Okay, they was gone.
Those emails and communications that you received, have they impacted your ability to make an unbiased decision this evening?
No,
And you're gonna hear the evidence testimony tonight, and that will be what you're making your decision based off of?
right?
Perfect. Thank you.
And well, let me say this. I did go to the batch plant in Newberry because I kind of wanted to see what it looked like to be,
The whatever drive-by you did,
that it was
Is,
a drive-by because
is-
it wasn't open, but I wanted to see it.
is that going to impact your decision-making this evening?
No, because it was a drive-by. I didn't get to see anything.
Okay.
Just the plant there, just like the foundries over there. So I didn't get to see anything.
All right, so you understand that your decision tonight needs to be limited to
Yes.
testimony and evidence that's presented this evening.
Yes, I just wanted to put that out there because I
Perfect.
wanted to see it.
Thank you.
Danielle, I do have one
Yes, ma'am.
correction. The Sherry's did stop by my home one day. It's probably like a few months ago. So I didn't think about that, but yeah,
I'm sorry, who stopped by your home?
the Sherry's.
Okay, and you discussed the batch plant?
Not necessarily. They just wanted to make sure that I was aware of what the county was offering.
Okay.
Yeah.
What the county was offering.
As far as the same
services.
email, yeah, their services. That
Okay,
was
so
it.
you didn't
Just
have
wanted to
any
make sure.
discussion as to the application
No.
or the evidence that was going to be presented?
No,
Okay.
no. And I also watched some of the planning and zoning meeting on
Oh.
YouTube as well. I watched some of it. No.
Okay, so
Not all of
question
it.
for both you and Vice Mayor Penny, one at a time for the sake of the court reporter. We'll start with you, Commissioner Green. The watching of the P and Z meeting, is that going to impact your decision at all tonight?
Not at all.
And you understand that you're limited to the evidence that's presented tonight?
Yes,
Okay. Same questions for you, Vice Mayor. Are you going to be influenced by the P and Z meeting at all?
No,
And you understand that the evidence tonight is what you're basing your decision off of?
yes.
Excellent.
Okay.
All right, Mayor Bailey, I know at this point you've got my questions memorized.
Almost.
Ex parte communications?
A bunch of emails that were forwarded to the city for further information, because at the time I had none.
Okay.
All right.
So
Yeah.
you've disclosed all of those ex parte communications?
Pretty much. And then the only other thing I can think of is I did also attend that planning and zoning meeting. I guess that was last month. Anyway, I did attend that one, and I was also contacted by a candidate, and she asked me a few questions about the plant, but ask your question so I can
Sure.
answer. But yeah, it wasn't about the application or anything specific, but go ahead and ask your
Okay.
question.
Any of the communications that you received had the attendance at the P and Z meeting, is any of that going to affect your decision-making abilities this evening?
No, ma'am.
And you understand that you're limited to the confines of the evidence and testimony presented this evening?
Yes, I do.
And you feel as though you're unbiased?
Yes.
All right, I think that that's everybody for ex parte. Nobody has any other ex parte communications to disclose? Last chance.
I don't think so.
All right. Oh, I thought you were turning it on. All right, we've sworn you all in. So now I'm going to read the resolution by title only. Bear with me, North Central Florida writes our titles, so they tend to be a bit lengthy. Resolution of the City Commission of the City of Archer, Florida, granting with appropriate conditions and safeguards a conditional use permit as authorized by the City of Archer Land Development Code, providing for granting a conditional use permit for a concrete batch plant within an industrial I zoning district as provided for within table 16.06, item 4.2 of the Land Development Code on certain lands within the corporate limits of the City of Archer, Florida, providing for revocation of the conditional use permit, repealing all resolutions in conflict, and providing for an effective date. So at this time, we're going to start with the city's presentation. Mr. Thomas, would you like to start us off?
Madam Attorney,
Yes, ma'am.
one question before he does, please. Would it be possible that sometime between 9 and 10, we can take a 10-minute break just for everybody to get up and move? And because it's kind of tight here for us to get up and go to the bathroom.
Between 9 and 10, yeah, we can do a brief recess to give everybody a stretch break. Yeah, it might have to happen before 9 or 10, but point it.
Don't forget to pull that microphone close.
Yes,
Thank
ma'am. I'll try to get a little bit closer this time. Do you want the full staff report or just a quick overview?
Let's just do, let's do a quick overview because I do think that in my order, I said that the applicant would get to present their case
Right.
prior to the city. So if you can just essentially introduce the item for the purposes of the city commission and the audience, that would be great.
Okay. And as far as advancing the slides, just give a signal or,
If you just want to put your finger up when you want
Okay.
Deanna to change the slide, she'll change it.
okay, sounds good. Thank you. So as we're all aware, this is a discussion of resolution 2024-19, which is an application for a conditional use permit, CU 23-01. Okay, next slide. Just some housekeeping. My credentials, just so everybody is aware. I did spend the last 10 years as Director of Planning and Economic Development for the city of Newberry to the north. I spent 6 years with the North Central Florida Regional Planning Council prior to that, working in various different projects, 2 years with the city of Jacksonville and a year with the Appalachia Regional Planning Council. I do have a Master of Science from Urban and Regional Planning from Florida State University, a Bachelor of Arts in Economics from the University of Florida, and I'm a certified public manager through the Florida Center for Public Management at Florida State University. And if I could, I'll turn that in for the record.
Thank you. You're keeping a record. Everything that gets turned in tonight. Just so everyone knows, when you see folks approaching, I like to explain it so everyone knows what's going on. They're adding things into the record for purposes of tonight. You're building not only the testimony record, but you're also building a paper record. So you'll see Mr. Flagg approach to hand things to us. You'll see Ms. Patrice Boyes approach to hand things to us. We're adding to a record that will then be a complete synopsis, essentially what was introduced in terms of evidence this evening.
Okay, thank you. And so the application before you is a request by Ronnie Arnold Sr. for a conditional use permit to construct a concrete batch plant on approximately 5 acres on a 25-acre industrial site, basically in the heart of the city of Archer. The location of the plant is the former site for the Maddox Foundry and Machine Shop. The site's been in heavy industrial use for approximately 100 years or a little more. It has a future land use designation of heavy industrial with a zoning category of industrial. And a concrete batch plant is an allowable use in the industrial zoning category, but because it's going to be conducted outside and not in a fully enclosed structure, it requires a conditional use permit to add additional safeguards and ensure compatibility with the surrounding community. I think probably if you want to leave the overview there, we'll start here.
All right, so at this time, we're now going to hear a presentation from a representative of Mr. Arnold. I imagine it will be Ms. Patrice Boyes to kick us off. And then essentially, Ms. Boyes, my thought is to hand it over to you to present how you see fit. So I won't jump in any way, shape, or form.
Just 2 preliminary matters. I'm not that tall. First of all, the burden of proof is on the applicant, so I just request that we be given a few minutes at the very end of all testimony and public comment to rebut anything. If that's acceptable to the mayor, I'd appreciate that. And the second thing, our certified appraiser is just wrapping up testimony at a hearing in North Carolina, and he will appear here this evening by telephone. And so I'm thinking that after our engineer finishes his presentation, I'll get him on the phone, hold it to the microphone so everybody can hear him and you can question him. And if there's any cross, we would need to do it at that time. Okay? I appreciate your indulgence. Just rewinding a little bit so the record's clear. My name is Patrice Boyes. I'm a shareholder at the law firm of Stearns and Weaver. I've practiced land use and environmental law in Alachua County in North Florida for the past 33 years. This evening, I represent Ronnie E. Arnold Sr., who's here in the audience with us tonight in the white shirt. He is also the managing member of Ronnie LLC, which is the owner of the property where this project is proposed. And together, the entity and Mr. Arnold are the applicants for a conditional use permit from the City Commission for a proposed concrete batch plant on a small 5-acre corner of the existing Maddox Foundry property. The location of the proposed batch plant is critical. You'll hear the engineer talk about that and the property appraiser. It'll be situated back behind the existing foundry buildings, which will not be removed, which adds a visual screen as well as additional noise attenuation. As you heard, a concrete batch plant is a permitted use under your code at this location, given the zoning and the land use. There are other uses by right at this location that do not require a conditional use, which are also very intense and industrial in nature. Under your code, those include things like a distribution or storage warehouse, which would have a lot of truck traffic associated with it, a paint and body shop, a junkyard, things like that. There is a list in your code, as you know. We would submit that the concrete batch plant is a much less intense use than the historic foundry use of the property. So under your code, the consumptive use, I knew I was going to do that tonight. We're not here at the Water Management District. The conditional use permit is presumptively granted unless there is competent substantial evidence to rebut that presumption. So it requires you to kind of twist your mind around a little bit. Because it is a permitted use, it's assumed to be okay to approve it unless there are things wrong. And your code gives a list of where you have to look. And if you see there's something you're concerned about, like noise, you want to make sure that you put conditions on that approval to protect the citizenry. So if you have any questions about how that works, I'm sure your attorney can repeat me. So to date, based on my review as a lawyer, and what I say, by the way, is argument, it's not evidence. Same with Mr. Flagg. We're lawyers. We are not experts. We do not give you competent, substantial evidence. We try to help you understand what you're hearing and how it fits into your comp plan and your code. So please don't, I'm an expert on the law, but not any of the subject areas. Anyway, likewise, when anybody's up here before you and they're trying to give you scientific or technical data, competent substantial evidence is not a layperson who has no credentials in a science or a technical area simply giving you internet research. That doesn't count. So be on guard for that. We see that a lot in counties and municipalities, and it's not competent substantial evidence, nor is a lay person's opinion on scientific subjects adequate to meet that burden. The professionals who have reviewed all of the application materials are in agreement that it does meet your code and your comprehensive plan, and that the application contains all of the requisite information and the supporting technical data and analysis supporting approval of the conditional use permit. And at a future meeting, when you notice a future meeting, we all get back together, you'll be asked to approve a site plan, but not tonight, just the conditional use permit. And that's another important thing to remember as we move through this evening. You'll have people get up and who want to talk about, I don't know, all kinds of detailed design, building design standards. And that's not what we're here for tonight. The professionals who have reviewed the application, in addition to Mr. Thomas, who's a professional planner, include the North Central Florida Regional Planning Council, the Alachua County Fire Rescue, has looked at it for fire-related items, et cetera. Every professional who's looked at it has concluded that it does meet your code and your comp plan. This evening, you'll hear expert testimony from our project engineer, Mr. Chris Camure, who is a Florida licensed professional engineer, who has based he prepared the application, and he's based that application on his own work, of course, but also on the technical information that has been supplied by the various subject matter experts, like the environmental consultant, the property appraiser consultant, things like that. In your packets this evening, I have pre-filed with the city by the deadline Friday. We had a 5 o'clock deadline Friday. We met the deadline. I'm seeing new things tonight, which isn't fair. I want to note that for the record, coming in from the opposition attorney. But in your packets are those reports concerning environmental assessment, the fact that there are no impacts to property values. There's a report by our certified property appraiser and an affidavit from him. I gave that to you in an abundance of caution because we couldn't get a Zoom appearance to work. And so we'll try the phone for live testimony and cross. Also noise methodology, providing evidence that the batch plant will comply with the city's noise ordinance. One of the conditions will be that confirmatory testing is done once the plant is built so that it stays in compliance. Your staff has thoroughly reviewed the application and recommended several conditions, including hours of operation, with which we concur and have no objection to you including those conditions in your resolution this evening. So at this time, I would like to formally enter into the record applicant's exhibits and the index that goes with it. City attorney has had that link as of Friday. And Madam Attorney, just a reminder, when Mr. Kirkland is on the phone, he'll need to be sworn. Thank you. And at this time, we'll call up Mr. Engineer.
Hello, Madam Mayor. My name is Christopher Gamir. I'm a professional engineer registered with the state of Florida. I'm the president of Gamir Engineering, and we prepared this application on behalf of the applicant, Ronnie Arnold, and which he's also the owner of the property underneath Ronnie LLC. My resume is on file, showing more than 15 years of direct experience doing a wide variety of industrial, multifamily, commercial, restaurants, all across North Central Florida. And I prepared this application for this conditional use permit. Moving on to our next slide. So we get an idea of where this site is located in Alachua County. You can see we have distances to Newberry, Bronson, Williston, and Gainesville, and we're about equal distance between all those different cities in the area, which prompts the need for a concrete batch plant to serve the local construction community. Next slide. So let's take a look at the overall site there. So you can see we are a small portion of the overall 20+ acre site. We'll show an exhibit showing the actual portion. We're about 5 acres, so about 25% of the site. And it'll be on the western side of the property. And you can see right there on the western side, that's where the foundry is not located. So it's the open area on the west side of the site. And that's where the foundry was piling up their sand that they use for casting. So they would take a large casting, fill it with sand, and when it was all used up in their foundry process, they would pile it up in large piles on the west side of the site. So the foundry's been around for over 100 years, as everyone knows on the site. Mr. Ronnie is not the owner of the foundry at that time when it was operational. He acquired that property recently. And those foundry buildings will remain, except for, I believe, one building on the western side, but it's just a metal building with just storage of casting materials, et cetera, that the foundry utilized at that time. Moving on to, actually, let's go back one, because I have this as a zoom in, but my previous slide, we can do that. Yes, perfect. So to the north, you can see Mr. Ronnie's construction property. He operates a construction office north of the Maddox Foundry there. Also to the north is the fire station, the Public Works Department, and Archer Road, along with the church to the north of the site. So if we go to the next slide. To the west of the foundry site is Canopy Storage. That's where they do storage, long-term storage of RVs, boats, etc. You can also see a little section of Archer Road there to the north, along with the church. We then have to the east the foundry buildings themselves. And inside those buildings are 3+ stories. There's all types of large metal equipment, lathes, et cetera, that was done inside that building, and see how close it is to the southern property line. And the area that we're proposing the concrete batch plant would be on the western side. Again, you can see those large piles of casting sand that have just been piled up on the western side of the site. We can move to the next slide. So we're talking about the application timeline. This is something we've been coordinating with city staff for years now. You can see we had pre-application discussions with the city in 2022. We made our initial application with Gamir Engineering on October 9th of 2023. So we're coming up to a year in which we started the official application process. November 7th, we did comments and revisions to the application. We then got a determination back from the North Central Florida Regional Planning Council of their approval of the application, of its completeness. And in May, we completed the final acoustic study that was also reviewed by city's representative through Kimberly Horn, their engineering representative, and I'll get into that a little bit later on. We had our first planning and zoning board hearing that resulted in a tie vote. September 9th, we got the staff report with a recommendation of approval for the city commission, and we're here tonight hearing this application as well. Let's go ahead and work on to the next slide here. So you can see our proposed conceptual plan, site plan for the site. I try to make it color because many times our black and white site plans are hard to understand how they'll be laid out on the site. And so I hope you can see 3 different shades of green on here. So I'll start with the darkest shade near the top, and also you can see it's on the other side of Archer Road. I show those as dark green, even though they're stormwater ponds, because they're intended to be dry stormwater ponds instead of wet stormwater ponds. So in a big storm event, they'll fill with water, hold that water, let it soak into the ground, but most of the time they will remain dry. So I've started showing stormwater ponds that are going to be dry as dark green. They should grow really well with grass, etc. You also can see there's dark green stormwater ponds just north of the batch plant that's in gray. That's showing the paved area of the concrete batch plant. And to the dark green, just to the south of the batch plant, those are the standard settlement ponds used for a concrete batch plant. And we'll talk about later about the process in which the trucks will come in, they'll do washouts of them, and they have a whole settlement process that allows for recycling of all the water used for the operation of the batch plant. So now we go on to sort of the middle green, and on here on this green, it's looking more like of a bright green, but you can see it's a berm, and it wraps all the way from just underneath the church, goes to the west, goes all the way along the western property line, and goes along the southern property line, but not the southern property line you see in yellow. Those are additional properties that came with the Maddox Foundry when Mr. Arnold purchased the property. So instead, we're keeping it on the actual industrial portion of the site, and we're leaving all of those properties to the south in their existing conditions. So we're not proposing to take trees down there. We're going to have a full berm, and we'll get into how high that berm is a little bit later on in my presentation. And of course, the light green, that's just the grassed area that's going to be remaining between the berm, the concrete batch plant, stormwater ponds, et cetera, at this portion in time. Let's see if I covered everything. We are future land use of industrial with the industrial heavy zoning classification. And we are an allowed use as covered by Ms. Patrice Boyes. And one thing that we wanted to really bring up, and we'll go over this later on, is that we did an analysis of many, many, many concrete batch plants to see how they impacted their neighborhoods that they're in. And none of them had any sort of berm surrounding them. So that's a unique feature that the city of Archer is going to get with this application to address some of the perceived concerns that the community may have that the applicant is happy to provide on the site. He's a site work contractor. He knows how to build berms, and that's no problem for him to do. All right, moving on to the next slide. So this being a conditional use application, Ms. Boyce went over it briefly, but that the city requires that the conditional use approval for a concrete batch plant shall be granted by the city commission unless it's found to violate some of these 5 conditions. And we'll go through them in very great detail following here. So you can see these are the listed conditions. So we would have to somehow fail to comply with this land development code. We're going to show our compliance with the land development code. We have to pose some sort of danger to public health and safety. We're going to show how this facility is safe and healthy and exists across the state. This facility would have to pose some sort of substantial adverse impact on adjacent property values, and we have an expert that's going to be testifying to that, along with the report who's submitted for your record. This site would have to be substantially out of character with the existing neighborhood, and we'll talk about how this site has a historic industrial use on the property, so it's nothing new for the neighborhood. Or this site would have to be somehow conflict with the comprehensive plan, which of course, even your city planner, and we have reviewed, and also North Florida City Regional Planning Council has reviewed this application for its consistency with those documents. So we're going to get into the specifics of each of those components. So on the next slide, we're talking about compliance with the land development code, specifically industrial districts. So industrial districts are designed primarily to accommodate manufacturing, heavy industrial activity. And of course, this site has been a foundry for over 100 years, 1905 to 2022. So this should be nothing new to the area and its historical use of this property. With, I believe we all can agree, a foundry would be a very heavy industrial use on the site. So if we go to the next slide. So now we take a look at the table of permitted uses. And as Mrs. Boyce already talked about, your code allows for all types of industrial uses that would be a use by right, not even requiring a conditional use permit. Wholesale sales, which would have tons of traffic coming into the site, fabrications and assembling operations inside a fully enclosed building. So the foundry could reopen today without any conditional use permit on the site. They could do a cold storage facility, so they could have meat packing or other kinds of things on the site, warehousing, distribution, and storage. Again, these are all items that would not require a conditional use permit. Manufacturing items for treatment and items of mass production operations conducted inside a fully enclosed building. So these can be items in which they're doing all types of chemical treatments and other types of manufacturing, sorry about that, manufacturing processes inside of a building, and again, would not require a conditional use permit. Public charter schools, sales, rental, paint and body shops, junkyards. That's the one that really stood out to me. A junkyard could operate in the site without any conditional use permit. So the only thing that would come up in here is the fact that we're proposing to do manufacturing and assembling outside of a fully enclosed building. That's the reason why we're here with you tonight. It's not whether or not the use is particularly out of character. We just met the technical definition of not being inside of a fully enclosed building. And with that, I'll continue on to the next slide, which is compliance with the LDC, but section 17, the performance standards. So those standards include fire safety, dust control, glare, and noise. And the next slide will talk about specifically fire safety. So when we provided our plan to the city to review, we showed the location of all the fire hydrants, et cetera, on the site. And to note that the review of this conditional use permit was for the actual batch plan itself. So there's been a lot of concern about the site in general. And yes, a foundry would have all types of issues with fire concerns, et cetera, but that's not what we're reviewing. The foundry has stopped its use here. And we're talking about a concrete batch plant. A concrete batch plant is storing sand, it's storing rock, it's storing the cement itself, and all of those items do not have any fire risk associated with them. Matter of fact, they're stored within bins that are usually built with CMU blocks. So again, there's not much concern about fire on the site, and the site already has a fire main going down the center of it that we'll be evaluating in the site plan process to confirm it has the needed fire flow, but the needed fire flow for a concrete batch plant, since it has no storage of flammable materials on the batch plant itself, is incredibly low. And so we would do whatever is needed to meet that fire demand requirement, which is why Alachua County Fire Rescue, when they reviews the application approve the proposed site plan as shown for the concrete batch plant. So if we move on to dust control. So the biggest concern that we've heard from the community in general is about dust control. And we understand the concern that neighbors have brought up, but things have changed a lot over the last 20, 30, 50 years when it comes to dust control. The biggest thing that was sort of brought up in the last P&Z meeting was that the dust coming from the actual processing machinery itself might be coming from the cement, but that cement is money. That cement dust would be encapsulated by the filtering. You can see we control 90% of the dust at the 1 micron level, okay? They have an entire computer controlled, that's what PLC stands for, a computer controlled system that monitors all the pressures inside the machinery occurring. And once it gets to a certain level, they have a control system that uses a jet pulse to go backward through the internal filters, dump whatever materials in those filters back into the corkscrew that then takes it right back and puts it right back into the cement bins for use and continued use inside the mixing equipment. That's what we're selling, for lack of a better term, in a ready-mix concrete plant is that concrete. And that's what's very valuable about the facility. On top of that, we have other things that we're mixing in to make concrete. You have sand, rock, etc., that need to be stored in these bins. And some concern was, well, maybe there's some dust coming off of those facilities. Well, that's not a concern for us and concrete batch plants in general, because when you're mixing that material, you have to meet very strict FDOT guidelines on the mixing quantities and ratios of each component inside the concrete. As such, you keep those piles wetted with the recycled water that you get from the washout so that it has a known water content, so that when you test your concrete at the end of making it, it'll meet all the criteria and you won't have to guesstimate on that. You don't want sand that's partially dry, partially wet at different times, depending on if it rained the last 2 days. You want sand that has a known water content so that when you mix it up, you'll get a finished product that meets all the criteria for the delivered product. So that's what I mean by the water sprinklers using recycled water to control aggregate bins for dust. We're keeping those bins continuously wet with the recycled water. Let's go on to the next slide. So we're talking about glare. This was a huge concern for cities over the last 50 years. How many lights have you seen people put on their backyards and it was just beaming into people's yards over the last decades, right? But that's finally gone away. We finally realized and got through to manufacturers of lighting that all of them now come with glare guards to keep the glare down around the entire facility. That is not a hard standard to meet. That's a no problem standard to meet for glare. And on top of that, that berm that we're providing as an additional added benefit for the city for this concrete batch plant will then make the visibility of the concrete plant unvisible because it's going to be an 8-foot tall berm around the facility. So site lighting and glare is not even a beginning concern for this project and for the neighbors. Next slide. So let's talk about that berm, all right, and the noise ordinance. So we completed a noise study, and for an abundance of caution, when we calculated the worst type of equipment, so there's many different types of concrete batch plant equipment, and the worst type of equipment for noise would be the tall stacks you've seen sort of in the city of Newberry one, where there may be a mixing motor at the top of that. And so in the noise study, the providing of that 8-foot berm attenuated a lot of that noise. And then even on the southern side and the northern side, we provided an acoustic fence on top of that berm in addition to the 8 feet to confirm in the study that we would meet the city noise ordinance. And this was confirmed by the city's consulting engineer, which you have a continuing contract with Kimberly Horn. And in their May 23rd, 2024 communication, they confirmed our approach to the noise on the site. Yes, good point. Miss Boyd brought my attention. we made a typo on here where it says 7 foot, and our intent is providing 8 foot, and it's all the other documentation.
That's what I was gonna ask. Thank you.
Thank you, Madam Mayor. It's right here on my notes. I don't know why I missed it. And then again, one of the conditions is we're going to continue to perform acoustic monitoring after construction's done. We want to ensure that we're not going to have any problems with the city's noise ordinance at the site. We'll get even more into the noise ordinance. Let's look at the next slide and what we're proposing. So this is sort of the black and white exhibit I'm talking about, where I hope the color won't help there. You can see the linear 8-foot tall berm along the north, west, and southern lines. All right. And then you can see the sort of line with circles that represents the acoustic fence and or the vegetation along those specific northern and southern perimeters. Okay. On top of that, if you notice how the batch plant does not get to the berm along the southern property line, we're providing an additional 100-foot separation from that southern berm. And let's say we come back and we want to add some storage buildings there or something in that 100-foot area, that would increase the sound attenuation along the southern line there. So we're adding this as sort of like sound attenuation buffer between it. And anything we put in there would just increase and add more to the buffering of any sound from the site. On top of that, you can see the hatched area at the bottom. I sort of mentioned this before. Those are properties that came with the purchase of the Maddox site that aren't industrial. Those are still residentially zoned properties in that hatched area south of the southern berm, and those will remain in their existing conditions. We don't want to go into those areas at all. And as such, with all this review and analysis with that study, we expect to meet the City of Archer's maximum decibel levels at the property lines. All right, let's go ahead and move on to the next slide. So now we're moving on to public health and safety. So we have not seen anybody submit any competent, substantial evidence of adverse health effects or safety risks from a concrete batch plant. The property will be operated. It will control and collect its dust. It will mitigate and provide excess buffer to ensure no off-site adverse effects. And what we've only received to date has been just internet research. Matter of fact, concrete batch plants are located all throughout everywhere in the whole entire country because they're needed in order to get your driveway poured, your sidewalk poured, your footer for your buildings. These are materials you live with every day. Workers go after concrete is poured. They work these materials. They're working with them all the time. So they're a final product that you can just buy from Lowe's and have inside your house working with it nearly any point in time. It's a very common building material, very safe building material. Moving on to the next slide.
Yes. Can I ask the question?
Thank you. On this.
Go ahead.
Okay. Back to the other slide.
Okay, good. Please go back to the previous slide then. Thank you.
I apologize. Back to the other slide.
Go back one slide, please. Yes.
You're saying no competence to substantial evidence of adverse health. What are you considering substantial competence?
Yes, Madam Mayor. So this was reviewed by Ms. Patrice Boyes, and she can go and answer that question more specifically if you'd like, or the city attorney.
Competent and substantial evidence is going to be evidence received from either an expert or a qualified individual, testimony to that nature, whatever their field is, documents that have been submitted in accordance with the opinion of an expert, things of that nature is going to be your typical standard for competent and substantial evidence.
So they bring in something from the evidence, from the internet, but it's maybe from DEP, maybe it's from, I don't know, whomever, somebody that suffered from it. That's not competent, substantial.
I can't hear your question, Commissioner Wood. I'm sorry.
Did you hear it? I'm sorry.
I did not, ma'am. And maybe that'd be a question for the city attorney to answer as well.
Let me put it in my mouth. If someone came, one of the citizens, anyone comes up here, you do, whatever, and shows something from the internet, because you're saying you're throwing the internet out. And they have something that is documented through DEP, through whomever. That would be a competent, no?
It's hearsay. It's hearsay. Under the evidentiary code, it would be hearsay because you don't have the author who wrote that memo, let's say it's an EPA memo, you don't have that individual here to substantiate or answer questions about it. So that's the problem with everybody doing internet research nowadays and loading up the record.
So Madam Legal, our legal, we're supposed to throw that out?
Hearsay is an out-of-court statement that is being relied on for the truth of the matter asserted. So an internet document that cannot be verified by the author before you tonight is hearsay.
Thank you.
I don't mean to be harsh, but that's the legal standard we have to all abide by.
All right, Madam Mayor, moving on to the next slide. So we're going to have testimony from the certified legal appraiser that no impact to the adjacent property values. So the Florida certified general appraiser found no impact in their study on the property values based on his study of the sales data for Florida homes adjoining concrete batch facilities, and in some cases closer to batch plants than what we propose here in the city of Archer. And he noted that the berm was unique to this facility that's being proposed. That's in no other concrete batch plant that he did his analysis with. That demographic data shows that in most cases, within a quarter mile of a batch plant, they actually have higher price points than the market average, with buyers having in those quarter mile areas higher than average incomes in the study that he performed. On the next slide. He also noted that the existing foundry improvements are closer to adjoining homes and are substantially more impactful than the proposed batch plant. So compare a foundry that's been there to a lesser use, a concrete batch plant. And that foundry was not a brand new use to the community either. It's been there for over 100+ years and makes up some of the historic fabric of the city as well. Also, you'll note that there's subdivisions going on in the city of Newberry, and there is a batch plant in the city of Newberry just south of the Easton Newberry Sports Complex. And the new housing is going in all around the Easton Newberry Sports Complex. And you can see the batch plant very clearly driving down US 41. And these new homes are being constructed, directly visibility of that, all the way down towards that southern property line. And you can see these homes filling up with people living in them across the entire area. So again, the new subdivision homes show that the close proximity to an existing batch plant, that these home values are even higher than the existing homes that were in the area in the city of Newberry.
Excuse me right quick. I'm going to ask for the conversations to please cease. It is difficult for everybody to be able to hear the information and pay attention to the information with so many sidebars. If you need to discuss something, please step outside. Thank you.
Madam Mayor, moving on to the next slide. So we also received no competent substantial evidence of the impacts to the surrounding properties. For example, we're not proposing a change to the land use or the zoning. We're using the zoning that's been there, that the city of Archer designated for this property, that's historically been on this property. The character of the site as an industrial site and its surroundings has pre-existed for 100 years. And our proposed use as a concrete batch plant is less intense than that previous 100+ years, because the Maddox Foundry plant reduced and reduced and reduced over time. It's been way more substantial at previous points in history. On top of that, currently the Maddox plant has sort of a shared driveway to Archer Road right with the church. We're going to have that be dedicated to the church. As you saw, we have that berm surrounding the northern and western side of the property, so we're not going to use that driveway anymore. And we can show, or we show in our conceptual plan, a dedicated driveway to Archer so that we're not having to go through the city with any of the traffic. We'll work with FDOT for specific permitting of that driveway connection and make sure it meets all the applicable safety concerns of exiting and entering the site from this Archer Road. So we can go into the next slide. Finishing up with the neighborhood. So we showed on that exhibit, the black and white exhibit, that additional 100 feet by moving the southern part of the batch plant 100 feet north from the proposed berm. And all the other uses around the site. To the north is the church, and of course, Archer Road, and of course, Public Works and the fire station. To the west is the canopy storage facility. To the east of the batch plant is the Maddox Foundry itself. So those are all non-residential uses, and we're providing all of this buffer to the south for noise purposes. And on top of that, it provides visual buffer as well. And so our proposed use is in character with this historic, heavy industrial use of the site. Going into the next slide, we're getting into the comprehensive plan requirements. So the future land use element has potable water capacity, and city staff has done their concurrency report that potable water capacity exists, as well as sewer, etc. Our site is located along Archer Road, which is an arterial collector road, which also meets the requirements of the comprehensive plan. And on top of that, stormwater is a huge concern for this site. Matter of fact, we sort of were surprised when we started talking with FDOT that along Archer Road, right there in front of the Maddox site, I don't know, maybe 15 years ago, they installed some stormwater piping down Archer to the west, towards the low spot there, right in front of the church, and it didn't go anywhere. So part of this development is we're providing new oversized stormwater facilities on the site, and also they cross over onto the construction property to the north of the Maddox site as well. So if we move on to the next slide, we'll get more into the benefits of this oversized stormwater facility. So hopefully you can just click cancel in the bottom left corner there. Hopefully it'll go away. There it goes. Perfect, perfect, perfect. All right. So this is where my even more specific expertise. I probably tell people I spend 3/4 of my time talking to people, and I spend the other quarter of my time doing stormwater calculations. Okay. It's a big portion of my design because of what the impacts to personal property, to infrastructure, to emergency access, stormwater can be when it floods a road, when it floods people's homes, when it floods neighborhoods. It can have a huge detrimental impact to the economy of a city. For example, city of Alachua had a large problem with their downtown having incremental flooding. And it just put a lot of burden on Bev's Burgers and all the other communities when you're trying to go to downtown for lunch and there's 6 inches of water in your entire downtown. So that's a big issue here. So for our site, it's surprising to know that you can see there's a large red and yellow dotted line that encompasses the Maddox Foundry, Ronnie Arnold's property, Public Works, fire station, the church, portions of the park to the north, portions of City Hall, residential areas to the east, and it all drains down to one low area right next to the church. And the FDOT has pictures showing it really close to flooding the church. And when I run my calculations, because we're in the Swanee River Water Management District, it's incredibly undersized to handle the large storm events that the Swanee River gets. So there was no existing stormwater capacity there that existed today. FDOT never solved it when they did stormwater pipe work. We're going to take all the existing Maddox impervious area coming to the site. This large drainage area means that Mr. Ronnie is going to be constructing a stormwater pond to serve the church, the fire station, public works, all these areas that discharge to this low area, and have at the end, an FDOT stormwater pond in his front yard dedicated to FDOT for that purposes, so that it can meet all the different drainage criteria, taking even Archer Road runoff into that stormwater pond facility. And we're going to be having permits from all of these agencies with that process. Matter of fact, the size we have shown there, we believe is probably 90% correct with all their standards, with all of our conversations and permitting that we've been doing with those agencies today. Moving on to the next slide. More comprehensive plan, the future land use element. So we found no unsuitable areas on the site per the phase 1 and phase 2 environmental studies that were completed. The environmental review found no sensitive features, including endangered species or wetlands on the site. Again, this was a historical industrial site. The comprehensive plan encourages urban infill development on existing industrial sites. So that's already in your code. And we know how much the Maddox plant was reducing in activity. And so this continues an active site and continued economic development within the city. And we've placed the equipment with additional buffers, with oversized stormwater management facility that mitigates these impacts and improves the existing conditions, which is also an objective in the comprehensive plan. Moving on to the next slide. So traffic circulation element. So we already talked about that northwest driveway being eliminated. That's an objective in the comprehensive plan. We're limiting our access to Archer Road to the, they call that a limited to the facility. And that's because when you have something, they encourage you to have direct connections to the major roadways. We're meeting that criteria. Obviously, the closure of the foundry and the low impact of trips from the concrete batch plant results in a negative reduction in trips from the site. And we have the full site plan review that's going to follow the CUP to evaluate the safety and operational improvements when we make that driveway connection to Archer Road. So the FDOT is going to evaluate if there's any turn lane requirements, deceleration lane requirements, and the traffic levels of that roadway. And we've already had some of those items, conversations with FDOT as well. So moving on to the next slide. So now we're talking about economic development. So this concrete batch plant is operated as a subsidiary of a long-term construction company that's operated in this town. So Mr. Ronnie Arnold has been operating his family-operated company for 35 years, and he has it headquartered in the city limits of the city of Archer. Since 2010, he built it here. You can actually see in the aerials when his building got constructed as you compare it over the timeline of this city. This specific concrete batch plant will create between 15 to 25 jobs approximately. And Mr. Ronnie Arnold has experience in construction company, and he'll be able to leverage this concrete batch plant and its market position to make sure this batch plant serves the community in order to facilitate construction projects in this local area, bringing jobs to the city of Archer, but also reducing truck trips. So the concrete needed for these developments are coming from somewhere. So they're coming from other concrete batch plants in other cities that are driving through the city of Archer to get to these construction projects, both in the county, city of Archer, city of Newberry, etc. Move on to the next slide. So we're getting to state permits. So this facility will require an air general permit required by Florida DEP. So that's where the city of Archer relies on other agencies to make sure it remains in strict compliance with this permitting. We're going to need an environmental resource permit by the Swanee River Water Management District. We've already applied for that, and we had actually put that on hold because of how long the CUP process was taking. And the city of Archer relies on these state agencies for environmental regulations as listed in your land development code, that you rely on these agencies. Moving on to the next slide. So review You can scroll up a bit. One more down. Perfect. So we've had several reviews during this process. For example, the North Central Florida Regional Planning Council, in their March 7th, 2024 letter, indicated that this CUP application met all the CUP submission requirements, and you have that letter. We have environmental studies and noise methodology that your North Central Florida Regional Planning Council, and on top of that, Cumberland Horn as the city engineer, reviewed these reports, deemed them sufficient. Your city staff recommended approval of this project based on review of the Land Development Code and the comprehensive plan. And at the Planning and Zoning Board, there was a motion to approve, but it resulted in a tie vote, which then moved this application to you, the City Commission, with no recommendation. Moving on to the next slide. So this is a request on behalf of Ronnie Arnold, to respectfully request the approval of this conditional use permit for a concrete batch plant under application number 23-01. And we thank you much for that. Yes, good point. So we also have letters to enter into the record of, please excuse me, so many papers up front here. Here we go. Of developers and contractors in the area that are in support of this application. I will hand it to the city attorney. They are from CCI Cabot Construction, from Rory Casal, and from Robert Burleson.
Thank you.
All right, Madam Mayor, I have Richard Kirkland on the phone. We're going to do a sound check. Rich, if you can please state your name for the record.
Hi, my name is Rich Kirkland.
Can everyone hear him? Madam Court Reporter? Can you hear him? Okay. Mr. Kirkland, please go ahead with your testimony.
Sure. Again, my name is Rich.
Oh, wait, hold on. We need to swear you in. I'm so sorry.
I apologize, sir. I know we can't see you, but if you would please raise your right hand. Do you swear or
Yes.
affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
May we proceed? Go ahead, Rich.
So my name is Rich Kirkland with Kirkland Appraisals. I'm a state certified appraiser in North Carolina, Florida, and about a dozen other states. I am also an MAI through the Appraisal Institute. We regularly do conventional appraisal work, but we also, as part of our practice, do impact analysis on a number and wide variety of uses. We were asked to do a impact analysis regarding the concrete plant at this facility in Archer. And I believe you've got a copy of this in the report that's being submitted to the record. But I guess I'll be speaking to that, assuming that that is part of the record.
Yes, it's in the record.
So we do impact analysis on a wide range of things. We've looked at concrete plants before. We have looked at concrete plants associated with rock quarries, as well as standalone facilities like what is proposed here in other states. But for this project, we focused on data that we can find in Florida. When we do impact analysis, we are typically looking for what's called a paired sales analysis, sometimes called a matched pair analysis. Simply speaking, we look at homes that are near, in this case, a concrete plant, and we compare that to similar homes that are not near a concrete plant to see if there's anything that we would separate out and attribute to that proximity. We also sometimes do a resale analysis. This works best when you've got a home that sold prior to, say, a concrete plant coming into location, and comparing that to a more recent sale after the concrete plant is there. And we also look at demographics around these projects, and we've looked at all these in this process here. Specific to this project are a number of mitigating factors that we consider. The adjoining land, the nearby homes that we were identifying to this facility are already adjoining land that is zoned for heavy industrial use. There's a factor that is often identified just due to the proximity to that heavy industrial zoning. due to the fact that the market already recognizes that there are a number of by right permitted uses that that land could go to. We also have considered the existing and historical foundry use that's right there. It's a large industrial facility that is right there and is in closer proximity to the same homes that we are looking at related to the concrete plant. So, and the third mitigating factor is actually a part of the proposed project is the berm that they're proposing to put around it. A lot of the concrete facilities that we look at do not include berms. And so this is a positive attribute of the facility that's proposed that could provide a mitigating factor to property around that project. And looking at the nearby uses, looking at similar concrete plants, we looked at about 5 different concrete batch plants around Florida. The first one is in Newberry. You can see that starting on pages 10 of my report. And important to note is there's a nearby subdivision that was developed after the concrete plant was in use, and new home construction has been ongoing in there. We specifically identified the closest sale for analysis, but there are numerous homes within a short proximity radius around the concrete plant that sold at similar prices and provide similar data as far as sales points. Those homes are selling in that new subdivision between $300,000 and $400,000. And just for comparison, the median income for Newberry City and the median home price, I should say, the median home price is $300,000. So most of the homes in that development are above the average and above the median for Newberry. But we specifically looked at a property at 25034 Northwest 9th Lane, and that home sold in April of 2023 for $380,000. We compared that to nearby identical homes and or nearby similar homes and found that they were selling at very similar price points. And there's numerous examples of that throughout that development that are similar to that. We also looked at projects over in Jacksonville. We looked at a home sale that happened. This home is about 340 feet from the existing concrete plant. And when we do a paired sales on that, we still find actually the home that sold closer to the concrete plant actually sold at a premium above that, the home that was further away. Likely that is attributed to the landscaping buffer and the trees that separate that plant from the comparable properties, but again, does not support a negative impact on property value. But again, I won't go through all the examples, but we have others in there, and they're consistent with data we've seen in other locations. That home values, when you have them in proximity to these projects, when there's already an expectation in the market of impacts associated with industrial use, there's no sign of any additional impact due to the concrete batch plant use. I'd be happy to go into greater detail, but it is my professional opinion that this project as proposed will not have a negative impact on adjoining property values, that is in harmony, and that it is in character with the existing neighborhood.
Madam Mayor, if there are any questions from the commission, I'm sure he'd be happy to answer.
Questions, commissioners? Any questions? No, thank you.
Okay. Is there any cross?
Mr. Flagg, if you, oh, there was a chair there, now there's not. We're gonna turn Tony's mic around. Can you turn it so that he doesn't have to?
No, that's okay. Just future recommendation, maybe we can prepare a quasi judicial hearing properly. If possible, I'd like to be able to cross Mr. Christopher Gamir, sorry.
I think we're going to do that in the normal order. We asked to take him out of order because of the
I'm sorry.
logistics.
I understand. Okay.
All right.
All right. So this is your appraiser,
Yes.
Mr. Kirkland.
Yes,
Mr. Kirkland, is it correct that you have not been to Archer to actually visit the city?
I have been to Archer before, but I have not been there for this specific assignment.
And when was the last time you've been to the city of Archer?
It's been within the last 2 months.
And you talk about the other surrounding properties that you evaluated. Did you do a drive-by, or did you do anything to actually physically or closely inspect any of those properties?
We did a desktop analysis for this report.
And wouldn't you agree that one of the primary important considerations of any appraisal work is to actually have a detailed understanding of the property that you're analyzing?
I'm going to object for the record. Object to form,
It's quasi judicial.
but you can answer. Well, we're making a record.
We're not in a
You
deposition.
can answer.
I'm not sure I fully understood the question, but again, we looked at street views using Google Earth, and we looked at the aerial imagery through the GIS and Google Earth to identify the adjoining properties and characteristics, and looked at MLS data regarding the properties we analyzed.
Sorry.
I'm sorry. So again, please keep your conversation to a minimum, especially now, because we are trying to hear Mr. Kirkland on the phone. So please, let's be respectful of each other. Thank you.
Mr. Kirkland, this is Byron Flagg again for the record. When you came through Archer approximately 2 months ago, what was the reason for coming here?
I was in Alachua County for a different hearing.
So your visit to Archer back then, 2 months ago, was merely just passing by, is that correct?
Yes.
And if I understand your testimony tonight, you and your team basically just did a desktop review using Google Earth. Is that correct?
Objection. It's not what he testified to.
We did a desktop analysis, but in the process of that, we looked at a number of sources, and we identified every adjoining property. We measured the distance to every adjoining home. So we have a very good understanding of what is around it.
But none of the information that you actually looked at or the Google Maps that you looked at are actually submitted into the record, or are they?
Pardon?
Are any of the maps, the desktop maps and the Google review data that you looked at, did you submit that as part of your report?
There are a number of these maps, yes, and the demographic data included in my impact analysis, the written report.
But you did not create any of those maps or the data yourself, did you?
I actually made those maps myself, not the ones that are referencing the site layout, but as far as pulling the imagery and the demographic maps and the surrounding uses, that was me that generated those using the GIS website.
And which GIS website were you using?
I would have been using the county GIS.
Thank you. Another question.
Any redirect? I know that you had asked for time to rebut. I don't know if you want to clarify any testimony that was given.
No, I think we're good. I meant rebuttal at the end of the case.
I just want to make sure.
Thank you.
Commissioners, I do want to give you one last shot to see if you have any questions for this expert. Obviously, he's appearing telephonically.
Bad questions? No? Yes? Yes.
Thank you.
All right. Thank you very much for your indulgence, Mayor and Commissioners.
Thank you.
Anything else, Chris? All right. And with that, we rest our case in chief.
Mayor, for clarification, I'm sorry, maybe I missed the trick, but where was the point where we could ask questions of Mr. Camille?
Of who? I'm sorry.
Did we do that?
Of who?
Of the engineer.
Of the engineer. At the end, we only called him out of order because he was only available telephonically.
I'm sorry, I'm
No,
slow,
you're
but
fine.
Kirkland got the questions, Mr. Camille did not.
Correct,
So, okay,
correct.
Later on, thank you.
Madam Mayor, we can make him available whenever you say.
Thank you.
Madam Mayor has requested a bathroom break, so if everyone's amenable, we'll take 10. It's 8:11, so we'll resume at 8:21.
Tony, can I possibly get a bottle of water? I'm kind of dying. Grab my head.
I've seen it. I've done the DOT. Submittals and turn lanes and stuff. We've done 1,200 pages. That's 2 years long.
We got lucky, we didn't discharge it. That's actually, you can. 5 acres. You have that under your core outside. And it's only for the impervious areas. Correct. You can have grass areas. But then you have to include. So that puts you, so then you have 100 years. When that pond, you get 12 tree. And as that overflow, you can discharge, then you take that discharge goes in, and you don't have to consider any calculations from that. That's I'll explain. Everything permitted is yeah, he is like, you get ready for the design. You get ready for the design. You get ready for that design. That's what well, the really it's about the site. So the site layout, whoever's doing the site layout, I propose the site layout. But you gotta get the site layout. So put your strategic location, type 2 in the back of the farm, show itself. That works. Anything. Nothing. It's, I can tell you all about it. Yeah, I can. I've got, well, take, if you haven't done it, I'll put you on that. Don't touch it. I've got a guy. Yes, I've got a guy can do it in 60 days. But most engineers do it in 30 years. Take a year to do this. I got a guy to do it in 60 days. And I got professional guys that give you
All right, ladies and gentlemen, we have 1 minute. Want me to say it?
I'll go.
All right, it is 8:21. The attorney is going to make sure everyone in the lobby and outside knows that we're starting back up.
I'm sorry. All right, Madam Mayor, with your blessing and the commission's blessing, I'd like to pick up where we left off.
Yes, ma'am, please.
All right. Mr. Thomas, it's now the time for the city's presentation. Would you be so kind as to kick us off?
Yes, Madam Attorney. Let's see. Okay, so where we stopped off was the brief description of the conditional use permits. Your conditional use permits are granted by a resolution of the City Commission. As you are aware, because you've discussed it, it's heard in a quasi-judicial hearing, which means that decisions must be made based on the standard of competent and substantial evidence. Competent meaning competent and substantial evidence. The competent meaning next, the testimony given is from persons qualified to give evidence on the subject matter. They've had some kind of additional education, special training, years of experience, and substantial meaning that there is sufficient, relevant, and credible evidence. So you've got a body of evidence in support of that decision, whether it's for approval or denial. Next. It is not supposed to be based on the popularity of the proposal. That popularity is not allowable as evidence in a quasi-judicial setting. So staff findings, and before we go into the staff findings, I want to address one thing. So as a professional planner, I'm guided and governed basically by the AICP Code of Ethics. And I just wanted to make clear, you know, the very first principle that a professional planner is governed by is that people who participate in the planning process shall continuously pursue and faithfully serve the public interest. And that is my intent. I want to assure everybody I was not brought on to represent the city of Archer to advocate in favor or against the project. I was brought on to make sure that the commission is provided from the planning perspective with competent and substantial evidence of the application viewed from the planning perspective in relationship to your comprehensive plan and your land development code. And that's what I have striven to do. And based on all of that is where the staff's findings and recommendations come in. So per section 16.06 subsection 4.02 of the City of Archer Land Development Code. Your conditional use permit is required for this development. Section 7.06 of the Land Development Code governs the issuance of the conditional use permit, which requires additional standards to ensure compatibility with the surrounding community. And once these conditions are established, if this is approved and those conditions are placed in the resolution, that essentially becomes the law that governs this application. And once those are in place, any violation of that is considered a violation of your land development code. City of Archer Land Development Code states that a conditional use permit shall be granted unless these conditions occurred. It doesn't comply with the Land Development Code. It does pose a danger to the public health and safety, poses substantial impact on adjacent property values, is substantially out of character with existing neighborhoods, and conflicts with the city's comprehensive plan. Next. And so after review of the application materials and the expert testimony, staff finds that the conditional use permit CU 23-01 is compliant with all relevant provisions of the city's land development code. It does not conflict with the City of Archer comprehensive plan. And staff recommends the following conditions. Before we get into conditions too, I just want to make it clear, I did speak with, as part of my review and research into the project, in addition to the land development code and the comprehensive plan, I also spoke with a member from County Growth Management, the director of the Growth Management Department. I spoke with the director of the Hazardous Materials section of the the Environmental Protection Department. The county didn't take a position either way, but they felt there was no indication that there would be negative impacts to county resources. And they did not make a recommendation for or against the project. They were neutral on it, but it was just, they did make clear that they didn't see that there were going to be negative impacts on county resources. The reason that I contacted them about the Environmental Protection Department was to look into issues with the Gainesville batch plant that's operated by Argos, and there's also the Florida recycling facility there, which crushes concrete and recycles it. And what he shared with me was that the primary concern with dust, well, the primary concern was dust, but that the dust they discovered on investigation was from the trucks exiting the site. It wasn't from the process itself. That wasn't, dust and all was not becoming airborne as a result of the silos or anything like that. It was because it was when the trucks leave. And so, they added some features that knock the dust off, knock the loose sand and dirt off of the trucks before they leave the site, which is cut down, he said, on the dust becoming airborne, and has substantially improved the situation. They also, to my knowledge, do not have a berm around those facilities. And then the other thing I would share with everybody is that I do have experience with batch plants, both because the city of Newberry already had one in existence, the Watson plant. The concrete batch plant was there when I started working for Newberry, and then they also added an asphalt concrete batch plant, which is a little bit similar but a little bit different creature. And then also, before I left the city of Newberry, we had an application for a second batch plant to be operated by a different organization on 50 acres, which was going to be directly adjacent on the south to an RV resort and directly adjacent on the north to and west to residential development, similar to the residential developments that are being built on the north side of the existing Watson plant. My experience while I was with Newberry, I was also over the code enforcement department, and the code enforcement for the 10 years that I was there, the only complaint we ever received about a batch plant was not the Watson plant. It was actually a temporary batch plant that had been established over by the Countryway Town Center to facilitate development of that particular development only. And late at night, they had some complaints about the trucks backing up. The trucks have the warning signal when they go into reverse. We never received any complaints about dust, and we never received any complaints on the Watson plant, which is a little bit farther than this development would be to the existing neighbors, but it does have a couple of existing neighborhoods in close proximity, and now a new neighborhood that's building closer and closer to it. And so that's sort of my background with batch plants did not have a lot of conflicts with the local community, at least not expressed in terms of complaints to the city or complaints to code enforcement. So with that, so the list of conditions, and these conditions are designed to mitigate potential externalities from the development and to ensure compatibility with the surrounding community. So constructing, as been discussed, the 8-foot earthen berm around the southwest and north sides of the batch plant, as you saw on the conceptual site plan that was presented. They'll have additional buffer area on the south. I believe the applicants, Mr. Gamir, discussed that. On those two particular parcels will remain as undeveloped buffer on the south, which is directly adjacent to the residential. Next. And on top of the 8-foot berm, earthen berm, they're going to put a 6-foot tall sound attenuation fence on the southern and northern side. So the side facing the residential section and the side facing the church on the north. Next. Operating hours of the batch plant are proposed to be between 5 a.m. and 7 p.m. Next. And they'll construct or improve existing stormwater management facilities on the site that will take not only the stormwater for the batch plant itself, but will also address issues with existing facilities on site. It'll take all of the water for all the impervious surface, which is not being collected right now. And then also there apparently will be an agreement between the applicant and Florida Department of Transportation to take some of their stormwater off of State Road 24. Applicant agrees to operate the concrete batch plant in strict compliance with all applicable federal, state, and local laws pertaining to safety, noise, and emissions. And I will say, one of the things that I discovered when I was doing research previously for the new batch plant in Newberry was also that under common regulatory requirements and inspection cycles and best practices, a batch plant today is far more compatible, can be far more compatible with the community than those of the past. It's when I did my internet research, trying to find things that would either corroborate some of the objections I heard in the planning and zoning board meetings or not, it appeared that it's easy to find a few bad actors out there, but what you didn't hear about was all of them, and there are hundreds all over this, thousands all over the country. You don't hear about the ones that are not that are behaving well, that are using best management practices, because nobody complains about those. And so there were complaints from primarily jurisdictions outside of Florida that maybe don't have the same regulatory compliance issue requirements that we do. And it didn't seem, I didn't find a lot of evidence to support the concerns that there was going to be excessive dust all over and that the noise was going to be untenable. And then also too, I also took the angle trying to find out if I could find any research that it would give me some form of basis of an opinion on the property values. And the most I could find was a study that was done by a group of appraisers, but it wasn't specific to batch plants. It was specific to industrial sites themselves, which are, of course, similar in nature. And those did find a small negative impact, but it was, again, it was a situation where it was an existing neighborhood and they were developing an industrial site next to it. It was not where the industrial site was already there and the residential was already adjacent to it. It was bringing in a new industrial use that had not been there before. And so, again, not an apples to apples comparison. And so my professional opinion as a planner Well, let's continue. So the recommendation, based on my examination of the application, the examination of your land development codes and your comprehensive plan, is that it is a permissible use under your code with adequate conditions, which you'll be evaluating and approving or not approving tonight. That it's, my recommendation would be for the approval based on the fact that the land is already zoned for heavy industrial. It doesn't appear to be any more of an intense use than was. In fact, it's probably considerably less intense use than previous use as the foundry over time. And so I didn't really find any substantial conflicts that would give me any reason to recommend to you denial. In fact, the opposite is true. It actually, everything that was in the application plus your land development code lended itself to a staff recommendation for approval based on your code of resolution 2024-19. Open to, of course, any questions from the commission.
Commissioners, any questions?
Yes, ma'am. Let me put this in my mouth. First of all, you said you did look at the comp plan
Yes, ma'am.
closely.
I looked at every element that pertained to this, so the future land use element and any environmental issues. I didn't look at things like the interlocal agreement with the school board and that kind of thing, because it's not going to have any.
Did you look at the historical aspect of it?
I'm aware that it's been there as a foundry for a long period of time.
And listed on the Florida site, Florida historical site?
That part I did not look into.
And that's part, and it is listed, it is on the State of Florida Museum of History. Did you look where our comp plan wanted a historical district? And that would be, it would be a 15-acre, about a 15-acre radius with Maddox right there in it.
Madam Mayor, I didn't look at that kind of an issue because it was outside the purview of what I was asked to do for this project. But that does bring up another point where I know some of the comments in the Planning and Zoning Board hearing were related to the appropriateness of having a heavy industrial zoning in the middle of downtown. And certainly that's an issue, but it's not an issue that necessarily we can address at this point, because what I was tasked with was looking at how things are, not how things should be or could be. And so based on how things are in terms of your comprehensive plan and your land development code, the existing zoning, the existing feature land use category, that's where my recommendation came, because as things stand right now, I think the right thing to do is to approve the.
And I understand where you're coming from. I totally do. And I appreciate the time you put into it. However, this is a historical building surrounded by historical buildings. Would you consider a batch plant to be a historical land use?
Not a new one, ma'am, no.
Thank you. Would you also?
The question, I guess, ma'am, would be, is it compatible with a historic use? And since, to my knowledge, the foundry has not been identified as a historical site
Yes, it
yet.
has.
The foundry itself, okay.
Yes, it has.
If there's anything out there that has been identified as a set aside, I didn't find it, saying that there were limitations on what you could do as far as heavy industrial zoning. I didn't find any of that.
There are several things, and that was why I questioned just how deep you did delve into it, but I'm good. Thank you.
Additional questions or comments from commission?
I have one more. I apologize. When you were discussing Newberry, Did I understand you to say that the one in Newberry, the newest one, that's in the subdivision by the recreation park, that it was not as close to the residences as this is?
That's correct, ma'am. Madam Mayor, the one in Newberry is approximately 900 feet from the closest residential. And when I did the aerial measurement using the county's Map Genius program, it looks like the closest here is somewhere between 400 and 500 feet.
Thank you, sir.
Anything further for Mr. Thomas?
No.
Nope. Thank you.
At this point in time, it's Mr. Flagg's turn. And yeah, it's your turn to do your case in chief. Before Mr. Flagg starts, because I know in his packet of things that he submitted, I believe was an online study. And as Ms. Boyce pointed out at the beginning of this, that is hearsay in a court of law. However, it would be my recommendation to you all, you accept it into the record and afford it the weight that it deserves. Evaluate it for competent and substantial evidence, but I wouldn't recommend excluding it from the record. Mr. Flagg, I apologize. You may not even intend to put that in there, but I did want to touch on it.
Well, we'll take that legal argument for what it is for the record. Thank you. Madam Mayor, may I begin?
Yes.
My name is Byron Flagg. I'm a land use and environmental attorney from Gainesville, Florida. I'm from Alachua County, grew up here. I represent Mr. Bill Lewandowski, who is over here in the blue suit, and he'll be up here soon to speak. It's an honor to represent him, to be up here with a fellow veteran. He's a retired lieutenant colonel from the U.S. Army, and he moved here to Archer with his wife Joyce in 2015. A lot of confusion has been created about what competent substantial evidence means and how you weigh it and how it plays a role in this hearing, and I'm going to address that. But let me introduce you and give you a quick overview of who's here tonight that's going to talk to you for Mr. Lewandowski's case, and then I want to explain that to you. If my PowerPoint can be brought up, please. No, that is not mine. Mine has my name on the front. Well, while that is what we're trying to find, it is a PowerPoint file named Flag Presentation Lewandowski, something like that.
Could be that one. I think that's the letter. Deanna, it was emailed to you at 4:35 p.m. this afternoon. I don't know if you have access to your email.
It's a PowerPoint presentation file. That's, for the record, how I was told to provide it to the city. Well, while we're waiting for this to come up, Bill and his wife Joyce, as I said, are residents of the city of Archer. Their property is their homesteaded residence, and the address is 17079 Southeast 138th Lane. It's actually approximately 460 yards away from the location of where this proposed concrete batch plant will be. It is in the neighborhood subdivision, which has many historic homes. just south of where the old Maddox Foundry property is. And in fact, if I can take a moment,
Sure.
I might be able to fix this problem.
Can you please?
Well, Ms. Deanna, I just emailed it to you again with all the same other documents that you have up there from me. I'm going to just go ahead and continue and hope we can get that PowerPoint up. If we can't, we'll figure it out. My client, Bill, is the Chief Operating Officer and Chair of the Board of Directors of the company called Information Visualization and Innovation Incorporated. It's a company that specializes in consulting and advising organizations and systems engineering and program management. And he's going to tell you a bit more about that. He actually is an expert in this field where he helps companies in both the medical and aviation industries with looking at their operations and how they come up with standard operating procedures for their activities and helping them sort of model or anticipate potential problems by researching their industry or their work and looking at data and then hypothesizing what types of issues they need to think about or plan for. That is his expertise. We have provided you an affidavit from Mr. Lewandowski, which includes his curriculum vitae, detailing his expertise and his experience. And there's my PowerPoint. Awesome, good job. Thank you, Deanna. But Mr. Lewandowski's expertise, he has relied on to analyze how this proposed conditional use permit application is going to affect his property, him and his wife's property. But he's also looking at it, how is it going to affect the community? And when he comes up here, he's going to talk about that. His affidavit is rather long and lengthy and detailed to make sure that his background is included. You don't have to read it. He's going to be able to read it and summarize it for you. If we can go to the next slide, Ms. Deanna. This is a map taken from the Alachua County Property Appraiser's Office. And at the bottom of this map, you can see that it is authenticated and competent substantial evidence as a map generated through the GIS mapping system of the Alachua County Property Appraiser's Office. That map gives you the time and date stamp as to when it was made. The property that Arnold Construction now owns, which is the old Maddox Foundry, is highlighted in red. And off to the left is a note explaining that. And there is a property to a small polygon to the south. That is the Lewandowski's property. And a note to the left explaining how close they are. That red line is made using it through a tool on the Alachua County Property Appraiser's website, their GIS mapping system, where you can actually measure the distance between points on the GIS map. And so that's what that map shows you. That line actually goes not to the middle of the Maddox Foundry property, but over toward the approximate location of where the site plan that you've reviewed or that you've seen tonight is where the concrete batch plant will be located. You also see that there are many other residential properties in close proximity to where the proposed concrete batch plant will be. The Lewandowski's home was actually built approximately 1890, and it is on the historic list with the State Florida Division of Historical Resources as a historic property. And that file number we have included in Mr. Lewandowski's affidavit. That is also competent substantial evidence, his affidavit, because that comes from his own personal knowledge. And furthermore, that his home was actually at one time served as town hall for the city of Archer, or city hall. You're also going to hear, he's going to talk to you more about that in greater detail. But you'll also hear from our expert real estate appraiser, Mr. Michael Hotaling, who's here tonight. He is with one of the managing partners of Moody Williams Appraisal Group based out of Jacksonville. He's come down here today and has gone around and looked at the properties and gotten an idea and a good background before we brought him down here today when we engaged him to analyze this. You're going to hear about his background and his expertise. He has more than 20 years of real estate valuation experience with extensive knowledge of a variety of commercial, industrial, residential, and special purpose properties. He does work across the Southeast United States, and he'll tell you more about his expertise. You're also going to hear from someone, another resident citizen of Archer. Her name is Miss Rhonda Roberson. She lives about half a mile towards the east of the old Maddox Foundry property, and she will tell you where her address is. And she's also provided an affidavit that has been submitted into the record. And what she's going to be talking about, she is not an expert in concrete batch plants. She is not an expert in a certain area. But what she has to share with you is competent substantial evidence. She's going to share with you her own life experience having worked at a concrete batch plant from 1979 to 1997. She had a career in that business. And she will tell you her own personal experiences, observations, and about what she lived through and what she knows about. And she'll also tell you about how she lived nearby that concrete batch plant. Now, you keep hearing me mention competent substantial evidence. We need to talk about that because I think some confusion has been made. I'm a former prosecutor. I've had many criminal trials and civil trials after I left the prosecutor's office here in Gainesville. Earlier, our city attorney described hearsay and defined it as an out-of-court statement made for the purpose of asserting the truth that it's made, and has suggested that hearsay is not admissible. That is not correct in the quasi-judicial hearing, nor is that correct even in Chapter 120 administrative hearings. Hearsay is in fact admissible. We are not in a court of law. We are in a city commission meeting that is designated by Florida law as a quasi-judicial hearing. It is like a courtroom, but it is not, because we're talking about the land use code, and we're talking about whether this conditional use permit should be approved or not, and we're talking about what are the criteria. So this is not a courtroom. All of this is appealable to a courtroom if the parties decide they want to do that. But competent substantial evidence, I'm going to give you a definition from the Florida Supreme Court, okay? That's the highest legal authority in the land. Competent substantial evidence is evidence that is relevant and material enough to support a conclusion that a reasonable person would accept. And that Florida Supreme Court case is DeGroot versus Sheffield, for the record. And so just that someone is not an expert witness doesn't mean what they say is not competent substantial evidence. So anybody who has personal knowledge, anybody who, I mean, Mr. Thomas just came up here and told you about the internet research that he has done. If you're going to rely on his testimony and comments where he made conclusions based on internet research that he has done, then you ought to be able to take the same for anybody else. And so there are types of documentation or reports that are generated by other people that may have relevance and that may have important information. Yes, it might be hearsay, technically, in a court of law, but remember, we're not in a court of law. And you can take that documentation or that report that comes from someplace else, and you can give it the due weight that it deserves. And also, I'm going to read to you from your land use code. Under procedures for these types of hearings, section 9.02, subparagraph 3. All findings and conclusions necessary to grant or deny the requested action shall be based upon reliable evidence. Doesn't have to be expert witness evidence or testimony. Your code, again, it says, all findings and conclusions necessary to grant or deny the requested action shall be based upon reliable evidence. That evidence, which would only be admissible in a court of law, should be preferred whenever possible, but in no case may contested findings be based solely on evidence that would not be admissible in a court of law, unless such evidence is not reasonably available, like a person who can't be here, and the evidence in question appears to be reliable, and the matter at issue is not seriously disputed. That's your code. That is not the Florida Supreme Court definition of competent substantial evidence. You have to still abide by that. But you've also given yourself, your prior commission has created another condition here in your land use code for how to analyze information that's coming before you. So if something is truly hearsay and you don't think it should be considered, you don't have to. So with that, I want to just move to the next slide if I could, Ms. Deanna. That was just a close-up of the map that I just showed you. And you can go to the next slide, Ms. Deanna. Thank you. Now, before we got tonight's meeting started, there was an issue about the professional services agreement that was entered into between Mr. Thomas and the city. And you all have chosen to follow your city attorney's legal advice to nunc-pro-tunc adopt that. In the process, the applicant stated that they would be willing to just adopt Mr. Brian Thomas's report and testimony as if it's their own. That's a new legal issue that is now generated. I've practiced law for 20 years in the state of Florida, many different types of forums. I also have an advanced law degree from the University of Florida in environmental and land use law, an LLM degree. So I have plenty of legal experience as well, just like Ms. Patrice Boyes. She has a fantastic reputation and she's a good attorney. And attorneys can disagree about how things should play out. But what you need to remember is that the reason we brought up that issue about Mr. Thomas's written agreement is because it was clearly, we felt so strongly that it was just clearly a blatant violation of the city's code, 2-2-85, where the city commission should be given an opportunity to review that contract first. And some of the questions that the commission has already asked and some of the issues that are already coming up, now we see why that's relevant. Certain aspects of your city's code and comprehensive plan need to be looked at and emphasized, such as the historic preservation policies. It's really important to this community. And that would have been the opportunity where you could make sure those kinds of things that are in your code and that are in your comprehensive plan are going to be looked at. If the zoning administrator duties are going to be delegated from the city manager to a private consultant, fine, but let's do it right. That's our issue. It's not about filibustering. It's about pointing out what your code says. And if we're going to do this, if we're going to end up, if this community is going to end up approving this concrete batch plant, then do it right. That's our point. So going to why we're here, the conditional use permit, you've already heard some interpretation and analysis about this part of your code. Section 7.01 is talking about a couple of things: certificates of appropriateness, zoning, and conditional use permits. But right here, it explains that it's unlawful for any kind of project that requires a conditional use permit to get going on construction until the city commission has issued a conditional use permit. That means we have lots of talk about, hey, this is an industrial zone property. There's many other types of industrial uses that could be here by right that don't need a conditional use permit. That's correct. But a concrete batch plant is not one of those. It has to go through this conditional use permit process. Your predecessor sitting before you on this commission adopted this land use code. They adopted it for a reason. I'm postulating, but I bet they knew that one day the industrial zone property at the Maddox property might be used for something else. And so for some reason, the prior commissions before you decided concrete batch plants or things that are manufacturing, putting things together on industrial property that are happening outside of a fully enclosed building, those kinds of activities, they need to be approved by a conditional use permit. City wants to have a chance to look at those more closely than just a by right type of use and make sure that we have conditions that are appropriate for it. So moving forward, if we can advance the slide, Ms. Deanna. Next slide, there we go. You can go ahead and skip to the next one. So this slide, this is the most important one of the whole part of the process. As you've heard, conditional use permit application for a concrete batch plant can be approved unless, and I have it highlighted here, unless it is found, and this is where you utilize your competent substantial evidence to make findings. If you find from the competent substantial evidence that's presented to you tonight, from Mr. Lewandowski, from our witnesses, but also from the applicant, you might decide that some of the competent substantial evidence that they provided gives you reason to make findings that A, B, C, D, E have either failed to be met or create problems or conflicts with your code. These A, B, C, D, these 5 criteria are the criteria that you use to figure out, do we have sufficient conditions if we're going to approve this to prevent these things from happening, or has the evidence that's been put before us show us that these things are going to be violated and that therefore need to be denied? There's a great amount of common sense incorporated into your conditional use permit process here. And this criteria is kind of broad too. It's not very specific. Your code is built this way, and it is a lawful code. It is built this way so that you have the opportunity to think hard about all the kinds of potential impacts that might come with this type of land use, and whether or not your code is being met, or whether or not you need special conditions on the conditional use permit. It's entirely within your powers under Florida statute as a local government, as a municipality, to enact zoning laws and regulate land uses like this. As long as you're not acting arbitrarily and capriciously, meaning you make factual findings to support your decision based on the competent substantial evidence, then you are completely acting within your right if you decide that there are findings that support denying this conditional use permit. You're absolutely within your legal right to do that. And it's important to note that the ultimate goal of your land use code, which is section 1.02, the goal of this land development code is to encourage and promote, in accordance with present and future needs, the aesthetic, safety, morals, health, order, convenience, prosperity, and general welfare of the citizens of the city. That's the overriding goal of your land development code. So going back to why Mr. Thomas's contract was done improperly. Why is this important and relevant now in this hearing right now? because there is a legal question that if the city violated its code for entering into professional contracts, is that contract void? And if it's void, then his entire testimony tonight and his report, which was given as a consultant from the city, it should not be considered if it's been disqualified, if it has been gained contrary to your code. And that is the legal issue that Mr. Lewandowski is prepared to appeal and see what the courts say about that. So for purposes of making a record on that issue, we formally object to what the city did in terms of approving that contract, nunc pro tunc, and moving forward with his testimony and with his report. We believe that fairness to the public and fairness to your fellow commissioners dictates that the commission should postpone this hearing, but we're past that point. So next slide, Ms. Deanna. So I want to walk through some of the things we found. Not all of the things, but some very important things in the interest of trying to be brief and trying to be efficient and looking at places that we found that create problems. So the conditional use permit application shall be filed with the zoning administrator. The conditional use permit shall be granted by the city commission unless it is found to fail to comply with this land development code. So if you look at the noise provisions of your code, not even in your land use code, but also your code of ordinances, there are noise regulations that still will apply to the activities on this property. And your noise code defines nighttime between 9 p.m. and 7 a.m., daytime defined between 7 a.m. and 9 p.m. If you look at the resolution that's before you that's proposed, condition number 4 of that resolution gives authority to this concrete batch plant to operate between the hours of 5 a.m. and 7 p.m. And that issue has not been brought up. Is this concrete batch plant willing to make sure that it's not operating loud machinery and making noises during nighttime hours and such that it would end up violating the noise code? That hasn't been addressed. That's a conflict with your code of ordinances. And similarly, the Kimley Horn noise study took a look at what they proposed and had significant concerns about that in the beginning. And they had to come back and provide more information. And I believe there was another report that was done where Kimley Horn decided in May of this year that most of those concerns that they originally had were alleviated. However, if you can go to the next slide, please. When you look at section 17 of your land development code, this includes performance standards and miscellaneous issues regarding all property, all types of zoning, different types of land that's zoned differently. In section 17.02, sub B, there is a special condition, a criteria that applies, that if the operation of whatever type of activity it is happening between the hours of sunset and sunrise on any day or at any time on Sunday, if any of these types of activities, pile driver, steam shovel, pneumatic hammer, dredge, or, and I've highlighted and bolded, an electric hoist or other appliance is left open for you all to decide the types of things that they're talking about doing, their competent substantial evidence, their types of activities could include other appliances that are going to make noise if outside the hours of sunset and sunrise. You need to safeguard the community to make sure that kind of thing is not happening. But that's a conflict with your land development code, with what they're proposing. And under section 17.02, the next section, the use of any motor vehicle in a manner as described here, creating noise at these same times. And we haven't heard too much competent substantial evidence about the type of noise that's going to be created in the hours of when the vehicles are going to be operating on this property. We've heard that Other cement trucks might be coming from other places to pick up, but the applicant is not in control of how those other vehicles are operating or maintained. If we could have the next slide, please. Again, more criteria, more performance standards in section 17 of the Land Development Code, 17.02 subparagraph K. The creation of any loud and ruckus noise heard within any school, public building, or church while it's in use, which interferes with the workings of such institution. We all know, we don't need substantial evidence to know that there is a church, an active church, abutting where this property is, where the concrete batch plant will be located. That church is already there. And that church, as you all know, I'm sure, has a daycare children's school. And that daycare school is operating and taking students, asking for students to attend, this week. So if there is noise occurring on this concrete batch plant to the degree that it can be heard within a school, a public building, or a church while it's happening, that's a conflict with your land use code, specifically the performance standards that are required from section 17. We haven't heard any competent substantial evidence about how they will not let that happen, how they will prevent that. If you could have the next slide, please. So, again, conditional use permit shall be granted by the city commission unless it is found to, and this is the second criteria, B, pose a danger to public health and safety. The competent substantial evidence that has been submitted to you by the applicant, you know what the type of activity is going to be going on this property. You're going to have heavy cement trucks. You're going to have heavy machinery. You're going to have employees constantly having to water down concrete aggregate material. All these things are going to be happening. You know what this is going to be like. And by their own admission, the nature of this kind of business can be dangerous. Maybe not just to employees, maybe they can take safeguards, but once a concrete truck leaves the property, whether it's a concrete truck that is their own or whether it is a customer coming to pick up cement, they can't be in control of that. So there is an increased risk of traffic safety in the center of Archer. There is a danger to the public health and safety. The next slide, please. Before we get into the property values, if we could back up one slide, Deanna, I'm sorry. And regarding the danger to public health and safety, you've heard a lot of comparisons about different locations. Residential projects can happen next to concrete batch plants. There's one in Newberry. There's one over here. There's one in downtown city of Gainesville, next to Depot Park. But those are different places. This is the city of Archer. And it's okay to compare just to try to get an idea. But if you really want to know about what kind of danger to the public health and safety is going to happen right here in the surrounding community next to this concrete batch plant, further studies should be done to find out and make sure that the dust that might be generated isn't going to create problems. And I want to point out to you a condition, a policy in your comprehensive plan that I haven't heard anything about tonight. It's and we'll get to it in a minute. And I've submitted some excerpts of the comprehensive plan into the record. But it's policy 1.9, which states that prevailing winds need to be studied. Prevailing winds need to be looked at in any kind of industrial use. And why is that important? Because different types of industrial uses might be emitting some kind of air particulate matter. They might be emitting odors. Wind is an important aspect of how is that going to affect surrounding community and the properties? That policy has not been discussed at all. It's policy I.1.9, criteria for permitting light industrial and heavy industrial development shall include but not be limited to, and it says climate, prevailing wind direction that does not impact adjacent residential areas should be looked at. So, and Mr. Lewandowski is going to speak more as an expert in his area regarding traffic. I'm going to have him come up here in a moment. But first, I want to have Ms. Rhonda Robertson come up and talk about her own experiences having worked at a concrete batch plant.
Good evening. I,
Good
Rhonda
evening.
Robertson, being duly sworn, states as follows. I am 72 years of age, am competent to testify, and the statements made herein are based upon my personal knowledge. I own residential property in the city of Archer, Florida, located at 16468 Southwest 132nd Avenue, Archer, Florida, 32618. This property is my primary homesteaded residence. The Alachua County Property Appraiser has assigned our parcel the following parcel ID number: 04796-000-000. I purchased the half-acre empty lot in 2014 and contracted with Steve Smith Builders in 2018 to build a site-built single-family home, which now sits upon that lot. My property is located about 1/2 mile east from the area. Thank you. I just couldn't do it. Okay. My property is located about 1/2 mile east from the area on the old Maddox Foundry property where the proposed concrete batch plant is proposed to be built. See attached Exhibit A, Robertson, Alachua County Property Appraiser Map. We purchased the lot in 2014 because I have family ties and fond memories of Archer, and eventually wanted to settle down in the area and retire in a small Florida town with unique history and small town character. I attended the City of Archer's Planning and Zoning Board meeting on July 18th, 2024, when the concrete batch plant conditional use permit application was heard at that meeting. And I spoke in opposition and spoke about my own personal experiences and observations when I worked at a concrete batch plant in Tampa from 1979 to 1997. Although it is entirely possible that the proposed concrete batch plant that is being proposed for the old Maddox Foundry property can operate safely and minimize its off-site impacts, based on my personal life experiences, I believe there is inevitably will be some off-site impacts affecting nearby residential properties and the health of people that will be in very close proximity. What I'm about to relate to you are my personal firsthand experiences having worked at a concrete batch plant. We can all Google the words cement and concrete and read for an hour on how detrimental they both are. I am very well acquainted with the health hazards of cement dust, and I use the word cement because that is the real threat. We all know the ingredients required to manufacture concrete: water, cement, sand, rock. I have a basic knowledge of the industry from working at a concrete plant in Tampa for 18 years. I see great strides have been made in the industry because it was really needed. I have seen the effects of cement poisoning on the arms and hands of the concrete drivers. The paint on my vehicle was eaten away when the cement silo was overfilled and cement filled the sky and settled everywhere. This happened more times than I care to remember. I had constant sinus and lung infections while working there. Okay. My best friend left before I did, and she is still living with the chronic bronchitis. I left on the advice of my doctors, and I'm still living with the respiratory issues and diminished hearing loss from the noise of concrete trucks being loaded off and on all day. Of course, Archer residents will not be in that close proximity of the actual product, but I fear that without safeguards and performance standards built into our land development code, we will all be breathing the dust particles given the location of the proposed batch plant. I sold my home in Tampa and used my life savings to build a house that I had hoped would be my forever home. But I'm pretty certain that will not be the case now if the concrete batch plant is built just across the highway from my house. I take care of my own yard, and I'm outside as much as I am inside. And I do not look forward to breathing concrete dust in my remaining years. Archer needs the kinds of businesses that will attract people, not drive them away. What Archer does not need is harmful, heavy industry within the city limits in residential neighborhoods. The concrete business is a loud and nasty business, and I believe you will come to regret your decision if you allow this batch plant to happen. Thank you.
Thank you.
Good evening. I'm Bill Lewandowski. I think you all know who I am. I would
Yes.
assume so by now.
We do.
So I am going to read from my affidavit. I will skip the parts where it says reference so-and-so. So you have the affidavit in front of you. There will be occasional times where I will deviate from the affidavit. I will tell you when that is, and that's just to offer an explanation. Because some of the terms and some of the industries I reference, you may not be familiar with. And I know my attorney's not going to be happy with this, but if I say something that you don't understand the terminology, please stop me. I'd rather just be clear. Okay, so let's go forward. So I know I don't look it, but I am 69 years of age. I am competent to testify, despite what some people may think in the city. And the statements made herein are based upon my personal knowledge. My wife Joyce and I own residential property here in the city of Florida. It's located at 17079 Southwest, not Southeast, but Southwest 138th Lane here in beautiful Archer. This property is our primary homestead residence. The Alachua County Property Appraiser has assigned a parcel number, and I won't read that. As my attorney said, my home was built in 1890. It was once the Literary Society Hall. It was acquired by the city in 1900. I believe it was a tax lien, so the city took it over for not payment of taxes. And it served the city hall and as a seasonal campground for the city of Archer for over 60 years. Our home is located, is listed in the Florida Division of Historical Master File Record. And by the way, there's some other properties close to me, like the Presbyterian Church, which I believe is on the National Register, not just the Florida. So there's other historic homes right in that area and buildings. Our property is located about 460 yards southeast from the area of the old Maddox property foundry. When the proposed concrete batch plant, is proposed to be built. We purchased our home in 2015 because we fell in love with the town of Archer. When I drove to Archer for the first time, I'm deviating now. I'm deviating, so say that. We looked forever on Zillow for a house. And then this one house kept on popping up. It'd been on Zillow forever. And Joyce and I drove out here with our Great Dane that we had at the time. And I looked inside that house and I completely fell in love with that house. And then we looked around Archer and I fell in love with Archer. See, the only way I can put it, I fell in love with this city and I never want to leave. I was on the agenda for, and I attended the City of Archer's commission meeting on July 9th, 2024, for the purpose of asking a moratorium on industrial projects so as to provide time to harmonize the city's land development code with its comprehensive plan. My concern was then that I had identified serious disconnects between Archer's land development code and comprehensive plan because the land development code had undergone significant changes in 2020 before the city had begun its legally required process of revising its comprehensive plan. You rejected that. I understand it. I walked away smiling. But we presented that. And I think you'll probably recall, those here on there, that I presented my concerns at the time you changed the ordinance back in 2020. So this is nothing new for me. And my position on this should not be new to anybody on the city commission or anybody who's ever attended any of these meetings. I attended the City of Archer's Planning and Zoning Board meeting on July 18th, 2024, when the concrete batch plant conditional use permit application occurred at that meeting. Not only did I speak in opposition to the proposed concrete batch plant at that time, but I also submitted a letter and spoke about a conflict of interest that one of the planning and zoning members had with that matter. And that member did in fact determine she had a conflict of interest over Florida statutes and ethical rules for appointed board members and abstained from voting. It's not enough to say that Joyce and I have significant concerns about what the offsite impacts from a proposed concrete batch plant may have upon our property and our neighborhood. Appalled is the more appropriate term for that. Use that because our fear was that a concrete batch plant will negatively affect our property and our community. As currently submitted, we believe the concrete batch plant application does not provide enough assurance that the plant will not negatively impact our property values and that its attempts to mitigate noise, intense dust, vibration, and increase heavy vehicular traffic are speculative at best. If this concrete batch plant is approved and their business expands, how will the city safeguard against an even more expansive concrete batch plant operation? Although we recognize that the property where the concrete batch plant is proposed has been zoned industrial for decades and has a history of use as an industrial property, a concrete batch plant has never operated on this property. We were not opposed to industrial activities located at the old Maddox Foundry property. Let me take a step back for a second from my thing. I asked Mr. Fletcher at a previous meeting whether or not the land around Maddox property was contaminated. And he can speak for himself on that, but he said no, and that they had done the environmental studies to prove it. I take Mr. Fletcher at his word for that. So when somebody says this is not a big deal, this is just like the Maddox Foundry, no, it's not. It just isn't. It's nowhere near like the Maddox Foundry. When we moved here in 2015, the only thing we occasionally heard was, I think it was the lunchtime work whistle. That was it. It was almost, there was really, unless you drove by it, you didn't know anything was going on. So that was the Maddox Foundry. That's different from what's being proposed. And I really think that we have not emphasized that enough. So we're not opposed to industrial activities located at the old Maddox Foundry property, and we wholly recognize the city's need for economic development. But we are absolutely opposed to any type of heavy industrial activity being approved without the proper safeguards and conditions that the City Commission is lawfully permitted to approve through its conditional use permit process. Now, I reviewed the entire application, engineering and site plan submitted by the concrete batch plant applicant that has been submitted to the city. I've researched and educated myself on how concrete batch plants in Florida are operated and regulated. And furthermore, I have thoroughly reviewed, analyzed, and studied the City of Archer's comprehensive plan and land development code. I retained land use and environmental attorney Brian Flagg, Esquire, to assist me in analyzing and understanding the application of the city's comprehensive plan and land use development code as it relates to the applicant's proposal. I'm going to skip section 7.02. We've talked about that. Those are the criteria, so I'm going to skip past that. I'm not a professional engineer, and I do not consider myself an expert in concrete batch plants. I am an expert in researching, analyzing, and developing training and simulation programs for the U.S. Department of Defense, the North Atlantic Treaty Organization, medical industry, and the aviation industry for the purpose of making systems efficient and safe. So what does that mean? I've looked at pilots flying the most advanced aircraft and why they were flying them flying those perfectly good airplanes with the highest computer-assisted devices into the sides of mountains. I've watched surgeons and looked at what they have done to determine why they're killing people. There's so many different types of things that I have researched, and a lot of it kind of boils down to the same thing. It's the human, the activity, and the context of what's going on. You can really kind of put it in that little circle. The other thing that there is a systems approach. You have to view things in terms of a systems. Things happen. In a concrete batch plant, there's processes, but there's also a system outside of that. There's the weather. There's all the other things that impact that. And so you have to view things from a systems perspective. My training, my education, my experience is looking at different industries and doing that. I can't fly an airplane. I've never done a colonoscopy, but I have trained people to fly an airplane, and I've trained physicians on to do colonoscopies, as well as many other medical procedures. And NATO, Department of Defense, I've done those types of things. I'm currently the Chief Operating Officer and Chair of the Board of Directors of a Florida-based company called Information, Visualization, and Innovation, IVIR. Our company specializes in consulting and advising organizations in the areas of systems engineering and program management, product development, and educational engineering and training assessment programs. Prior to working at IVIR, I served as Vice President of Surgical Products and Business Development for a major international medical and surgical simulation company where we supported industry and government training requirements. Step back. I love business. I love industry. I will be the last one who will ever say that I am not a capitalist. I am. I want to see growth. But just like you just can't look at revenue and say a company's healthy, you have to look at profit. So you have to take things in perspective. I also worked in the aviation simulation industry where I managed an airline flight simulation center and curriculum development division. In total, my consulting career includes 3.5 decades or 35 years of professional consulting in the defense field, medical simulation industry, and in the aviation simulation industry, advising companies and organizations how to be more productive and safer with their processes and systems. My expertise in these fields is largely thanks to my career in the U.S. Army. You see me come in front of you guys all the time. You see me volunteer. I'm out there because, sorry. I'm grateful. The people of the United States gave me an education, gave me a career, and I give back. Sorry. I'm retired U.S. Army Lieutenant Colonel. Doesn't look like it now, but I am. I have a bachelor's degree in history from Rider University in Lawrenceville, New Jersey, a master's of science degree in instructional and performance technology from Boise State University, and I conducted postgraduate research at the University of Liverpool in the United Kingdom. I have several military degrees related to armored combat operations, senior staff operations, planning and leadership that I earned during my 27 years in the U.S. Army and U.S. Army Reserves. Part of that requires things like learning how to do tactical road marches. How do you take units stationed in Germany and move them quickly on the German autobahns to be able to deploy to the German border? So I understand this stuff. No, it's not the same as doing a traffic study on the corner of Archer, but the principles are the same. During the tail end of my Army career, when we were living in West Virginia, I served in a public appointed office as president and member of the Jefferson County Planning Commission for 3 years. In my role as president of the Planning Commission, I presided over and voted on planning and zoning matters involving land use, development, property rights, economic growth and development, and the integration of commercial, industrial, and agricultural activities under the city's codes of ordinances, state and federal law. As a result of my experience, I am very familiar with land use and zoning issues and quasi-judicial hearings that affect property rights. It's my firm belief, based on my experience described above, and based on my attorney's advice and guidance, that the draft resolution fails to recognize critical policies contained in the city's comprehensive plan that require the city to adopt performance standards for industrial zone properties and land uses that are necessary to safeguard residential properties abutting and in close proximity to the concrete batch plan. As presented in the proposed concrete batch plan application, there is a significant risk of air pollution from plant operations as a result of accident, equipment failure, or employee error. This would probably have an egregious negative effect on those with pre-existing medical conditions and would be exacerbated by the dust from local dirt roads. In addition to that, in the springtime, we see our cars covered in yellow dust of pollen. That gets added. This is all part of a cumulative effect. No mechanisms have been described to immediately detect the errant release of particulate matter that can be caused by concrete batch plant operations when they occur, nor have effective means of remediation been described. People make mistakes, equipment breaks down. You just pick up the paper and you can see when those types of things happen. Okay? So where's the plan to prevent those things happening? You can't be 100% sure, but where's the plan to even identify that? Where's the plan to let us know when there is an errant release? It's not there, at least not that I've seen. The current road network is inadequate for the proposed project. As stated in the March 7, 2024 concurrency management assessment from the City of Archer Planning and Zoning Board, I quote, "The road network serving the site not anticipated to meet or exceed the level of service standard required for traffic circulation facilities as provided in the comprehensive plan after adding the projected number of trips associated with the proposed development." That's not me saying that. That's not my assessment. That is the engineers you paid for saying that. So that's not Bill Lewandowski. That's the guys you paid for. My review of the 2023 traffic data from the Florida Department of Transportation online data website called Florida Traffic Online indicates, and again, this is not something I'm creating. This is something the state of Florida, your taxpayer dollars pays to have this information available. So it indicates that just a segment of Archer Road in front of the proposed site, and it's measured from, and I'll show this a little bit later, it's measured from the entrance to the landfill site and then to the beginning of the intersection. Okay, so that little spot there has an average of 9,000 daily trips of all types of vehicles. 9,000 average daily. And I'll explain how that number comes out later. 783 of those consist of commercial vehicles of class 4 and higher. The average of 9,000 daily trips represents an increase of 18.42% from 2020. In my opinion, the ever-increasing traffic will result in an increase in air pollution and noise, particularly from the trucks and buses, as well as increasing risk of fatal accidents. You heard from the consultant you all hired that when they had issues with noise, it wasn't inside the factory. From what he was saying, it's happening outside the factory. And that's going to happen here too. You can put all types of barriers around it, but those trucks have to exit. The U.S. Department of Transportation reports that 46% of total highway fatalities involving trucks, these are class 4 or higher, occur on rural roads, twice that of urban roads. You know, folks, I can state the statistics all I want. If one person dies here because we've allowed this dramatic increase of traffic, it's one person too many in my book. It's not worth it. I also believe the applicant has failed to demonstrate that the proposed plant will not adversely impact property values. We'll address that later, so I'll let the expert handle that. I'm not going to read the rest of this because you already have this. You understand my objections to it. What I'd like to do now is to go into the details on traffic. So Deanna, wherever you're hiding, I had that PDF I sent you. Yeah, the one you had up earlier, yes. So let's look at that. Okay, that's it. Next slide, please. You can just, you just scroll. That's it. Yeah, a little bit up, a little bit more, a little bit more, a little more, a little more, a little bit higher. That's it. Okay, so I just want to point out, this is from the report I mentioned. This is one that was shown to the Planning Commission. It was in the agendas you guys published, so this is not something I created. I did add the yellow. And there's where that quote came from. As you can see, go back. Okay. Actually, you can just, yeah, that's you can just leave right there for now. That's good. So as you can see, your engineers have said that the road network is not going to be adequate after this plan is built. Go up a little bit higher. I'm sorry, the other way, go down. Sorry. A little bit more. Okay, so the next few slides I'm going to show are going to be from the Florida Department of Transportation website. So without any interpretation from me, and we're going to go over those in more detail. Next, go down a little bit, please. Okay, so here's some notes on this. I have references at the end, but the information on the traffic itself is coming from that Florida Department of Transportation website. Data is from 2023. Okay, you see this term AADT, annual average daily traffic. That's how the Department of Transportation calculates it. So they have a device out there that's measuring the road, that's measuring traffic. It has sensors to determine how many axles are going over it. And that is the average traffic. So one day there may not be anybody, but some day there may be a lot of folks. Passenger vehicles are motorcycles, cars, pickups, and trucks/vans. It's class 01 to 03. Class 4 through 13 is everything else. Concrete trucks are usually class 6, 7, or 8, depends upon which one you have. So there's different ones. Dump trucks are usually can be anywhere 6, 7, or 8, generally speaking. Okay, go up or down rather. So this is the segment from our intersection going back towards Gainesville. I think it goes as far as 91st Street, maybe. I don't recall what the end point is, but so you can see here that the annual average daily traffic is 13,000 trips. 13,000 trips. And 1,131 trucks are going up and down that trips. So anybody who goes in or out of Gainesville, especially during rush hour, you know what this means. You've seen this. Okay, a little more, please. Oh, go back down a little bit, up again for a second. The other way, yeah. I want to show that one slide. A little bit more, a little bit more. Good. Stop. It's a 13.04% increase from 2020 to 2023. That's no surprise to anybody with all the development going around us. Okay, go down. Okay, next one. So this is good. So this is that intersection. This is actually measured from where the road intersects. You know, they have 170 goes up, and people deviate and go to past City Hall, that truck route up by the Mustang. So that includes this. So that includes that angle going in, and it also includes traffic going up from the Levy County line up to where 170 goes off. So that's what this measures. 12,100 all vehicle trips. The truck traffic is 756, 126% increase from 2020. Okay, next one. And I mentioned this a little bit before. So this is the one directly in front of the proposed plan. As you can see, it's 9,000 vehicle trips and 783 trucks. Average daily trips. Okay, next one. So this is the segment again. Here's an aerial view of right in front of it, where you see it's on the left-hand side, sort of that cloud thing. It says truck traffic volume information. That's approximately where the measuring device was placed by the Florida Department of Transportation. That's where they actually had the monitoring station. Okay, down. So this is a little more detailed data. As you can see, where I've highlighted 6, 7, and 8, you can see the breakdown for the types of trucks that are currently going up and down that road. This is data that's automated data taken from them. Okay, next one. So this is from the original CUP application. in which the applicant says that he's going to have front loader, 2 to 3 concrete trucks, and unknown number of material delivery trucks. I'm assuming that they're going to be dump trucks. There could be other types of vehicles, but that's my assumption. So 10-hour day, 2 to 3 concrete trucks per hour. That's 40 to 60 extra truck trips in addition to the 581 average daily trips of class 6, 7, and 8. It's a lot of trucks. Okay. So a little bit further down where it says, although U.S. government research shows a much higher impact, the truck industry research shows, and this is from the trucking industry, it shows that a class 6 to 8 truck can have the same impact on the road surface as between 285 or 343 cars, depending upon the vehicle, road conditions, and construction. The feds had something that said something like 9,000. So I took the most conservative figure I could find, and that came from the trucking industry. Those references are at the end. So not only do you have issues with congestion and all of that, you're breaking down the road surface even more. And if you've driven down, it's one of the reasons why they're resurfacing 170th. Okay, down. Additional considerations, air pollution. I don't think there is an educated person or even uneducated person in the United States who doesn't think that vehicles cause air pollution. The more vehicles you have, the more trucks you have, the higher the air pollution. Studies show that there can be up to 4, 3, and 2-fold increases in different types of emissions. When you have congestion and you have slower vehicles going through town, so you have that buildup, you have more congestion, you have more air pollution, and of course, especially when it comes from diesel engines. I'm skimming over some of the scientific words. If you want me to go into the details of that, I can, but I'm skimming over that. I didn't think you wanted that. Okay. Studies also show that congestion can pose risk to commuters. Duh. Who doesn't know that? Next slide. Truck and safety issues from the U.S. Department of Transportation. 69% of highway lane miles are 69% of highway lane miles in rural areas. Nearly half of all truck vehicle miles occur on rural roads. That's a lot. The result is a disproportionate high rate of highway fatalities in rural areas. It's kind of logical, but that would happen. We want to put more on the road for here. So serious accidents involving dump trucks and ready-mix concrete delivery trucks continue to edge up, part of a persistent multi-industry problem. The industry knows this is an issue, and it's all the same type of things that cause any other type of vehicle accident. Poor driving habits, poor maintenance, all those different types of things combine in. So I am not saying, and I want to be clear, that Mr. Arnold is going to have bad trucks or that he's going to hire poor drivers. I'm not saying that, but it happens. And we all know it happens, regardless of who's doing it. But who pays the price? Person being run over, like that picture, which is from Brevard County just earlier this year. That's who pays the price. And it's too late once that happens. Okay, next one. Here's my conclusions. The planning staff's own analysis in regards to traffic shows this proposed project is incompatible with the comprehensive plan. As I recall, that road's not going to get, the Archer Road's not going to get better to what, 2040 is what I heard. Maybe you heard something different, but I think that's what I heard at the city commission meeting. The recent data that I've showed from the Florida Department of Transportation validates this. Any one of you can go online and see the same thing I just saw. The ever-increasing traffic load results in congestion that poses a serious risk to health. The increasing number of trucks in our roads increases the potential for serious accidents. We know our current traffic situation is driven by development and growth patterns outside of our control. We know that. Why would we deliberately make a bad situation worse? Why would we ever do that? So based on our current traffic situation alone, just considering that and nothing else, the adverse impact the proposed batch plant would have, I believe you have the legal and ethical responsibility to deny this proposed CUP. That's my opinion. Okay, so now I'm going to, with your forbearance, I'm going to briefly go over some pollution information. Now, I provided this to the planning commission, and, I heard what the attorney saying is that,
Can we just take a break if anybody needs a break real quick?
oh, yeah.
Madam Mayor, as a point of record, I make a motion to extend this meeting for the commission 1 hour. It's 10 o'clock.
All right, we have a motion.
I will second.
All right, we have a second.
Public comment on the motion?
Uh, uh, Commissioner comment first on the motion. None? Public comment on the motion, you have 3 minutes for that.
This is by charter, to
I'm
extend this
fine.
meeting.
I'm fine with the motion. I'd like the witness to finish his testimony before we break.
We're in the middle of a motion, Madam Mayor. Hold on.
All right, no public comment on the motion?
The motion is just to extend the meeting.
Right.
Just to extend the meeting, we have a stop time in our charter
It's-
of 10 o'clock, and
It's
so,
by charter, Mr. Arnold,
Yeah.
on the
right, so
meeting, to extend the meeting.
we just want to extend the meeting an hour.
So we can
Otherwise,
finish.
we should technically adjourn at 10.
I hope not also, but
Yeah.
you look at the agenda, we'll be here an hour.
Mm-hmm. All right, so let's go to a vote. All in favor of the motion signify by saying aye.
Aye.
Opposed likewise. Motion carries 5-0. Thank you.
So as I was listening to, as you were going through the questions about asking about conflict of interest and those types of things, I was a little surprised because I thought I heard somebody say that you're not supposed to take into account what happened at the planning commission meeting. I don't understand that because you have the planning commission review this stuff. They vote on it to make a recommendation. But I thought I heard you say, Ms. Attorney, that they're supposed to ignore it.
May I
Yeah,
answer your
please, yeah,
question?
yeah.
I'm saying that they're not supposed to rely on the evidence that was presented at the Planning and Zoning Commission. They're supposed to rely on the evidence that was
Okay, fair
presented
enough.
tonight.
Okay, fair enough.
The recommendation, I take yes, but the testimony, no.
So what I'm going to do now then is one of the things that I presented at that meeting, and you also have copies of it, is a peer-reviewed study. So a peer-reviewed study means that there are experts who wrote the study. These are all PhDs with references, and there's a certain formula they use to write these things. And then they send it to peers, folks who are other experts, to tear it apart, to see if this makes sense, and then it's published. So this is a peer-reviewed study that I submitted. It's called Polluting Under the Radar, Emissions, Inequality, and Concrete Batch Plants in Houston. It was published in Environmental Science Technology in 2023. Okay. So before I get into that study, just some general comments about what we're speaking about. So particulate matter, consisting primarily of cement and dust, but also including some aggregate, other types of emissions, that's the primary pollutant of concern. In addition, there are emissions of metals that are sometimes associated with this particulate matter. The typical sources are the transfer of cement and the postland material to the silos, from the silos. Other sources include the transfer of sand and aggregate, truck loading, mixed loading, vehicle traffic, and wind erosion from sand in the aggregate storage piles. The amount of emissions generated during the transfer of sand and aggregate depends primarily on surface moisture content, which is why they try to water them down, and all the other types of things that are going on in the environment. So it can vary from place to place, time to time. But when we talk about particulate matter pollution, that's kind of what we're talking about. Mostly dust and particles. There's other chemicals involved too, but that's really the primary concern. So this particulate matter can travel hundreds or thousands of miles from its source, depending upon the particles and the weather condition. It just sort of depends. So some of these can go from 100 yards to 30 miles. And the ones that are microscopic, they can travel for thousands of miles. It just sort of depends upon the situation. So when you start talking about these micron filters they're going to have, the micron filters are great, and they claim they're going to have 99% of covering all of that, but there's all these other sources that go around that you have to worry about. Of course, there's always a question of what happens if there's a mistake. So let's go into the study. This is the findings. Small industrial sources collectively release large amounts of pollution, including particulate matter, that contribute to air quality problems in the United States and elsewhere. Studies have estimated that in the U.S., excessive deaths attributed to particulate matter are over 100,000 annually. Moreover, exposure to particulate matter and other air pollutants is not evenly distributed across the population and often disproportionately affecting persons of color and those experiencing poverty. Operating largely under the radar are small industrial sources of primary particulate matter pollution. These facilities are typically managed under a general as opposed to a facility-specific permits that require comparatively less documentation and undergo less rigorous regulatory review. So let's look at the state of Florida. This is from the Administrative Code, Section 62-296-414, concrete batch plant emissions, frequency of testing. The owner or operator of any concrete batching plant using an air general permit shall have a visible emissions test conducted for stacked emissions referenced in the subsection no later than 60 days after commencing initial operations and annually thereafter. They're only checking this thing once a year after they first operate. That's the law. That's the law. So existing research has demonstrated that small industrial emission sources can diminish nearby air quality and increase adverse health risks. These things are cumulative with all the other stuff that's going on. So you can make a claim that your plant's not going to have a lot of pollution, but it all adds up, and it adds up in your lungs. Concrete batch plants as pollution sources are important for several reasons. First, although individual plants emit modest amounts of particulate matter, at least compared to sources like power plants as an industrial category, their aggregate emissions are quite substantial. Second, concrete batch plants can be located in the proximity of population centers, particularly in places without stringent zoning and setback requirements. And third, concrete batch plants are regulated primarily at the local or state level, where decision-making is often less transparent. Another thing they said, we show that concrete batch plants in Houston, and I'll compare and contrast Houston here a little bit. Concrete batch plants in Houston are disproportionately based in census tracts with more low-income Hispanic and Black populations, thereby raising important environmental justice questions about the siting and permitting process. In the concluding section of the paper, we discuss the implications of these findings and argue for the need for more air quality monitoring and emissions reporting from concrete batch plants and other small sources of particulate matter. In addition, we argue that regulatory agencies should consider not only by facility emissions, but also the cumulative environmental and health impacts of minor sources of pollution as part of the permitting process. None of that is done. None of it. None of it. And finally, discriminatory siting closer to marginalized communities can be a result of several factors. Regulators might choose to site the noxious facilities near these communities, responding to pressure from citizen groups with their political power to influence those decisions. Owners might choose to locate near marginalized communities, anticipating less opposition during the permitting process. Have you ever heard a developer come up and threaten to sue you because you weren't going to approve something? Has that ever happened in the city commission? That's what they're talking about. We have several of these now. So you've got High Springs, Gainesville Ready Mix. You have Esseron Plant number 10, Esseron Plant number 109, Silverback Concrete, Newberry, the Hawthorne Plant, Gainesville South Ready Mix Plant, North Gainesville Ready Mix Plant, and the Lindsay Peak Precast Incorporated. These are the plants in our area. All of these, some may be large pollutants, some may be minor. They're combining with everything else. Why would we want to increase that? So subject to your questions, that's all I have. Yes, ma'am. Okay.
Did you want to take a recess or did you want to keep going?
Madam Mayor?
She stepped out to use the restroom.
Okay.
Is she? Where? Oh,
This point of order, we have one more brief witness, and then I have my final comments, and then we'll be done, if we want to take a break.
You really want to take a break? Okay. If it's the will of the commission to take a break, we'll take a break.
Your motion, take for 10 minutes for the citizens.
Second.
Any public comment on the motion? Okay.
All in favor of the motion,
Aye.
We're taking a recess at 10:02. We'll resume at 10:12.
I don't know if it's on that.
I'm right.
All right, that was our 10-minute break. Let's reel it back in, please. Thank you.
Madam Mayor, can we go back on record? Ms.
Please.
Court reporter. Um,
All right, we're ready to begin, please. Thank you.
All right. Thank you very much, Commission, for your indulgence. It's important for citizens to make sure they're heard and exercise their due process rights. The other prong of one of the criteria for conditional use permits approvals is analyzing whether or not the proposed use would have a negative impact on surrounding property values. And we have an expert witness, Mr. Michael Hotelling, who's going to speak to his observations and opinions regarding that issue. And after he's done, I'll have my closing comments and we'll be done.
Good evening. I know it's
Good
been a
evening.
long night. My name is Michael Hotelling. I am also an MAI designated appraiser for the Appraisal Institute. I've been doing this about 20 years. I'm the managing partner of Moody Williams Appraisal Group in Jacksonville. Pretty much all I do is adverse studies and testify in court. The idea that any use does not have an effect on the surrounding property is just basic logic. Sometimes it's positive, sometimes it's negative, but typically industrial uses, as the planner has already indicated, tend to have more negative uses. His data that he talked about said that existing uses don't necessarily have it, only when a new use is brought in. And that's exactly what's happening here. So types of uses that I've studied, spill sites, railroads, landfills, power lines, power transfer stations, water treatment plants, any kind of public uses such as fire stations next to houses, jails, police stations. All of these are uses that are not typically considered within the normal land use code. And by that, I mean most land use codes are designed to be transitional in nature. Rarely do you see a heavy industrial use surrounded by residential. Typically, it's heavy industrial, light industrial, maybe some commercial, office, retail, and then some form of residential. They stagger those uses so they become increasingly less intensive. Some of these adverse effects can range anywhere from 8 or 10% negative value all the way up to 85%. I'm not an engineer. I'm not an attorney. I'm not going to sit there and argue how many microns affect whatever. I'm not going to talk about how the impact of traffic is going to affect this particular subject based off of how many trucks. I can tell you that the more traffic, the more of an impact. I'm not going to sit there and argue the civil procedure. I am going to sit there and say that no matter what use you put on that property, there's going to be an impact on value. I kind of want to speak to the appraiser that had done the study before, which is already on the record. he sat there and said that matched pairs are the standard tool for measuring those differences. And he's right. Ideally, you're going to find two sales that have similar properties, but with only one characteristic difference. And then you measure that difference. One sale isn't enough. It's not statistically relevant. You have to do more than just one sale. When he was analyzing the Newberry property, he provided only one matched pair of analysis. However, they were within the same subdivision. It wasn't like he did one that was right next door and one that was a quarter mile away or a half a mile away. They were in the same subdivision and directly across the street from it. So does it really matter if one happens to be one block closer than the other one? I don't think that that's statistically relevant. Same thing in Jacksonville. He did two problems that were within the exact same subdivision, actually discounted his own testimony, saying that he didn't think that that was statistically relevant because the one that was closer also backed up to a thick landscape buffer, which he thought was actually beneficial. I thought that was interesting. And those were the only two that he did. He quoted three more developments, one in West DeLand, provided no paired sales. His idea was that because median income and median house prices were higher within a quarter mile of the plant versus outside of that ring, that all of a sudden meant that it had no adverse impact. The problem is median house values are going to be higher statistically when you have a higher median income. And those developments that were within close proximity were in close proximity to downtown DeLand, which I've lived, University of Stetson, and several newer developments that were around there, as opposed to the ones outside, which were in the core center of town, where there's not as much residential, and farmland out to the west. So he's not really giving it a good basis for analysis. Same thing in Palatka. No paired sales, based it all off of census data. Ocala, again, same thing, stated that demographics made it difficult to compare and then makes no attempt except for the median income and home prices. Overall, I don't think that his analysis is compelling one way or the other. He may be perfectly right that there's no analysis, but he hasn't shown that. And I haven't done an analysis either. I do this day in and day out. Nobody has asked me to say, appraise this property as if the plant is there or appraise this property as if it's not. But I do testify often on what sorts of conditions have negative effects on properties. And industrial properties as a whole are generally that way. Adverse conditions can include traffic, plus or minus. There's no study been provided, except for the anecdotal data that he came up with. Lighting. Light pollution is a real thing. We've done measured studies in the past, and as far as I know, no study has been provided. If the property is supposed to open up at 5 o'clock, that's well before sunrise. And, you know, I don't know that these lights with the hoods are going to shine in somebody's house, but I don't know that they're not either. Noise pollution. We actually have seen a study on that. And Kimley Horn has supposedly provided some paper saying that they think that it might work and they're willing to come back afterwards if it doesn't work. The berm is the only remedy that was considered by Mr. Kirkland's report. Flooding. Apparently there has been some retention discussion. Availability of utilities. I know that that's been discussed. Interestingly enough, the planner mentioned in the planning ceremony or in the planning hearing that one truck contains about 200 gallons of water, plus a reserve tank of, I think I remember, about 150. And so he guessed that on average, each truck would use somewhere between 200 and 300 gallons of water. And that was the equivalent of 5 seats in a restaurant. Okay, well, let's do some math. If you sit there and you take the hours that they're open and an average of 2 to 3 trucks an hour, call it 2.5, times those hours that it's open, and then multiply that times 250 gallons of water, what you end up with is a restaurant that contains about 112 seats, or about 10% of the total population of this area. Pretty big restaurant, every day. So the impact from these adverse conditions, it's really just a logical argument. And the other thing is, just because an industrial property has been there for 100 years and had all the uses contained within the property, doesn't necessarily mean that a paradigm shift can occur. Newspapers used to be real popular. Not a lot of them around anymore. Internet has changed the world. Cars have changed the world. When that place was built, weren't a lot of cars around. Why are those houses close? Because a lot of people had to walk to work. Cars don't make that necessary any longer. He's going to employ, I'm trying to remember, 15 to 25 people. There's a lot of ways that you can employ up to 25 people in a town without putting in a use like that in a neighborhood. If it weren't an existing industrial property, would anybody consider it? If somebody sat there and said, hey, look, I got this piece of open rural zoned property out here that just happens to be an infill area in this residential neighborhood, can I put a batch plant, concrete plant in here? I doubt anybody would consider it. Overall, it's just it's such a logical argument. This is going to have an adverse impact that I really don't know why we're even having the discussion. It's going to. Is what is measurable? It's hard to say. And who does that matter to? People buy homes for different reasons. The market's imperfect, and so maybe a home value would go down 5 or 10% for one person, but somebody else would pay 20% less than that because the industrial property is there. You don't know. But statistically speaking, it's going to happen. That's it. I'm done. Thank you.
Thank you.
Madam Mayor, I don't need to go back to my PowerPoint. There's two other criteria under the conditional use permit code, section 7.06, and that 7.06 D is the question about whether or not the proposed use would be substantially out of character with the existing neighborhood. I'm not going to waste your time arguing about how it would be. I am willing to wager that you all, being the commission members, know the community way better than me, and whether or not this would be considered substantially out of character. One thing that we have heard is that what is being proposed to try to mitigate the noise is a large dirt berm around the perimeter of the property with a high fence built on top of it. That is a visual difference that doesn't exist there. I do have a question that I will ask when I'm able to about whether or not that kind of new visual aspect of this use will prevent a view from the roadways to the old Maddox boundary property. The last point in 7.06 conditional use permits that you're required to consider is whether or not the proposed use will be, thanks, Ms. Deanna. If you can scroll down 2 more slides. The last is a couple more slides. The last prong is to determine whether or not the proposed use is contrary to your comprehensive plan. The next one. That's it, conflict with your comprehensive plan. And if you go to the next slide. In my PowerPoint, which is available to you all, I've pulled out excerpts from the comprehensive plan that talk about what your policies are regarding industrial properties. And one thing that I want to keep going back to is that one condition or that one policy in your comprehensive plan, policy I.1.9, criteria for permitting light industrial and heavy industrial development shall include, but are not limited to, considering the climate, meaning the prevailing wind direction, and whether or not that impacts the adjacent residential area. That's a part of your comprehensive plan that hasn't been considered. And furthermore, there's a portion of your comprehensive plan, Ms. Deanna, if you could go down the next 2 slides. The next one. And next one. Next one, last one. This is the last one. I want to point you out to. The city shall develop performance standards for light industrial and heavy industrial uses in order to address the following, all of these bullet points. That's policy I.14. This part of your comprehensive plan, I am not confident that the city of Archer has actually complied with this part of the comprehensive plan and adopted performance standards. There is a section 17 of your land use code that talks about performance standards in general for all properties, and some of those do apply to industrial. And there's also another section in your code that has a couple of development and design criteria for industrial properties. But this part of your comprehensive plan does not seem to ever have been considered fully by the commission or the city at any point in time, and then actually have these criteria developed to the point they're adopted into your land use code. And if we are talking about a project that doesn't take into consideration these kinds of policies, that's a conflict in your comprehensive plan that exists. And that's something, it's another reason why we believe that even if you're not going to vote down this proposed use, that this hearing should be continued until the city is able to actually look at this part of the comprehensive plan and determine whether or not this is something that needs to be resolved. Thank you.
Thank you. Mr. Flag, does that conclude your? Thank you. We're to the part of this evening where we're going to move on to public comment. As a reminder, if you raise your, we're going to do cross at the end after public comment. Nope, you're good. As a reminder, earlier, if you raised your hand and swore yourself in, you're welcome to testify. If you haven't, if you didn't, and you've changed your mind since then, just please let us know when you approach the podium. I'm happy to swear you in at that point in time. Please keep your comments limited to 5 minutes. Obviously, there's a lot of you and we want to hear from all of you. So just make sure you're operating within that time frame, please.
Nobody's going to say anything. Hi, good evening, Madam Mayor. My name is Pat Berry, and I've known Ronnie Arnold here. I've known his sons through school, but, I'm a resident of Alachua County my whole life. Anyway, I've been in the construction industry and happened to be in the ready mix particular industry, and I've started talking to Mr. Arnold as he wants to put up a ready mix plant. I wanted to do that myself. I talked to Miss Maddox maybe 8 years ago about doing the same thing, but my wife wasn't going to work out with me. That wasn't going to work out for me. So, but I've constructed approximately 65 ready-mix plants in the state of Florida over the last 20 years. Dozen block plants, precast plants, rail yards, drop pits. I've been all through it. And only thing I do know, I've heard all the testimony and I've heard all the concerns, and there's a lot of there's some good information here that there's a lot of research has been done. At the end of the day, of all the projects that I've been involved with and all the clients that I've worked with in the state of Florida, there's only one place that Mr. Arnold's allowed to put up a ready mix plant, and that's on heavy industrial property. That's the property that's proposed here. So he can't go anywhere else otherwise. The other part is He's heavily regulated by the FDEP. I didn't hear any of that mentioned other than saying that it's regulated. So the Florida Department of Environmental Protection is the strongest jurisdiction in the state of Florida. They can put you out of business just as quick as they can drive up on your property. He has to comply, he has to get a permit, and they will regulate his operations with emittance, with stormwater runoff and everything. As the lady testified, she had worked in a facility and she got out in 1996, 97. In 96, they came up with a generic operating permit. That put everything into the DEP's hands instead of having a land use permit, which was stormwater, and then an air operating permit. Now it's a generic operating permit. Anyway, Mr. Arnold has also looked at, I've talked to him briefly, and I know he's purchased a brand, or is in the process of looking at a brand new piece of equipment. It's the state of the art. I've put up a lot of junk over the years as these clients drum this stuff up and want us to reuse them and remove them. He's putting up a brand new plant. It's got state of the art technology with dust collectors, with all of the bells and whistles that you would get if you went out and bought you a brand new 3,500 pickup truck today. You get everything on it. He's got it. I mean, so you get the state of the art. He's volunteered to, put up a berm and two acoustical sound barriers. I very rarely have seen that. Most clients, they don't have to do it because they're not required to do it under industrial use. But Mr. Arnold's proposed to do that. I think that's just a icing on the cake. Now, he's just trying to work with the community. As far as other truck traffics and stuff that's being added, if you bought a concrete right now in Archer, and it came from north side of Gainesville, it's on the road for 45 minutes getting here. I mean, you still got the same pollution that truck, if you want to compare it. But in new trucks, as Mr. Arnold is reaching out for, they're just like buying a brand new car today. I mean, all the emissions and everything is up to speed, and it's the best, rather than most people that start out come up with a used plant and just an old beat up truck. And it would support a lot of the comments that I've heard this evening, but I don't believe that's where you're going here. I support Mr. Arnold's plan out here. I think it's an added resource to this side of Gainesville or this side of Alachua County, and it would minimize traffic from Newberry, from Williston, from other areas. But anyway, I think if you have any questions about the construction of it, I'm not a part of the conditional use permit. I'm not familiar with all of that. I'm just in the confines of the construction site, and I know all about that. So I can answer any questions if you have any. That was it.
Thank you.
In Green, I think we've heard of filibuster. But what I wanted to make one correction, the Presbyterian Church is on the National Register of Historic Places, and that's a historic designation. The site file for the state of Florida was done by Melanie Barr when the city had a grant. Every building over 50 years old is on that site plan. So that's really not a historic designation, for any guidelines for development. I just want to see that end of Archer come alive again, and I would certainly support Mr. Arnold and his efforts, and thank you for your patience tonight.
Thank you for your patience.
Hello,
Hello.
my name is Michelle and I live here in Archer, and I came here to learn more. So I appreciate everything that's been presented on both sides. The big thing that I think we've kind of missed not discussing this evening is the why. Why is there a batch plant that's being proposed in our town, and what are the plans for that for the future? So I believe, engineering and technology and all that can do great. I mean, let's just say for argument's sake, that's all true. Let's just say that it's great and it's not going to cause health problems and whatever. Okay, fine. But why? So what I do for a living, what I've been doing for the past decade of my life is devoting my cause to preserving the American farm and being an advocate for farmers and ranchers. And what I'm concerned with is the 500 acres that was going to be turned into development. And once we take farmland and we take that out of farmland and we turn that into concrete or cement, there's no going back. We lose 3 acres of farmland every minute to urban development in this country. And so my concern is not necessarily the batch plant itself, but what is the end game. So when we're considering why that's being done, and when we talk about traffic and pollution, and just think about all the additional people and what that's going to do for traffic and for other parts of the industry. So that would be my concern and my reasoning for understanding the why and how, and to consider our local food supply, our local food system, beef production, and keeping cows keep Florida green. And I think one part that we love about living in this town is that it is a small town, and it is green, and it is very agriculturally driven. And I think that's why we love living here so much. So thank you very much.
Thank you. So, excuse me, you said your name was Michelle.
Yes.
Do you care to give us your last name?
Michelle Miller.
Thank you.
Thank you.
Liam McSherry, we all know each other. We've been bouncing off each other for almost 50 years. But I heard very interesting holes being poked in the permit as it's been handed to you guys. And I think there's probably 7 or 8 areas that really need to be defined, really need to be specific, really need to give the city as an entity and the city, the people, assurances on a number of areas. And right now, I can't remember a single one of them, but I was impressed. There are some problems. And I'm not a fan of saying, oh, we'll fix this later. You have somebody wanting a permit, let them ask. That's a good thing. And they need to submit a plan that rises to the occasion, that has the holes plugged, that has the explanations placed. And most of the gaps are on areas they really don't want to talk about. Fair enough. But my suggestion to the commission tonight is there's no rush. Mr. Arnold's been working on this a while. He's getting, every time he shows up, he's got a better proposal. I will say that. But I think we need to go through this one more time. I think we need to stay the permit tonight, however the word is, have a workshop so people can be informed of the areas in the plan, that the permit application that are inadequate, and have Mr. Arnold and his people tell us how they're going to fill in the gaps. I think that would lessen the rancor in the town over this project. He's trying, I give him that. And if he gets his plant built, he's going to make a lot of money. So he can afford to be patient and get it right and satisfy the commission and the people of the town. That's my suggestion. This evening, stay the approval of this plant and work forward. And what's another 4 weeks in the grand scheme of things when it comes to getting something right that could be there for the next 20 or 30 years? This is a big decision. This isn't building a garage in the back end of somebody's property parcel. This is something we're all going to have to live with for 30 or 40 years. Mr. Arnold would like to think that. He and I will probably have gone to our reward by the time that turns around. But that's, I can see how he's thinking. It's a good way to think. So we have to figure out how to make this permit work for the next 30 years. This is our one stab at it. If we approve what's there with the holes that are in it, there's too many problems will crop up. There'll be an endless controversy, something you want to avoid at all costs. So I repeat my suggestion. Stay approval of this permit until Mr. Arnold and his very capable people fill in the gaps that have been identified on the record tonight. And we have a little powwow. Figure it out. Let's get it right. Thank you.
Thank you.
Madam Mayor Roberta Lopez.
Fresh.
I would like to take care of one little thing before I get into one other thing. I'm not going through all these papers because I gave them all to you guys. I'm a paper person, so maybe you'll get to read it. You'll see the code of ordinances and other things in there that may interest you. Anyway, at the planning and zoning meeting, I brought up Mr. Arnold. And I mentioned the sand piles and the trucks coming through our neighborhood, and, well, not my neighborhood, but in Holly Hills neighborhood, passing down 129th Avenue with dirt blowing into the people's homes. I also mentioned reporting a very large gas tank to Alachua County Environmental Protection Department when he was setting up his business in 209, 210, right in there. Well, I pulled the report, and Mr. Arnold didn't just have one non-compliance on his facility, fuel tank, storage tanks. He has three. He had one in 2009, 2010, and 2022, along with a lot of his other things in there that are being monitored by the EPD. I have included the EPD report in your package for your information. Mr. Arnold denied everything about coming in with the dirt. And also I reported when he stockpiled a bunch of dirt and it was flying all over the neighborhood when the wind blew, because it's open space where I live. So anyway, I have a problem with people slandering my name and telling lies on me. I have a real problem. I do not take it lightly. And, my problem is this: how can we trust someone who lies? My mother told me, she said, Betty, that's what she calls me instead of Roberta. She said, anyone who lies, don't trust them anywhere to say or do anything that they say they're going to do. So I don't know if I can trust Mr. Arnold to carry out this batch plan. I pulled up some code of ordinances, stormwater development and design standards. It is in my understanding that Arnold Construction will pump water from the Maddox property on the Highway 24 into retention ponds. There are two on his land out in front. I live nearby. To come into his ponds where they were only designated to hold water for his property that he owns up there now. I don't think they were designated to hold water from 20 acres of land across the street, Santa Fe runoff, and all the runoffs all around there, the church and everything else. So he has there are two detention ponds, because detention and retention are different. Detention, they're dry until a storm comes. It's the temporary collection and storage of surface water for subsequent evaporation, percolation, and release at a rate of discharge, which is less than the rate of inflow. The storm water discharge could possibly leave the site and enter natural and artificial surface drain systems on other properties. Detention areas should be designed where possible to completely dry within a certain amount of days. I think I read in these codes 3 days, but I read something else in somewhere else. This did not happen at Arnold Construction. I also included pictures of that pond. It was filled to the top. During the recent storm Debbie, the two ponds filled up to the top. And I checked in a hotel that Sunday. I came back on Tuesday. I took a picture of it. They were at the top. At the top, full. So I saw water from all the way from Tuesday when I got there. Of course, they were full when I arrived on Tuesday at 12 o'clock, all the way until that Friday. So anyway, what I'm saying is those ponds could possibly hold pollution. I know that I understand that they are planning on making them bigger. And I hope that happen, or either if this goes through, because I don't see how they're gonna hold the water that's coming from everywhere to those two ponds.
Thank you, Ms. Lopez. That was your 5 minutes.
Thank you.
Mhm.
I didn't plan on speaking, but I'm.
I appreciate your honesty. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I didn't plan on speaking, but the gentleman mentioned that Mr. Arnold's equipment's equivalent to if you bought a 3,500 pickup with everything. Well, I bought an F-150 with everything except for the moonroof. And this is to show that human factors involved and accidents happen. I go to Lowe's one day and come out and I can't even open the doors of my truck. And I look in, it's doing a software update. When they do a software update, the truck's disabled. I had to sit at Lowe's for almost 3 hours till the software update was done. I went home, calmed down. Next day I didn't bother with Ford support. I called the CEO's office. Of course, you never get the CEO, you always get an aide. Well, now what happens, and what happened was they did a previous update that changed their clock to a 24-hour clock. And my truck is set up to automatically update every Wednesday night at 10 p.m. They interpreted 10 p.m. as 10 a.m. So when I went into Lowe's, 10 a.m. happens. I could have been at a rest area. I could have been at a gas pump, wouldn't have been able to move the truck. So even if you have the best equipment, failure is going to happen. And the human error was that software programmer, and I worked in IBM software programming, he made a mistake. They didn't catch it in testing. They put it out to the country, and how many other people had the same problem I had. So I don't care what technology you have, what you have, human factors involved, and you're going to have something happen. But on the good side is now, when this software update's coming, every time you start the truck, it tells you, starting on Sunday, that I have an update coming Wednesday night.
Thank you.
Good evening, Madam Mayor.
Good.
Charles Tufano. I'd like to share with you some pretty interesting information I found out researching this, to be fair, about the concrete batch plant. And what I found out was, in talking to a very helpful person up at the Jacksonville DEP, that concrete batch plants are regulated by what they call a general air regulation. And so I did a little more research, and what that means is once the batch plant is established and created, it has to have an inspection within 60 days. And then after that 60 days, it's once a year. So we're talking about an initial inspection and then only once a year. However, the inspection, what I found was most interesting, is an opacity inspection. And after further research, opacity. So basically, it's a certified person who sits outside at a predetermined distance from the batch plant, and he visually watches the stack to see if anything comes out. And if it exceeds 5% opacity, which I'm not sure how he measures that, it would then exceed it. That's the air regulation for a concrete batch plant. Am I not correct? 5% opacity? It's a general? Got it. Okay, so that's what I found out. I believe that is a true statement. So I'm going to leave that piece there. The other part I wanted to touch on a little bit is Mr. Arnold's engineer indicated that there should be a net reduction in trucks going into that area. Because I'm trying to remember why he said, but a net reduction. The Maddox plant has been pretty much inoperable for a decade, like we've heard many of the folks who have testified tonight. And it was the last couple of years it was in production, it was open, there was minimal. So I'm not really sure I understand how there's going to be a net reduction in trucking. So I didn't understand that. So hopefully you folks will take these things into consideration tonight. And then I would just add briefly the comments of Mr. Lendowski and his attorney when we referenced the 5 points A through E, where the planning, the commission, our city commission, needs to make sure that A, the proposed conditional use complies to our land development code of the city. We've already identified very clearly through his attorney that clearly there are conflicts, so you can't meet that. The proposed conditional use will not interfere with or adversely affect the health, safety, or welfare of the surrounding community. Again, we've heard many instances where, their experts say it's not going to happen. Our experts say it can happen. So there are many unknowns here. And you, as commissioners, the only way you can approve a CUP is if it meets all 5. And clearly, the attorneys have demonstrated that they cannot. It goes on, I'm sure you folks have read it, the proposed conditional use is consistent with the character of and the existing land use patterns in the surrounding area. And our real estate agent here indicated a very good point I never even thought about. What is it going to look like when you have an 8-foot berm plus another 6 feet surrounding that entire? I don't see how that's going to be consistent with the surrounding area. And I think that's really it. I don't need 10 minutes, but I think those are some very important parts. I hope you folks take those into consideration. Thank you for your time.
Madam Mayor, just so I don't have to interrupt anyone, we are rapidly approaching 11 o'clock.
Make a motion to extend this meeting 30 more minutes, Madam Mayor.
Thank you. We have a motion and a second. Any commissioner discussion? All right. Any public discussion on the motion, which is to extend the meeting? How long did we say?
30 minutes, Madam Mayor.
30 minutes. All right. If there's no public discussion on the motion, the motion to extend for 30 minutes.
I want to just say that it's been a long evening and a lot of people left for the public comment. And I don't know if it's an option to, I don't know what you call it, adjourn tonight and come back. But I think it would be fair to give the residents of Archer and, the community time to actually weigh in and give public comment. I'm tired myself. I can barely even see the screen up there, and I've been sitting here most of the evening, but I just wanted to just share that just for consideration for the city commissioners, that, when you're talking about extending it now, additional time. Thank you.
Thank you. All right.
We have a motion on the floor.
Right, that was for the motion. Yes.
Thank you.
All right, if there are no more comments on the motion, we're going to go to a vote. All in favor of the motion on the floor signify by saying aye. Aye. Opposed likewise. Motion carries 5-0. Go ahead, please.
Good evening. My name is Gary Williams, citizen of Archer. Make this short and sweet. I won't take 5 minutes, but I'm going to talk about the public health and safety issue of the CUP. You guys have in your hands tonight the health and well-being of the citizens of Archer. Okay, I don't want to put a whole lot on you, but you do. The phrase here is a properly operated facility will control and collect dust, migrate, and provide excess buffer to ensure no off-site adverse effects. Listen, this is life. There's going to be human error. There's going to be accidents. There's going to be machine malfunctions. Okay? The question is not when or not if, but when. How big is that accident going to be? How big and how many people are going to be affected by it? Okay? God forbid, I'd hate to be in your shoes tonight and vote yes, and something happens, and down the road, it's going to affect the health and the well-being of the citizens of Archer. That would, I couldn't live with myself. Thank you.
Thank you.
Very quickly, good evening, Mary Helen Wheeler, Alachua County Commission. I am here tonight to help and observe from my sister who owns property right next door. And I wanted to address the conditions that you were putting on for sound and time of operation. Her house is maybe 10, 15 feet from the fence line from where the trucking company is now parking their trucks right up against their fence line. They're not obeying the time frame that's been set up that was a condition of their use of that property. I hear from her every day about how she wasn't able to sleep or how the trucks were starting early, 2:30 in the morning, with the backup lights and the lights on, the sounds, the music that's coming from the cabs of the people who are driving. And we've talked to codes, we've talked to them, and there's still no way to actually get compliance with those conditions in terms of time of operation and noise levels. So just that being said, no, it's going to be really hard to make sure that that is controlled. The second thing is that I'm chair of the TDC committee, the Tourist Development. And it's been my goal as a commissioner to make sure each of our municipalities in the outlying areas have a gig that we can promote for tourism. And there's a lot of historic places here in Archer. There's a big draw to Archer, and I would really like to be able to see us promote, all those good things that are in Archer. I don't worry, High Springs, Newberry, Alachua, they're part of my district when we were doing single member districts, but I came on at the time when we were not doing just single, we were doing the whole county. So my focus is on Archer, Hawthorne, and Waldo. I've got 2 years left on this term, and I would really like for us to be able to work with you and have you understand that we really want you to have that gig here. Tomorrow we vote on the monies that we are going to be sharing with you all from that 1 cent. And so Archer is, is foremost in our heads at this point for the county. So don't consider the county as an enemy. We're offering help. We want you to take it with the understanding that we care about this community. So thank you all very much for your time.
Thank you.
Good evening.
Good evening.
Lisette Avery, resident. I had a question. How many match plants are found to be in the middle of a historic small town? And speaking of historic, we have heard many times, as it is true, that this site has been zoned industrial for over 100 years. And somebody did allude finally to the fact what was a good idea 100 years ago may really not work today. And maybe it shouldn't have been zoned industrial. But this is an opportunity to revise that and to do something different. I also heard that the foundry could be reopened tomorrow, and they wouldn't need a permit. So why not do that? I also heard that there's an inside versus outside requirement. So if it's so safe, why not enclose it completely? And they wouldn't need a permit. We wouldn't need to have this conversation. And we wouldn't need to hear what's going on inside. The other thing I just wanted to mention is that just having this meeting and these conversations seems so out of place. And it just seems so out of place because every other meeting that I've had the opportunity to attend, something has gone through the cracks. Something has happened that we didn't know about or we weren't informed. And it just seemed like this conversation shouldn't be had. And it's just very sad because this is a huge deal for this town. And this is a huge thing to just slip through the cracks.
Thank you.
I'm back again. I'll just I have 3 points, very important. A concrete plant caught fire. It's called Miami Sweetwater Ready Mix Plant. It caught fire. They could not put it out August of last year. It took 18 fire stations from all 4 counties around Dade County to try to put it out. It was impossible. Mr. Arnold has said he's never heard of a batch plant burning down, but these filters, if they're not changed regularly, the dust can create fire. We grow hay. We could burn our hay field down if we're not careful about dust. So anyway, 18 units could not put that fire out. Who's going to help us if this batch plant catches on fire? They couldn't even have water pressure to put out the boat plant. They had no water pressure to put out the fertilizer depot. People lose businesses because Archer doesn't have the infrastructure. So let's delay this, have a workshop, figure out how to get the proper infrastructure so that we can have these industries. I've reviewed the conditional use permit, section 7.6, and I would like to know where I can find the city's industrial performance standards for a concrete batch plant. The information should be how you're going to regulate the bins and silos, the conveying equipment, such as the belt conveyors, bucket elevators for the cement and aggregate, batching equipment, scales, water meters. We don't know if any of this has even been discussed. And why should Mr. Arnold be confused if you don't know how to regulate this within the city? This is why we should work with the county. They have experts that can come to our workshop and discuss all these things. You know, if you have a fire, who's going to show up? You need to tell this community. You need to communicate with these people here. You want everybody's house to burn down? It can happen so quick in a big wind. Please delay this. Let's talk about it. Mr. Arnold's patient. He's been patient for 3 years. He's in no hurry, okay? If you think DEP is going to protect us, do you think the state will protect us? Nod your head, yes or no. It's the Department of Environmental Protection. Mr. Thomas said, oh, good, we have the state involved now. Well, according to DEP, They allow 10 tons a year of hazardous air pollutants. They allow it. They allow 25 tons a year of a combination of hazardous air pollutants. And they allow 100 tons of other air pollutants. We're not protected. We have to depend on ourselves. We depend on you to do the right thing and make sure that we're safe and the welfare of the people are protected. And I'm so concerned about all the 500 children that come here to Archer Elementary School. They come from all over the Southwest County. They shouldn't be exposed to this noise or this pollution. You know, you don't want to have coughing kids in class. It's horrible. So thank you.
Thank you.
Good evening, Madam Mayor. My name is Lisa Renshaw. Although I don't live in the city, but I live on the outskirts. This is my town. I use the post office, the library, the stores. And I love this small town. We live here. We all live here because it's a small town. We're not looking for it to be a big town. And we like it that way. And here before you lays an opportunity for either future growth, like smart growth, where we preserve the history of the town and the things that we love about it, or future demise with things that can cause problems with people's health. And there's a health clinic right across the road from the site. And to kind of say it again, you know, just because something was an industrial site for 100 years doesn't mean it has to stay that way. We can carve out a new future for ourselves, for our kids. Our kids shouldn't have to suffer. You know, if this is approved, it's gonna be here for a long time. And you know, I keep hearing state-of-the-art equipment. I'm in technology. Technology fails, computers fail, and there's human error. And what's going to happen when that happens? You know, you can't control all the dust and noise that comes off of the trucks. So I just feel that, you know, I understand that, you know, city doesn't have a lot of money. One of the things you're probably looking at is, oh, this is a source of tax revenue. But, you know, I implore you to like look beyond the money. Look at the welfare of the citizens. You do have a responsibility to take care of the citizens. We voted you into office to look out for us, to represent the citizens. So that's what we expect. You know, I find it ironic. I was thinking about this. During the pandemic, there was this great concern for public health and safety. Yet when there is an option to allow or not allow something that would cause harm, there is this great debate. And I feel like this should be a no-brainer to just say no. So I just urge you to vote no on this in favor of the people. Thank you.
Thank you.
My name's Nicholas Dean. I'm wearing an Arnold shirt, but I do not work for Ari Arnold. I was lucky enough to get one tonight to show my support. And I just kind of wanted to point out that it seems that the one argument that everyone is making on the other side tonight is that to err is human. In fact, Lieutenant Colonel, thank him for his service. Appreciate what you do. I don't know why he's even considered an expert, because by his own words in his testimony tonight, he spoke on no less than 7 different subjects and contradicted himself several times. So I would like to put that on the record. I do not believe that his testimony should have been an expert testimony. Other than that, I believe that Mr. Arnold has shown that progress is necessary. We all know progress is necessary. And you have an opportunity tonight to work with someone who you've already seen what he's done with this city. And you've seen the type of progress that he puts forth. So
Excuse me. Thank you.
that's just my opinion, and I appreciate it, and thank you very much for your time.
Thank you for your time.
Okay, Robert Kosicki, citizen. Most of you know where I live, right across from City Hall. In a house that was built before Maddox, 1893, just like the depot, just like Mr. Lewandowski's house was before Maddox. A lot of the churches, the older churches were before Maddox. They didn't come here because of Maddox, they were here. And after Maddox was built, they didn't leave just because Maddox was built. You didn't jump in your wagon with the horse out front and start moving away. They lived with it. And Maddox has done a lot of things. I mean, you figure in World War II, they made a lot of the shells for the mortars. They did a lot of things. At one time, they gave us the water and electric for Archer. That's where our water and electric came until the water towers were built and things start changing. But Archer's put up with a lot of things over the years. Take the dump. That was the Alachua County dump. Oh, no, that was Archer dump. Because everybody in cities knew that that was Archer's dump. And it started in the 70s and went through the 1990s. And it was supposed to end in 1998. But in 1996, the county came back to Archer and says, we need to make that dump bigger because we need to save money. Mr. Robert Simons, who was the mayor at that time, said, no, we're done. He worked with Alachua County, and it did close in 1998. Another thing that we almost had to put up with was a prison right there at the corner of Archer Road and 2741. Mr. I can't think of his name right at the moment. Lauderdale took the city commission at that time, plus residents, up to Stark to go ahead and try and bring around a prison. Again, the Archer residents got together, they put out signs, they put out petitions, stop that. It was another thing that was tried to, they were going to bring jobs. It's going to do all kinds of things for Archer, just like the dump. Oh, that's going to be great for Archer. We'll take away your trash bill. So these are some of the things. One thing that did change was when the Stewart came and the Helpling property was put up. And that was going to change into the sewer. And Ms. Green came up to the city commission and says, hey, let's not do that here. Let's not do that for the Archer residents. The Archer residents came to her to do that. She wasn't a commissioner then, but she acted like that by taking on that problem and bringing it to the commissioners, who then changed all that. And now we're getting a sewer from Newberry. So we put up with a lot of different things over the years. And now we're looking to put up with something else that is supposed to do great things for Archer. And that's all you hear. It's going to be, you live with it, and it's going to be good for you.
Thank you.
Michelle Rutledge, Madam Mayor and Commissioners. I wanted to just comment on a couple of things that were said, and maybe something that wasn't pointed out as well is the impact to the people, I think, was a little light this evening. Even in the picture where the blue church, where the church with the blue roof is off of Archer Road, the pictures really didn't show that right across the street was a ballpark, an outdoor park, and the neighborhood, Holly Hills, is a residential neighborhood that could potentially be impacted by this facility. And it seemed like, I'm a healthcare professional, so I thought it was a little inaccurate to say that this dust, particulate matter, might not pose a danger of public health. And that is something that the commissioners, you commissioners are considering tonight, whether it poses a danger to public health or adverse impact on property value. So I just, if possible, there was a comment that there was no complaints made from the residents of Gainesville who live near the cement companies. But there is an article by the WUFT. Porter's community residents are growing tired of noise and dust coming from neighboring cement companies. One of the companies that they mentioned was Argos Ready Mix, and I believe the gentleman who testified specifically said Argos. But the residents say that they have lived with dust on their plants in their homes. And so I think saying that no public health or safety seems to be a bit inaccurate. And it also says that there was a comment about wind. And it says the dust is especially bad in the spring when the winds blow it over the quarters. And so that's a very real thing of the dust that may come from these facilities and how it may impact the neighbors that are adjacent to it. The article goes on to say this can be particularly problematic for some of her neighbors who also already suffer from asthma and other sinus-related issues. The EPA has some information about health and environmental effects on particulate matter. It's EPA.gov, particulate matter pollution. There's also information about an extensive body of scientific evidence shows that long and short-term exposures to fine particulate pollution, particulate matter, also known as fine particulate matter, can cause premature death and harmful effects on the cardiovascular system, including increased hospital admissions and emergency department visits for heart attacks and strokes. Scientific evidence also links particulate matter to harmful respiratory effects, including asthma attacks. And so in this study, in this analysis, has anyone looked at the neighborhoods that are around this facility? Do we know what our residents have? What health conditions have we had? Has anybody assessed that to see the increased traffic? Has anybody assessed how this noise and increased exhaust might impact vulnerable populations that might be around this site? I was trying to cover some of the other comments. If we haven't talked about environmental racism, but siting of these facilities are often disproportionately on folks of color or low income. And there are definitions for the EPA that talk about that. I might be running out of time, but there is definitions that talk about that at the EPA, and I think that's important to consider. And also they mention about where we want to go. Just because something has been cited there previously, it didn't make it right that it was there in the first place. And this could be a time for us to look at our future as a town and move in another direction if that is what we want to do. Real quickly, environmental justice means the just treatment and meaningful involvement of all people. And thank you for your time.
Thank you.
All right.
Madam Mayor,
Is that, yes.
will we have any time to ask the questions of the engineer? Yes,
Repeat that.
the questions that I have for the engineer.
Yes.
Thank you.
My name is Charlie Squires. I'm a concerned citizen. Basically, what it all boils down to is that this facility, this proposed facility, is supposed to meet all the criteria with obtaining a CUP. property values will be affected. There's no doubt. When I go to sell my property and I disclose that there will be a cement plant, concrete batch plant being built close by, a lot of people are going to recoil at that. They're not going to want to buy my property. My property value will go down. By how much, I don't know. So it doesn't meet the criteria based on that one element. Thank you.
Thank you. All right, any additional comments before we close it? All right.
All right, Madam Mayor, public comment at this point in time is closed. Cross-examination will go in the order of Ms. Patrice Boyes, Mr. Byron Flagg will get to go, and then the city is also given the opportunity to cross-examine, at which point the commission may ask questions.
So we only have 8 minutes. We extended for 30 minutes, which would be 11:30.
Make a motion to extend the meeting 30 more minutes, Madam Mayor.
I second.
Thank you. Any commissioner discussion? Any public discussion on the motion?
Madam Mayor, if I may, just before y'all vote, I just want to make sure that everybody is feeling all right. We're good to continue to hear testimony. All the commissioners are feeling okay. I know it's late. We don't normally go this late, so.
Are we
I'll be
good?
very brief.
We're not ecstatic about it.
All right, I just want to make sure. Thank you.
All right. All right, all in favor of the motion on the floor signify by saying aye. Aye. Opposed likewise. Thank you. Motion carries 5-0.
Madam Mayor, if we could have Mr. Lewandowski come over to one of the microphones. I have some brief questions for him.
Okay,
You can hear me all right?
yes.
Okay.
I'm gonna get you a chair. I'm gonna put a chair.
No, I'm fine. Oh, somebody else wanted, okay.
All right, we'll get going and she can bring you a chair. You mentioned you have a degree in history.
I have a degree in history. I have a degree in instructional performance technology. I'm a graduate of the U.S. Army Command and General Staff College, and I'm also a graduate of the Combined Arms Services School.
Okay. So, and you admitted you're not a registered professional engineer in the state of Florida, correct?
Correct.
And you're not an expert in concrete batch plants.
No.
Are you an air engineer?
Repeat the question?
Are you an air engineer?
No.
Are you a medical doctor?
No.
Are you an environmental engineer?
No.
Are you a traffic engineer?
No.
Are you a licensed professional geologist?
No.
Are you a licensed professional hydrogeologist?
No.
Are you an AICP certified planner?
No.
Do you hold yourself out as an expert in meteorology?
No.
Are you a stormwater engineer?
Nope.
And are you a certified property appraiser?
No.
Is Mr. Arnold or his project proposing to demolish your house?
No.
Would you agree with me that 460 yards is equivalent to about a quarter of a mile,
Yes.
roughly 1,400 feet, if my math is correct?
I haven't added up, but yes, I'll concede to that.
Okay. Do you have any evidence or do you have any evidence that a concrete batch plant has killed somebody?
No.
How many employees are in your company?
The current company?
Correct.
So we have 4 employees, and then that's regular employees.
Right. And are any of those relatives or spouses?
Not employees, no. You have to, I don't want to get too elaborative about the company.
Right, you have 4
the company-
employees.
Yeah, the company does contracts, so most of the employees are 1099, or their
Okay.
subcontractors.
All right, but you have 4 regular employees.
Correct.
And are any of those individuals scientists?
Computer scientists?
All of them?
No.
Okay. Give me an example of a current client.
The Department of Defense is one example. The other one, project just finished, is NATO.
Is what?
NATO,
NATO.
correct.
Any of those involve concrete batch plants?
No.
Okay. Do you know the difference? Do you appreciate or understand the difference between an engineered traffic study versus a zoning or planning level trip generation analysis?
Yes.
And do you understand when an engineered traffic study is required? At what stage of development approval that's required?
I'm actually unclear because the ordinances are unclear on that also from my
In
reading.
the state of Florida?
No, I can't answer for the entire state, no.
All right. You mentioned, you showed some slides of FDOT trip counts or level of service as it relates to DOT standards. And I believe you showed a level of D. Is that correct?
That was not from the slide, that service of level D was
Yes.
from the concurrent management report provided by the planning commission. That was not for me. I just showed a copy of it from the agenda.
From the North Florida Central Regional Planning Council, North Central Florida Regional Planning Council. You did the concurrency review for the city.
It was from, on the memorandum, it said from the.
RPC.
No, it said it was from the Archer Planning Commission.
Okay, well, that's the city would have received that from the RPC. Anyway, the point is, that showed a level D, did it not?
Yes.
That's not failing, is it? F is failing, correct?
So.
Do you understand how traffic engineers classify level of service?
So what I understand, and I could be wrong, but what I understand is the clear reading of this. Let me read this to you
Okay,
again. Do you want me to read it to you again?
No, I don't. D is not F, is it?
No, but it also, it appears, based upon this, that D is not an acceptable standard.
According to you.
No,
According
ma'am.
to you.
No.
Okay.
According
Please
to
wait
the
for a
engineer.
question. Please
Okay.
wait for a question.
Okay.
All right. You provided the commission with a journal article involving the collection of novel data in the metropolitan Houston area concerning concrete batch plants.
Yes.
Okay. And would you agree with me that the article says Houston has no zoning?
It had, so as I recall the article, it has a mixture of no zoning, and there's some areas that have some zoning. So that's.
Well, let's look at page 141 of the report if you have it with you, and let me read it into the record. Within Texas, concrete batch plants are of particular concern in Houston because it is the only city in the U.S. without a formal zoning policy.
Okay, I'll take that.
Okay. All right. And you would agree with me that that is not the case here in Archer, that Archer, in fact, the reason we're here tonight is because we are applying for a conditional use permit under the zoning code.
Correct.
Okay. And you would agree with me also, would you not, that the land development code does not contain a cumulative impact rule for industrial projects? Correct?
I'm going to object for the record as that's asking for a legal answer.
No, it's not. He talked about aggregate, concrete batch plants in aggregate. Is there an aggregation rule that you're aware of?
Not that I'm aware of.
Okay. I have nothing further.
Madam Mayor,
Yes.
very quickly, because at some point or another, we're going to be looking back at this recording, and Mr. Flagg, I don't know if he was close enough to the microphone. Mr. Flagg, would you just mind repeating your objection?
I was objecting because the question was asking for a legal conclusion, and he's already explained he's not a lawyer.
Thank you. Ms. Boyes, did you have any other cross-examination you'd like to do? Mr. Flagg, do you have any cross-examination you'd like to do? They've extended it to, I believe, midnight.
30 more minutes, yeah. 29.
Christopher, I'm sorry. Can you pronounce your last name again?
Yes, Mr. Gamir.
Gamir. I apologize for that.
It's a unique name.
Is this better?
Yeah, I think that's better.
Okay. All right. Just a couple of questions. You had mentioned in your presentation that the applicant had put the permit application with the Swanee River Water Management District on hold. I wrote down that you used the words on hold, but isn't it true that actually the applicant has withdrawn their permit application for consideration? And why was that?
It's a standard practice. So ever since Rick Scott changed the 10-2 rule for the Water Management District, the Water Management District is trying to increase their review speed. And so when we think we're going to have a response to comments that take longer than 90 days, we do the Water Management District a favor, request our application to be withdrawn. They will allow them the application fee to be valid for another year, and then we can restart the application. And this helps the Water Management District staff meet their goals and their timelines when they're doing the reviews to be responsive to the applicant.
So you would agree with me when you told the commission that the permit application was on hold? That wasn't exactly correct. In fact, the permit application has been withdrawn.
It is a technically withdrawal, yes, sir.
And that means you don't have the permit application at the current time, or you don't have an environmental resource permit at the current time for the stormwater system that is proposed.
It will come with the final site plan application.
And does that stormwater system require getting an easement from Florida Department of Transportation?
It will be granting an easement in their favor to help the flooding situation associated with Archer Road.
And isn't it correct that you still have to submit some information to the Florida Department of Transportation in order for them to consider that?
Yes, and it'd be nice if that would have had an allowance for the actual project that's going along with it that we're approving tonight.
Thank you. I don't have any other questions.
Thank you.
A couple of questions to Mr. Thomas. Thanks, Mr. Thomas. You had mentioned in your presentation and your comments to the commission that you had some conversations with people at Alachua County, both Environmental Protection Department and Alachua County Fire. Is that correct?
Correct.
And you relayed the substance of those conversations to the commission tonight, correct?
Yes.
But you agree that none of those people at Alachua County Environmental Protection or Alachua County Fire were here tonight under oath to confirm those things that you said, correct?
Correct.
When you talked to the Environmental Protection Department at Alachua County, you mentioned that you talked about an issue regarding hazardous materials. Is that correct?
The gentleman that actually contacted me was the head of the hazardous materials division under county EDP.
And can you explain to the commission what his concerns were?
He didn't have concerns. He was calling me back. I had left a message with his office requesting information on their investigations on the Porter's Quarters area batch plant.
Okay.
And so he was returning my call.
Understood. To your knowledge, are there any hazardous material issues on the property where the concrete batch plant would be located that need to be dealt with or remediated in any way?
Under the official definition of hazardous materials, no, because the state does not categorize concrete batch plants as hazardous materials.
And I understand that, but my question is, to your knowledge, are there any hazardous materials, as you know the definition to be, on the property that must be dealt with?
No,
Not to your knowledge, correct?
that's my knowledge.
Have you, for your work on this review, have you been paid by the city of Archer yet?
No, I have not submitted an invoice.
And when will you do that?
Imagine at the conclusion of the proceedings.
And wouldn't you agree that if the city commission had had an opportunity to review the scope of work that you were proposing, that they could have had a meaningful opportunity to talk to you about what they wanted to review?
I'm not familiar with their procurement policy, so I'm not prepared to comment on that.
So you're not answering?
I don't have a comment on that. They may or may not have.
Well, my question is pretty simple.
Mhm.
If the commission had an opportunity to review the contract pursuant to the code like it's supposed to, wouldn't they have had an opportunity to talk to you about what you're going to do for the city? You can go ahead and answer.
Just for the volume situation, I'm just noting that Ms. Boyce objected as to relevance.
I look to the city attorney at whether or not that's a relevant question or not.
We're not abiding by the strict rules of as evidence because it's a
Okay.
quasi judicial hearing.
Okay.
So you're free to answer.
I mean, presumably yes, they would have had some opportunity to review, comment on, perhaps modify.
Thanks. No other questions.
Now, the corollary to Mr. Flagg's question is the commission likewise may have had nothing to say about your scope, correct?
Yes, that could be correct.
Mr. Thomas, I apologize, Mr. Flagg, you said that you had concluded your cross.
We're concluded.
Thank you. Mr. Thomas, did you have any cross-examination that you would like to do?
Not so much cross-examination, a couple of minor rebuttals.
I'm going to keep in order. The applicant bears the burden of proof here and asks for a reservation do you want to go first for your rebuttal? Last. Okay, I understand. I apologize. Go ahead, Mr. Thomas.
Just quickly, Mr. Flagg mentioned that I had testified that I was doing internet research. Just want to clarify, actually. Yes, I did some internet research, but that was in the context of looking for substantiation of the complaints or concerns that the residents had posed during the Planning and Zoning Board hearing. I was not testifying that my determination was in any way influenced by internet research. That was based on competent substantial evidence and my experience as a professional planner then. And that's what I testified to. He also mentioned that operating hours from 5 to 7 would somehow violate the noise ordinance. The implication being that if you're operating outside of the daylight hours that are listed in your code, which go from 7 a.m. to 7 p.m., would automatically be, the implication was it would automatically be a violation. The noise ordinance will have to be complied with regardless of what hours of operation that the business is operating under. And so just because they're operating at a time earlier than 7 a.m. doesn't mean that they would be out of compliance with the noise ordinance, because they'd be required to meet those requirements at all times. And then he also talked under 17-02 subsection 2.b, talked about noises not being permissible from certain activities or certain times or certain days. But if you go farther down in 17.02 and you go to subsection 4.g, it actually exempts industrial activity, industrial noise. And so I just wanted to point that out, that that's also there is an exception for that. Again, having to meet the noise ordinance requirement at all times. And I believe that was it. Thank you.
Mr. Flagg, I know you did cross, but did you have anything that you wanted to clarify or anything to that nature? No? Okay. Ms. Boyce, I believe the floor is yours. And then I know that the commission is wondering, after Ms. Boyce finishes, it will be your turn to ask questions of any of the individuals who have spoken tonight or either of the attorneys, should you choose to do so.
Madam Mayor, we're going to bring our engineer up to handle the factual rebuttal. I have brief closing comments at the end of the proceedings, so I'll sit down.
Madam Mayor, Christopher Gamir, professional engineer. I wanted to start first by talking about the traffic concurrency study provided by the Northwood Regional Planning Council. So as a rebuttal to that, if engineering reviewing this calculation they did, they made an obvious mistake. So there's 3 ways to calculate traffic if you're just using an ITE manual. You can do square footage of the building being proposed, the number of employees being proposed, or maybe the acreage of the entire industrial site. And so it's obvious from these calculations that they accidentally applied 5 acres as if it was an entire building. I can raise that up. Thank you, Trace. So when they did those calculations in the report of calculating, 162 PM trips, that was as if the building was 5 acres itself. And so that was an obvious miscalculation. But then also looking at that table, the existing level of service for that level of the road was a traffic level C. And at the other end of the table, it still remains a C, even with that gross overcalculation. So with an approximate calculation, instead of 162 trips, it should have been more of 46 trips or 35 trips, depending on how you calculate it in the PM. And of course, that's also just a generic industrial table calculation. So I wanted to point that out, that we are not going below the operating service level of that street. Also too, you all had the FDOT here talking about road widening. They're proposing road widening from Archer to the city of Gainesville, but also they discussed how none of the other road segments, especially going west, would require widening to at least 2040 because there's plenty of capacity on those roadways. Reviewed all those items. Moving on to the testimony received from someone who'd worked at a concrete batch facility. Obviously, they're not an expert on the operations of the facility. And of course, as you heard in other public testimony, in 1996, the laws changed completely. And none of the current best management practice, we call them BMPs, are in place at that time, which are in place now. All right. So I want to talk about a lot about tracking of dust on the site. So one of the many commonalities we saw at other concrete batch plants that are very old, that were way before these sort of timelines, is many of them aren't paved. They have just lime rock down. So it's almost similar to what you might see as a complaint from a construction site, where trucks rolling through the lime rock might track off sediment of the site. So first of all, our site is completely paved, all right, first of all. And then also in that concept plan, we have a long driveway going to the road. So not only are we paved, we have a long driveway, and that just wouldn't be acceptable for this type of facility. So we don't have any concerns about dust being tracked off the site. Additionally, the references keep being made to the Porter's Quarter, and they not only have the concrete batch plant there, but they have crushing facility. So they're accepting all of this old concrete from demolition sites, and they're crushing it in that location, which is tracking in equipment bringing in dirty equipment, dirty concrete from sites, crushing on the site, and then exporting that material. So they're going through a bulk quantity of raw construction supplies and materials through that site, which is not our case at all. That also brings it to the operation of the facility. So the concrete trucks coming in will be operated by Mr. Ari Arnold. These are not third-party trucks coming in. And when we're talking about a reduction of trips and travel, is that because of this plant's location and because all the other facilities are in surrounding cities, we're reducing truck travel by 10 miles easily in each direction. So we could be saving trips on the roadways from 10, 20, 30, 40, 50 miles per truck delivery. So this facility itself helps with the efficiency of truck deliveries, et cetera, et cetera. So as Mr. Thomas indicated, the noise ordinance is fully complied with at all times. The hours of operation are not incompatible with the application of the noise ordinance. We talked about the BMPs on the site. So talk about the historical land use. So you already had testimony describing the land use of the property and about the historical purpose of it. The city has a section in their code for historical overlay, but that has not been established or provided on this property. The building may have a registration, but we're not proposing any demolition of the historical portions or the older portions of the existing batch plant. I mean, the Maddox Foundry, sorry, slip of the tongue on that one. All right. Talking about historical record. And there was some, I can't remember where this came up, about dust being somehow not controlled and that there's no performance standard for emissions. Well, dust is a form of emissions, and dust would be the really main or only item of concern for a batch plant. So by us talking about the dust formation, we have talked about emissions per your performance standards in the code. And of course, there's also a concern talking about how the comprehensive plan required certain performance standards in land development code for industrial uses, and that they didn't exist. However, your code is full of buffer requirements, setback requirements, all types of industrial requirements in that code that we're showing compliance with and will further show compliance with the site plan application. I think we've talked significantly about DEP and the general air permit for the process. So I'm not going to get into that about that article and how it's just not at all applicable to Florida due to the completely different state regulations about air quality standards and air permitting. Internet research is not competent, substantial evidence. And more importantly, I will go into the point about the equipment that we're purchasing. So this is modern equipment being purchased brand new. So it's being designed to meet all the criteria as a guarantee warranty from the manufacturer. So it's important that we realize that this is not a separate side operation. This is brand new equipment that has intent from the beginning. And we're adding berms to this facility to further provide buffers to the adjacent properties and many of their concerns. I believe I've covered most of the items that I can think of. Thank you, Mrs. Boyce, and I'm available for the commission if you have any questions following this Boyce closure.
Okay, I know that one of the commissioners had questions for the engineer. Do you, okay.
Thank you for your indulgence, Mr. Amir. I just have, I think it's a total of 5. I'm double seeing here questions. In this CUP 23-01 application for an outside system known as a cement plant, number 1, there was discussion or description of recycled water to keep the product moist.
Yes, sir.
Potable or non-potable water as recycled water, please?
It's non-potable at that point. So obviously the water's not going to last forever. We put some of it into the actual concrete.
Okay.
And it starts off as potable, and then whatever we use for washing, it'll go into settlement areas that are permitted with the
Okay,
state.
that's fine.
Yes.
All of this source water for the application of the outside system, ready mix cement operation is coming from the city of Archer,
That's exactly correct, sir.
every gallon,
Yes, sir.
okay? Second question, and again, I don't want to belabor a typo, but there was presentations of a 7-foot, 8-foot, 9-foot berm system with a fence on top of that. What is the purpose of that exterior berm in the engineering design with this outside system? What is the purpose for it?
Yes, so as shown in the noise study, it's providing a direct obscurance of potential noise source. So as shown in the study, there's one kind of batch plant that has a very high silo associated with it, and there would maybe be a pump at the top of that silo. So that's sort of the worst case scenario.
So the berm system around this outside system is to reduce or control noise.
Exactly right, as specifically stated in the noise report.
Thank you. And it would be 8 feet?
Yes.
Okay,
Yes,
I mean, we had 7, 8, 9, it's 8 feet.
Sorry for the
Thank you.
typo.
That's okay. Because there's a current berm around that backside now that's probably 12 or 15 feet and probably 50 feet, 40 to 50 feet wide, so.
Correct, those piles of sand, spent sand are in random
Right.
locations, and we
And
unify
will there
that.
be, will there be utilization of that to build the new berm system?
Oh, yes, partially, yes, sir.
Okay, thank you. Where will the egress and delivery road be? From Archer Road or off of 170th Street?
It's coming off of Archer Road, as shown in our exhibit and site plan.
And that
concept
is a
plan.
change from previous design application, correct?
Correct.
Okay. And that will be the only delivery will be off, that will be the egress and access to the cement plant from Archer Road and whatever the designated approved DOT apron is, et cetera.
Exactly correct, sir.
Okay, thank you. You spoke in the design of the potential of the improvements in the stormwater runoff and retention and flow. Well, is this system and what you're proposing for this outside system include the current out of control rain event water that comes from downtown and comes from north to south 170th Street? I don't know if you're visually aware of what happens in a rain event, but that 20 acres is taking all of downtown Archer water. And I'm not giving testimony, I'm just saying, in this design, will it include, or will there be just a design of a blockage of the current non-stormwater system in Archer? Just in a proposal, I'm just trying to get clarification because I'm sorry, I'll let you answer.
Yes, sir. So part of figuring out where the water goes is we determine the watershed that contributes to the low spots. So everything on the west side of Alachua County, I'm grossly simplifying here, but there is no direct path to the creeks or streams and overland flows. So we're all going to depressional areas that result in floodplains. And so we're part of our application with the Water Management District and also FDOT, since they're also now invested in the drainage of this project, are defining the areas that drain to this low spot. So there could be other areas of city that also have drainage issues that could be evaluated that drain slightly different locations.
Yeah, and I'm not trying to get into the design component because I know everyone's tired, but I know that there's a current stormwater issue that would encompass what I think DOT would be able to allow if there was a culvert system or something that went to State Road 24. So, because I just know right now, there is a real problem with the water all flowing into that site. And not trying to get into your design, but
FDOT holds us, and they're the ones that really brought all the complaints that they had about drainage in the area, and they have a pipe there going to nowhere, so they have a
It went
huge.
somewhere. It went to Maddox's
Well, yeah.
DEP required deep retention pond for heavy metals. That's where it went. So, sorry, giving testimony. I'm sorry, Madam Attorney. Okay, I have one other question. That's it. Thank you.
Thank you. Any other questions?
Thank you.
I
You
have
have a question? Oh, I apologize.
Okay.
Yes, ma'am.
So my question is, how often will this facility, this plant be monitored? Or is that the right term? How often do someone come out like OSHA or we have Joint Commission but how often do they come out to make sure y'all up to the standards or following the procedures or the,
Sure, Madam Mayor. I am not an expert on the actual enforcement and inspection portions of those permits. I'm a civil engineer who designs and makes these applications for their construction, similar to how an electrical engineer might design an electrical circuit for a building, but the building inspector comes at their point in time, or if there's any sort of complaints about, now I'm conjecturing about different facilities, but inspections happen separately, and I'm not an expert on the frequencies of all those inspections.
okay. As for your job, then, how often do you go back and look and see how you can approve or to make sure what you implemented is the standard for the plan?
That's actually a great question. So first of all, I run computer modeling because we're thinking about a 100-year storm event. And more specifically, because we're in the Swanee River District, we're designing as if it rained for 10 days in a row, 240 hours of rain. And so it's impossible to sort of, you can't experience that. It comes at times you're not expecting. So I do the design, I'm signing and sealing it. Construction occurs, I'm making observations during construction, logging those. The Water Management District, FDOT, all make me certify at the end of construction that I observed and I'm happy with the design as constructed, that it substantially complies with my design. And then from that point on, it really comes to complaints or storms that come along, and then we get direct complaints from agencies. And FDOT is normally number one that gets complaints, especially on a major state road. So that's the main source of these kinds of complaints, how they come back to me.
Madam Mayor, I apologize for interrupting the questions being directed to Mr. Demir, but we are at midnight.
Yeah.
I just want the commission to make
Yes.
an appropriate motion to extend, that's all. If that's
Make
the
a motion
desire.
to extend the meeting 30 more minutes, Madam Mayor.
Second.
You got it. We need to finish.
I'm sorry, did we have a second?
I believe it was Commissioner Green.
Commissioner White. and
Oh, I
Green, but we
apologize.
both said it at the same
okay.
time.
All right. Oh, I'm sorry. I guess it's too late because I didn't hear either. All right. Any commissioner discussion on the motion? Public discussion on the motion? All right, let's go to a vote. All in favor of the motion on the floor signify by saying aye. Aye. Oppose likewise. Motion carries 5-0.
Ms. Boyes, is it your intention you'd like to do your closing? Is that what you're? And then Mr. Flagg, obviously, you're welcome to come do a closing when she's
No, I would
finished.
do my close after him.
Oh, I'm sorry. Oh, yeah, okay. Mr. Flagg, would you like to do a closing?
No, it's late. Appreciate your time very much. This is what local government is all about. I grew up in a family that was involved in local government. I just want to say and reiterate those conditions under the conditional use permit that we walked through and went over, and remind you that if any of the competent substantial evidence you heard, the testimony, remember, it doesn't necessarily have to be an expert witness to be competent substantial evidence. whether it's information that you've learned from the applicant or from Mr. Lewandowski's side. Any of that information can be utilized in your articulation to, if you are going to decide that I'm finding that there are problems with this conditional use permit application and I think it should be denied or postponed. Thank you.
Thank you.
Madam Mayor, Commissioners,
We'll come back. Thank you.
thank you for indulging us this evening. This is a very important vote to my client and to the community. You've heard competent, substantial evidence from your staff, the reviewers that you have in the packet that we've talked about ad nauseum tonight, our engineer, our certified property appraiser, and you've received written competent, substantial evidence in the application materials and expert reports before you this evening, all of which pretty much would compel an elected person on this board to approve the permit under your code. You've
Can we
heard,
interrupt you just for a minute?
Yes, ma'am.
I'm sorry. We still got questions down here.
We went out of order. I don't know how it happened, but Mr. Demir wasn't supposed to be asked those questions. We were supposed to let them finish first.
Okay, I'm sorry.
no problem. Do you want me to?
No, go ahead.
Continue.
Okay. You've heard a lot of lay testimony that's dependent on internet research, and that's what's not allowed. An expert can rely on other expert opinion, other information that's professionally accepted methodology collected in that manner in the formulation of their opinion. But to give you a packet of info derived from the internet without an expert or even the person who wrote it is simply, you give it the weight that it deserves, which in our opinion is not much. So you've heard lay opinions about the technical requirements for the conditional use. You've heard a lot of legal argument that's not evidence, remember. You heard lengthy legal argument about your code, and that is not evidence. Mr. Hotelling agreed in his testimony that all industrial uses are likely to have a negative impact. And that means any use that's permitted here in the industrial zone that lives on this property, whether it requires a conditional use permit or one that does not. And what that means is the impact of industrial use is already cooked into the community's property values surrounding this particular site. I do need to say, and I mean no disrespect to Mr. Hotelling, but I do need to say for the record, because they've threatened to sue you. So if they do that, we have a court review of what is in the record. We don't get a new trial or a new hearing. It's what is in this record this evening. But Mr. Hotelling is what we lawyers refer to as an attack witness. He didn't do his own study. He didn't do a paired study. He didn't attempt to gather his own data or analysis. He simply attacked our witness. And I think even in doing that, it was very general and very speculative. Our witness on property values, in contrast, did an impact analysis. He looked at data in Florida concerning numerous concrete batch plants. He did a paired analysis, which is the industry standard. He looked at homes, sales before and after a plant gets built. He observed that the foundry itself is closer to homes than the proposed concrete batch plant. And he pointed to the unique characteristics of this site, as did our engineer, regarding the berm for noise and visual attenuation, as well as the placement of the actual equipment back behind the foundry. So you won't see it. And likely, well, you can't hear it or it would violate, the noise ordinance, morning, noon, and night. It has to comply with the noise ordinance. In contrast, supporters of the proposal pointed to job creation, economic stimulation, redevelopment of the old foundry site, which has served as the industrial heart of Archer for more than a century, allowing the city to grow up around it. The project makes tangible improvements to the stormwater situation in downtown Archer. My client is voluntarily doing more than he has to do for his project to assist the community with a palpable stormwater situation for the church, for the roadway, and for everyone else in this general vicinity. You heard also testimony, there will be community benefit in sorting out the driveway situation as it relates to the church and cleaning up access coming down on that backside of the property. I did want to mention that when we come back for site plan, an engineered traffic study will have to be done. And that's where we look at exactly how many trucks, how many people are expected to work here, and it will be site specific, not a general trip generation study, which is all we had to do for this particular level of approval. So you'll see the turnings at the intersections. There will be a detailed analysis of if intersection improvements are needed or operational and safety improvements are required by DOT. That comes at the next phase. So we're not here tonight to vote on the traffic study. I just wanted you to be aware of that. And I think with that, I would leave you with, Mr. Arnold's application complies with all requirements in the Land Development Code and the Comprehensive Plan, and we respectfully request that you approve it after this very long evening. Thank you so much.
Thank you.
Madam Mayor, now would be the appropriate time if the commission has questions for any of the individuals who have testified this evening or their counsel, or the applicant himself. I know he didn't testify, but.
Actually, a couple of mine has already been answered, which was 24 going to be the only access? They will only be able to come off of State Road 24?
Yes, ma'am, for the concrete patch plant, yes, ma'am.
Okay, and my other question was going to be, and you've already answered that one, was the access was going to be paved, because I know as the trucks will go in and out with the lime rock, whatever, that creates a lot of dust. Another question that I had, how many days per week will they be in operation?
I don't have an answer for that, but it
For
could
that
be
one.
a standard 5-day, or maybe sometimes it may have some weekend work associated with that.
Would that be Saturday? Well, I guess that would be a question for them. Would that
It
be
could be on, but
Saturday and Sunday?
it could vary on that, depending on how the job come up. I'm sure that's not a typical operating period on weekends, but it could definitely happen. But that's why we have the operating hours as part of the conditions.
Okay, and also since the dust seems to be one of the biggest issues, I know about some concrete plant working because my father raised 5 children working at a concrete plant, and my father and 4 uncles raised their families and, working at the concrete plants, actually down in the Porter's Quarters area. And I do have to say that none of them ever had lungs problems or anything like that. So I thank God for that. None of them had any of those issues. But my question is, since there is a major concern about the dust, what would happen if something did not function, or if there was a breakdown?
Right, so that's where we talk about how this equipment is computer controlled with monitors. So we didn't show a picture of it tonight, but all the current equipment has multiple computer screens. They're monitoring the ins and outs with the pressures, and it would throw errors and shut down and have to be fixed and before it can be brought back up into operation again. So there's many safeguards in the equipment that's going to be used on the site.
Okay, so you're basically saying if something did happen with that, everything would just shut down?
They would know it and it would shut down, yes, ma'am.
Okay, thank you.
Before any,
Yes.
before any dust escape? I'm going home. Before any dust escaped?
I would assume so. I'm not an expert on the actual physical operations of what shuts down when. And of course, it probably depend on what the nature of the error that occurred. Obviously, let's say the dust clearing device didn't function. Well, it's still contained. It just didn't go off. And there could be some other malfunction. But again, we're talking hypotheticals now about all the ins and outs of the equipment.
We're also talking about computers. Technology's wonderful till it ain't. So the other question I had was, hold on. It's expected to meet the city of Archer's maximum decibel levels.
Yes, ma'am.
And what I read in Kimley Horn and the ARM was that until production started, we wouldn't get a clear decibel level.
I can address that for certain. Sound calculations are really hard to experimentally prove. That's why we provide all those diagrams, all those expert considerations on the calculation of that, and then the Kimley Horn justification. And on top of that, we have remedies that we could then apply to the site if we did exceed sound values. So it's not something that you can model to 100% accuracy. It's something that we're showed a good faith demonstration that we're going to meet the requirement with ways to meet the requirement in the future by monitoring of the sound and noise levels.
Someone spoke about the September 2023 study on particulate matter. It's on, I'm sorry. It is in front of me. Someone spoke on the study on particulate matter from September 2023 and about 100,000, oh gosh, what was that? Anyway, forget that. Forget what I was going to ask there. Okay, now that's all I guess with you. I need our planning.
Mr. Thomas?
Yes. Yes, Mr. Thomas, I'm sorry. Deanna,
Is she still there? Oh, she is. Hi.
Deanna, can you pull a section, and I think it's on this one, section 7.01. Yeah, it's in the land development code, but I thought the attorney, Mr. Lewandowski's attorney, brought it up earlier. It's on one of his. Yeah. That's what I'm looking for. Mr. Thomas, the very first paragraph. When you read that, in layman's terms, tell me what it means.
It shall be unlawful to erect, construct, alter, or remove any building or structure, to change the use of any building or land, or to engage in any development activity until a certificate of appropriateness has been issued by the Historic Preservation Board, the zoning permit has been issued by the zoning administrator, or a conditional use permit has been issued by the city commission in accordance with the requirements of this land development code. So basically, in layman's terms, if you are I don't see any language about contributing structures, but if you're in the historic district, it's implying that you would have to have some sort of approval, certificate of appropriateness.
This is not the historic, is it? This isn't part of the historic, is it? This is the permits.
Typically, certificates of
What is
appropriateness would
section
reference
7, Deanna?
historic.
Can you tell? Section 7 should be permits. Yes.
Okay, each community can be different, and so presumably this is referring to getting a certificate of appropriateness for any of these listed actions.
When I read it, this thing's loud. When I read it, I'm reading that if I come in here and I want to build something, that I can't even start until I get that permit, the zoning permit or whatever, or the CUP.
Yes, ma'am. So I see where I got off. The certificate of appropriate is for historic, but it goes on when it talks about
Right.
then getting a zoning permit from the zoning administrator or a conditional use permit issued by the city commission.
Okay, so was I correct that it just means that you can't even get started on anything until that CUP's been issued?
Yes, ma'am.
And you agree with it?
Yeah.
Do you agree with it, Madam Attorney?
I agree with the plain reading of the land development code.
I'm through with you, sir. I'm sorry.
And just
I'm through
just
with-
as a point of note, so once any of those are granted, at least in this particular situation, then you still have to come back for site plan review.
Right, I understand. But before anything can be done, that CUP's got to be done.
Yes, ma'am.
Okay. Do you agree with that? Okay. Everybody agrees. Right now, there's loads and loads and loads of gravel, rock, sand on a clear strip. It was completely stripped of the trees and all the greenery on that piece of property, correct? And there's been loads of material brought in that's going to be used for that.
There's no testimony in the record to that, Commissioner?
There's no what?
There's no testimony in the record to that? So if you're going off some type of information you got outside the hearing or a drive-by,
I see
you
it.
need to let us,
I
okay.
live here. I see it. We
Okay.
all do.
But that's not part of your hearing tonight.
Madam Attorney? Oh, never mind.
Okay.
Tony, you are a codes enforcement officer?
Ma'am?
You are a codes enforcement officer?
Yes, ma'am.
Is that a violation of our codes?
What's on that property?
Yes.
No, ma'am.
That is not a violation of section 7.01 of permits?
Not that he's dumping on his property. No, ma'am.
Do you see it as a violation of that? I mean, I'm not the brightest bulb in the chandelier, but I'm not burnt out, and that is explicit.
Madam Mayor, my interpretation of that would be that if it's related to a structure of any kind, I don't see anything that would prohibit you from moving dirt around or storing aggregate or something on site, or even, I'm not familiar with your tree code because I didn't look at the tree code if you have one relative to this application. But I know in other jurisdictions, for instance, on industrial sites or other commercial sites, some of them allow you to take trees down without a permit. So we'd have
And
to
I
look at that.
understand, that's not what I'm saying. I'm saying the trees were taken down in anticipation of bringing this business in. Then there were loads of material used for this business brought in and stockpiled in there. And I don't need testimony because I've lived here 60 years. I know what it looked like. I know what it looks like now. It's fine.
I don't
got
see,
the
I
answer
don't see
needed.
where, because they haven't moved a structure, built a structure or anything, relative to a structure, that it would necessarily fall under this. I guess an argument could be made that it falls under the general category of development activity, but it may not be development activity. It may just be storage of material on site. Without further explanation or investigation, couldn't say.
Okay. Okay.
All right, we have 10 minutes left. What-
I don't, it's not gonna take me very long at all. Commissioner Hope, did you have additional questions you wanted to ask?
No, ma'am.
Vice Mayor Penny, did you have any additional questions you'd like to ask of anyone? You know, it's not just limited. I know that we're talking to Mr. Demir a lot, but any questions you have for,
My question is, who and how often will this site be monitored? He just said he couldn't answer the question.
Right, I answered to the best of my ability, considering I'm not specifically involved in the air quality permit.
Right. So I don't want you.
I know it's late, but I recall testimony that it would be inspected. You have a construction permit, then you get inspected 3 months, 3 months after it's erected, and then annually after that. And if there are complaints or issues, then
They go in.
we go in again more frequently.
Okay, I just wanted to know.
No, it's fine, it's
No,
fine.
you act like you got offended.
No, I'm just trying, I'm having a hard time remembering. I hope that answered your question.
Thank you.
Madam Attorney, just a quick point of order. Just want to remind the commission that what the attorneys say, pursuant to Ms. Patrice Boyd's own explanation, what the attorneys say is not evidence.
I was summarizing testimony you had from someone else.
Thank you.
Okay.
Thank you, everybody. I do not have any questions. I did, but they were cleared up, so thank you.
okay, Madam Mayor, at this time, I'd like to advise you all as to the legal standard you're applying tonight. As we've discussed previously, the decision tonight needs to be based on from, you know, metaphorical gavel to gavel, evidence that's been presented to you. I know that there's been a lot of discussion on competent and substantial evidence, and both attorneys have presented to you fact. Mr. Flagg presented to you that someone doesn't have to be an expert in order to testify. That is true. There's a case out of the 5th DCA. It's Marion County versus Priest. And it essentially says that in zoning hearings, it's permissible and may constitute substantial and competent evidence so long as it is a fact-based testimony and not mere generalizations. That's going to be a case-by-case basis for you all to decide tonight for testimony that you heard for folks. Ms. Boyes brought up the fact that, you know, on certain matters, you have to have experts. That's, again, for you to decide as to whether or not they're presenting competent and substantial evidence in their field of study. As a wrap-up of competent substantial evidence is such evidence that is sufficiently relevant and material that a reasonable mind would accept as adequate to support the conclusion that's reached. And then just to reiterate what I had said prior to Mr. Flagg putting on his case in chief about hearsay, my recommendation to you all was to allow it to be admitted into the record and to afford it the credibility and the weight to which you deem fit. Again, that's going to be on a case-by-case basis. So tonight, essentially, you've got really 4 options on how you want to handle your resolution in front of you. 4. I mean, you can approve the conditional use permit with no conditions. You can approve the conditional use permit with the conditions as set forth in the resolution before you. You can approve the conditional use permit with varying changes to the conditions set forth. Now, I will flag for you that the conditions, if you were to vary from them or to add additional ones, they need to be reasonable. They need to tie back to these factors that are on all of your resolutions of those 5 things that both attorneys have discussed tonight ad nauseum. And they would need to be based upon competent and substantial evidence that's been presented to you tonight to work in conjunction with one of those 5 issues. And your last option is to deny the conditional use permit. It's going to be my request as your city attorney that when you make a motion this evening, you not just make the motion of, you know, I move that we approve resolution or I move that we deny. If you could please provide some information as to what competent substantial evidence you are relying upon in making that motion this evening for purposes of the record, that would be great. Madam Mayor, that is all you.
Thank you. Do we have a motion?
Madam Mayor,
Yes, ma'am.
I have listened to all the testimony. I've watched it. I've read our comp plan, the majority of it. I've lived under it almost. Our land development code. And I've been through this several times in the last, over my 16 years. We had two property appraisers, both of them telling us that there was a subdivision in Newberry with a batch plant in the center of it. One neglected to tell us that it was not as close as the homes are to this batch plant, which is 50 to 75 feet about across the road. It's a historical district. It is a historical district. Maddox itself is historical, and it is listed in the state of Florida Museum of History. The fact that it's 100 years old and was built before we had land development codes and comprehensive plans doesn't negate the fact it's 100 years old. It's historical. Across the street from it is the historical depot. To the southwest of it is an older home. To the southeast of it is an old historical home. To the far southwest, to the west of it is another historic. It's surrounded by historical homes and buildings. And nobody will convince me that a cement batch plant would work in that residential district with that historical residential district. We have heard testimony that the dust particles do create problems with people with breathing problems in the lungs. I know you've told us that those dust particles are going to be limited. But it's running on a computer, and even you said, until it happens, we don't know how many dust particles get out. So there is a health hazard there, a potential health hazard. It's out of character with the neighborhoods.
Okay, so sorry to interrupt, but we have like less than 2 minutes left on our extension. So what do we want to do?
Well, I'll finish my motion, and
Oh,
how do you want me to do it, Madam Attorney?
you have less than a minute.
I think that the land development code, it's been shown where it does not meet the land development code. As a matter of fact, it was violated. However, I only have to meet one of them. And I firmly believe that it doesn't meet either one of them. But I'm going on the two that I just gave you. And our comp plan, our comp plan is clear about preserving and protecting the historical buildings and lands in this city. So for that reason, I'm going to make a motion that we vote no to this.
Madam Mayor, I will second that, but based on a different character justification, and that is this CUP 2301 is being applied for an outside system in a heavy industrial zoned area. A completely different application than the previous industrial application, 100 years old or not. No basis for the historical value of it at all. It is an outside system. It was explained to me the berms for potential noise abatement of unknown decibels until operation starts. That in itself substantially is out of character for the area and the community around it. Thank you.
Okay, so we're out of time. We have a motion and a second. Yeah, and we're out of time. So
Madam
what-
Mayor, I think it would be appropriate to just pause this motion and the commission decide whether we want to extend the hearing for longer to wrap this up.
Extend this meeting 30 minutes, Madam Mayor, as a motion.
Second.
All right, so we have,
Hope and White.
yes, a fifth extension for 30 minutes. Any commissioner discussion? Any public discussion on the motion to extend? All right, let's go to a motion. All in favor of the motion signify by saying aye.
Aye.
Opposed likewise. Motion carries 5-0. Continue. Were you done? Commissioner Hope, were you done?
Yes, ma'am.
Commissioner, discussion on the motion.
It's a lot
It is a lot.
to just vote on. You heard all this testimony tonight, and you really couldn't discuss it prior to the night. And now you want us to make this decision tonight. And it's a lot to digest, to just make this decision like that. Because where it is some people saying, no, we don't want this, there are some people saying, yes, we want this. We need this. So it's just hard for me just to say no, but it's hard for me just to say yes. So I'm just thinking right now, what was our options again, Daniel?
You have a motion on the floor at this point in time, so the options I don't think are super pertinent at this moment in time. The motion on the floor is to deny the conditional use permit, and that's what I would suggest you limit your discussion to. I do want to reiterate, I understand there are people who don't want it, there are people who want it. Your decision tonight is based upon the testimony that was presented to you, not the ex parte communications that have been communicated to you all.
Thank you, Danielle. Discussion down at the end of the table. You good? All right, and for those people that don't understand what the quasi judicial hearing is for us, because I heard several times people talking about why we didn't know this and why we didn't know that. We just got the information recently after planning and zoning. So there was a lot of information that we could not be privy to. There was a lot of information we could not discuss. And so, yeah, it's more of, did they meet their, those 5 burdens that they needed to meet? It's not about what everybody else's opinion is and why we didn't do this, that, or the other. Did they meet those 5 things? Now, me with a science background, I kind of disagree. with the motion. I do. Because I, listened very intently to everybody that was up there. And because of having to know about EPA, the state of Florida, different things to do my job, I understand, the information that was laid out. And I do agree that it is a lot for us to hear in one night because this has been a very long night. So we can't remember every single detail, but it is our job, even though this is how it's thrown on us with per se, it is our job to make this decision. That's what I will say. So with that being said, commissioners, you're done, right? Public comment on the motion.
Just for everyone's clarification, this is regular public comment, so you're limited to 3, you don't get 5, just as a.
Charles Tufano, resident. My comment is you need to vote no. It does not meet all 5 criteria. And I disagree with you, Madam Mayor, but we've heard testimony from both sides, and I have very carefully listened to the same testimony you have. And there's a lot of holes in this thing. And I think you need to do the right thing and vote no. Do the correct thing. Thank you.
Thank you.
I promised I wasn't going to get up here and talk tonight. We have met all the conditions that we're supposed to meet. We have an independent planner come in, and he recommended that you pass this. I don't agree with anything that you have to say. You're just spewing Luganski over there.
Oh, boy.
But this is a good project. I'm going out of my way to do a beautiful, wonderful plant. You're not going to get the stormwater. You're not going to get anything that with that plant. It's historical. If it's historical, are you going to buy it from me? Are you going to? I know that my son overheard a conversation where one of the commissioners mentioned to Mr. Luganski, or Gansky, whatever his name is, that the Alachua County will go ahead and fund any lawsuit that I bring against you. I thought that was odd. You've heard testimony where numerous times, Alachua County will come over and do this for you. Alachua County won't do that for city of Alachua. They won't do it for High Springs. They won't do it for Newberry. They won't do it for, Williston's in another county, but they don't want Alachua County come in here and tell you folks what to do. This is the right project for Archer. I've been a good citizen for the city of Archer. I contribute to different things for the town of city of Archer. I pay a lot of property tax. Someone said, oh, you only pay $385 for property tax. That's because the property is owned by Ronnie LLC. So Ronnie LLC is paying the property taxes across the road, pays the property taxes for for the Maddox Foundry. So someday in this town, you're going to be willing to do something with this town. You've lost the 2022 census. You lost 14.9% of your population. Oh, it's such a great place. Well, then why are people leaving here? You've got a poverty rate of 37.4%. No one mentions the people across the road over there that can barely make ends meet, that we can offer jobs to.
Thank you, Mr. Arnold.
I think we need to vote. I think you need to vote no. It doesn't meet all the requirements. And what I heard just now was him threatening the commission and the city. That's a problem to me. If he's going to do that now, what's going to happen when this is built and he's got to comply with all the requirements? This is a historic thing. This is a historic area. I can't imagine an 8-foot berm. I'm trying to imagine it in my head. That doesn't match with the city, like a big wall, fortress. Is that what we want? Is that what we want?
Thank you, ma'am.
Gene Arnold. I wasn't planning on speaking necessarily, but there's been some conversation that's just flat wrong. I think Miss McSherry got up here and started talking about a concrete batch plant in the fire and who's going to put the fire out down in Miami. I looked up that article. It had to do with a cement plant. It was not a concrete batch plant. So that fear mongering has taken place where previous residents have come up here and they've talked about Houston and all the problems there. That wasn't applicable. In previous meetings, we had pictures of, again, cement plants. There's a reason that the city of Newberry, I believe you heard Mr. Thomas talk about in 10 years, how many complaints as the code officer did you have? Zero. Zero complaints. I'm sorry. So to fabricate and say health-wise and traffic and all these things that just aren't true. It's not true, but they're going to put that out there. And speaking of legal, the attorney for Mr. Lewandowski, he mentioned a lawsuit.
Yes.
He put that on the record. And that's why he did that filibuster thing with, well, y'all didn't have the contract done, and he's laying his groundwork. So Mr. Lewandowski, the model Archer citizen, he's legaling up or lawyering up too. Just understand that. We have been good citizens here and run a business, and we want to continue to do that. There is nothing more than that. It is helping Archer. When I drive around and I see a feed store that's going out of business, I see an auto parts store that's going out of business. It's not good. We need people to come to Archer and to this historical thing that people talk about. Oh, I love going down the main road. It's not that scenic. There's old buildings right on the corner down here with windows out. Fletcher, have you seen that? That's not good. That's not scenic and historic. It's a dump. And we need to, luckily there's a gentleman on the corner there that's redoing that. That used to be a Cuban place, and God bless him for trying to bring industry and business. Thank you.
Thank you.
Bob Kosicki, actual citizen of Archer. I live here. Where do you guys live? Alachua, somewhere else? Yeah, you're a citizen because you own a business in Archer. I'm a citizen that actually lives here. These are people that actually live in Archer and don't want that in Archer. You get that? Yeah, I guess you don't understand that. Well, if you.
Okay, Mr. Kasicki, you need
Madam
to.
Mayor.
The other thing
Order,
is,
Madam Mayor.
yes, ma'am,
Thank you.
Madam Mayor, I understand.
Thank you.
If you go around and I have people ask me, I work at the hospital. I have people ask me, hey, is there places to rent or buy in Archer? You can't find that normally. Because anything that goes up for rent or for sale or whatever, it's gone. It gets gone. So it isn't that people are always leaving. Yes, we have a building that's been condemned for how many years now? Because the guy left and the business went out, it just turned to crap. We've had that kind of stuff. But Archer, in the years that I've been here for 34 years, has improved in all kinds of ways, not always with the amount of people, but in its aspect of doing things, in seeing the community grow, in what they've done and working together. That's Archer.
Thank you.
But that we haven't found that just because a business wants to come in and do this, telling you that we got this, we're going to make you a place, or this will be everything for you. It doesn't always work out that way. It's a business for him. It's a business for his sons. That's what it's all about. It's his business.
Thank you, sir.
I think one of you commissioners asked how often it would be inspected.
Yes.
First 3 months. And then after that, once a year,
Once.
12 months. A lot of things can happen in 12 months. Is that going to be unannounced inspections, or are they going to be notified that they're going to be inspected? The local restaurants around here is inspected for your public health every 3 months. Okay, if you have a doubt about any of the 5 requirements, you have to vote no. If there's a shadow of doubt in your mind, you have to vote no.
Thank you.
Madam Mayor, Patrice Boyce for the applicant. I've conferred with my client at length, and I've notified the city attorney. We are hereby withdrawing this application this evening. We will return with an amended application or a new application to place this concrete batch plant inside a building. Anyway, yes, confirming. So please consider this application withdrawn as of this time. We will return, our engineer will return with a new application fee, placing this inside a building, obviating the need for a conditional use permit. Thank you.
Thank you.
Madam Mayor, at this point in time, there's no longer a motion before you, obviously, because you're not ruling on anything. So it would be my opinion that we can move to the next item. However, I would proffer to Commissioner White, as I know that these are two agenda items, if perhaps we could move them to next Monday, given that it is 12:49 at night.
No, right. So do we have a motion to?
The other items on the
table
agenda are
other items?
I believe, I'm sorry, I just heard a citizen ask what the other items are. The other items are the audit update and the update on the city manager. Yes, city manager status and audit update.
Thank you.
Madam Mayor. Thank you, everyone, for at least staying. There was a decision. We didn't get the vote. They withdrew their application.
Can I ask a question real quick?
Can you put you on your mic, please?
And ask.
Public meeting's over? I mean, the hearing. So, since he has withdrawn the application, can we now do a moratorium?
Your moratorium, the issue with the moratorium was the same as it is before. The moratorium was very clearly directed at one individual, which makes it a bill of attainder.
But it's not now. It's because this one's taken care of apparently. This one's done, right?
And coming back in front of you is what they just said.
But when?
For site plan, they'll have to come back, they'll still have to come back for site plan approval.
This could go on for years and we're still sitting in the same boat we were in. I mean,
Can we,
eventually we're gonna have to make some decisions.
can I bring an opinion back to you when it's not 12:50 at night, next Monday perhaps?
Thank you.
Madam Mayor, you either need to decide if you are
So,
recessing tonight, what are
We want to recess until Monday and continue this meeting. So now wait, if we recess it, do we have to start back over?
No, you'll pick up where you left off. Which will be the plan, yeah, we're leaving off at the planning calendar.
All right. Then let's recess it to 6 on Monday.
Madam Mayor, will it be in the chambers or will it be here?
So
I have reached out to the city manager a couple times with that response in regards to the civic center, community center, and services we provide there.
Could I interrupt you right quick? Is the meeting gonna be here, the meeting here or at the chambers on Monday? Sorry.
Okay, all right.
So we can adjourn.
He's, Kim Lozano.
Right.
A motion to adjourn.
I said maybe.
Yeah, the meeting adjourned at 12:52.
Draw a contract up between y'all.
So, in the
I'm,
meantime,
Attorney, I got a copy of the contract.
City Hall.